All right, welcome back, ladies and gentlemen, to the ongoing public hearings of the Environment and Transportation Committee. I am, as always, your friendly chairman, Kumar Barve. I'm joined by the even friendlier vice chairman, Dana Stein, and the merry band of misfits that comprise the Environment and Transportation Committee. Now, let me just say that we have a lot of bills and an awful lot of witnesses. We have 94 people who wish to speak, and we want to hear each and every one of you. But let me just remind you that it's 2 minutes, it's 4 minutes for sponsors and 2 minutes for witnesses. And the reason I have to do that, again, I just want to emphasize, it's not because I'm mean. I mean, I am sort of mean at times, but this isn't the reason I'm doing that. I'm doing this because I want everybody on my committee and everybody in the viewing public to be able to hear absolutely everyone. And so that's the way we're going to begin. We're going to start with the bills in the following order. First bill is going to be House Bill 777, which is introduced by Delegates Rosenberg and Stein. Next, House Bill 674, Delegate Stewart. After that, House Bill 881, Delegate Wilkins. After that, House Bill 688, Delegate Jalisi, followed by House Bill 705, Delegates Barve and Stein, followed by House Bill 720, introduced by Delegate Chanel Branch, then 762, Delegates Bridges and Wells, followed by House Bill 803, Delegate Williams. After that, House Bill 927, Delegate Polakovich-Carr, and then also 928, again, Delegate Polakovich-Carr. And the final bill of the afternoon, or maybe evening by that point, will be House Bill 932. And so with that, I understand that Delegate Rosenberg is not available to join us. So let me welcome to the committee his aide, Jason Beers, who will have 4 minutes to present the bill. Mr. Beers, welcome to the Environment and Transportation Committee. You can begin now.
Thank you very much. It's a pleasure to be here. I am Jason Beers, Chief of Staff to Delegate Rosenberg. The delegate apologizes. There was a scheduling conflict, and so I am here as a surrogate. I was hoping to present a short 2-minute news story on the importance of this issue. I sent the link to Trish, or if you could allow me to share screen, I have it open, whichever works better for you, Chairman. You're muted, Mr. Chairman.
I did not receive any documents to share, so you'll have to do it.
Okay. So Bill 777, House Bill 777, excuse me, is a bill bringing Maryland in consistent with several other states dealing with the issue of mutually owned properties that are inherited from ancestors, specifically tenants in common, in the case of which a individual dies without a working will. The descendants become co-owners. The way the law is currently structured, if one owner of the property wishes to sell and another one does not, a real estate investor could go to court and get a forced settlement that would basically force the other property owners to sell, usually below market value. And so we had a news story talking about the fact that all across the country, people have been forced to sell their inherited property that belonged to grandparents, great-grandparents for well below market value, and investors have been profiting off of this practice. This bill would create a system that would basically protect individuals that don't have, non-sophisticated individuals that don't have access to quality legal representation, to ensure that their interests are protected, and to make it so that they can't be forced to give up their family estate. As I said, this is a bill that mirrors several laws that several states have put into effect. It's something that, given the transient nature of modern society, having consistent property laws is beneficial for just about everybody. It's also the poster child for the case is oftentimes descendants of sharecropping, but it's something that occurs in tenants in urban areas. It's farmland in rural areas. It's something that affects people all across the state and across the country. And so we hope that this bill will receive a favorable report by this committee. And I'll yield the remaining of my time.
Thank you very much. Actually, I think you did a terrific job explaining the bill. Let's go straight to the witnesses. The first of whom is Thomas Mitchell. Mr. Mitchell, welcome to the Environment and Transportation Committee. You have 2 minutes, sir.
Good afternoon, Chairman Barbie and Chair Clippinger and committee members. My name is Professor Thomas Mitchell. I served as the reporter or the principal drafter of the Uniform Partition of Heirs Property Act. Fundamentally, as you've heard, the Uniform Partition of Heirs Property Act is designed to address the devastating impact of the application of an arcane property law, partition law, which has resulted in the substantial involuntary loss of urban and rural properties all over this country, and the devastating impact it's had on stripping many vulnerable families and tenancy and common owners of their generational wealth. Fundamentally, the UPHPA seeks to enhance private property rights for these vulnerable tenancy and common owners. It does so by increasing the chances that in a partition action that these vulnerable tenancy and common owners will be able to maintain ownership of their property, as well as the generational wealth that is associated with such ownership. And for vulnerable heirs property owners, their heirs property constitutes the majority of their assets. As has been indicated, the UPHPA is now the law in states with a majority of the United States population. In 2002, Maryland joins 7 other states that have introduced bills for the UPHPA, as well as the District of Columbia. The Maryland bill is very similar to the Virginia Act that was passed in 2000, and that it applies to all tenancy and common property. And I just heard this morning that California, which enacted the UPHPA into law last year, is now going to have a second bill to have it apply to all tenancy and common property, consistent with Virginia. The UPHPA has not just been successful in terms of the number of enactments across the country, but we've had evidence in the states that have enacted into law that—
Mr. Mitchell, if you could wind up your testimony, the committee would really appreciate that.
The UPHPA is working well. We have heard that it has resulted in a reduction of abusive partition actions in several states, including South Carolina and Georgia. And finally, it has helped families maintain their wealth. We are seeing sales across the country in states that have the law where the sales are significantly higher, approaching market value as compared to partition sales under the background law.
Okay.
So thank you for the opportunity to present.
Not at all, sir. Next signed up in favor of the bill is Robert Enton. Bob, did you make a mistake? I mean, are you testifying in favor of this bill? It'll cause me to change my entire worldview. What's happening?
You know, Mr. Chairman, the public is watching this. What must they think? I'm testifying in favor of 2 bills today, this one and one other one. So my name is Robert Etten, and I'm testifying in strong support of this bill on behalf of the Maryland Bankers Association. I think for our banks, we're very, very cognizant of the situations of individuals, their financial situation, and it just seems unjust to us that under the current law, where property is owned by tenants in common. So let me just say briefly, typically you own property as tenants by the entireties, husband and wife, there's a right of survivorship. You can own it as joint tenants. Once again, there's a right of survivorship and it goes to the joint tenant, or tenants in common, where there is no right of survivorship. So that if there's no will, for instance, and someone dies, that property becomes part of the estate and everybody would have a tenant in common interest. This bill establishes a fair and equitable process for distributing that wealth. And that's important for us. It's for the banking industry, it's very much something that we support, which is helping lower income people, maybe people that don't have enough wealth to go to a real estate lawyer or go to an estates and trust lawyer and deal with these issues. And this will help to deal with these issues. So therefore, we are very much in support of this bill, much to your surprise, Mr. Chairman.
Yes, I have to say that I so adore this new kinder and gentler banker thing that you've come to personify, Robert. Okay. Next, we will hear from William O'Connell with the MSBA Real Property Section Council. William, welcome to the committee. You have 2 minutes, sir.
Thank you. I asked the committee to make a favorable report for HB 77. This bill is, the concept is very similar to what we did in 2016 with the quiet title actions. We have a statute that allows for a partition action to be filed, but we don't have a process to be followed. This will rectify that. This will apply to all partition actions, which will be good for Maryland. While it will take care of the tenancies in common, it will also allow people who are joint tenants who now don't like each other to have a process to go through. There will be no confusion. Everybody will know in the front end how this thing will play out, and this is going to be good for Maryland. And I ask you to issue a favorable report. And I cede my last 56 seconds back to you, Chairman.
Yeah, we don't do that. Oh, to me, yes, of course, anybody can cede their time to me. That's just part of the unfair construct of the committee system in Annapolis. Let me just say that I neglected to mention that friends from the Judiciary Committee are sitting in: John Carden, Nicole Williams, and a simple country lawyer named Haven Shoemaker. So next we will go to Lillian Alexander. Lillian, welcome to the committee. You have 2 minutes.
Thank you. Good afternoon, and thank you for allowing me to speak to you this afternoon. I am with the Black Family Land Trust, and in 2020, the BFLT was responsible as one of the lead organizations for getting the Uniform Petition Heirs Property Act adopted and signed into legislation in the state of Virginia. I want to say to you that this is an incredibly important piece of legislation. As a Marylander by birth, I understand some of the issues that go on with heirs property in Maryland. But heirs property is not an issue of race, gender, ethnicity, or geography. It's simply, in our opinion, an issue of lack of access to trusted, affordable legal services, flexible capital, and education about what heirs property is. There's a lot of misinformation around what heirs property is. This particular bill, HB 0777, will allow for the landowners, the family members, the ancestors to have a clearer path to retaining those land assets, whether they're in urban areas or rural areas, that can also help stabilize community, stabilize tax bases, and help people of color, particularly, and lower income people to begin to rebuild assets for themselves and their communities. And finally, I'd say that the one thing that we do know about heirs property is if you have a farm in Princess Anne and you die without a will, you've created heirs property. If you have a house on McCullough Street and you die without a will, you've created heirs property. So I'd ask that you please support this bill to help protect assets and legacies for many families throughout the state of Maryland. Thank you.
Thank you very much. Next, let's turn to Ben Orzeski. I hope I got your name correctly. He is with the Uniform Law Commission. And take it away, Ben. You've got 2 minutes before the committee. Welcome.
Thank you, Chairman Barbe. That's exactly how to pronounce my name. I'm with the Uniform Law Commission, the organization that worked with Professor Mitchell to draft the Uniform Partition of Heirs Property Act, which is a uniform legislation on which this act is based, and has been adopted right now in 18 states plus U.S. Virgin Islands, and is pending in 9 other jurisdictions, including Maryland. I won't repeat what everybody has said. I'll just point out that what this act is designed to do, and is doing in the states where it's enacted, is protect vulnerable people who own property in a vulnerable way through no fault of their own. It's because an ancestor of theirs didn't do estate planning and they inherited property. And it's a very counterintuitive area of the law. Most people who own property, particularly if it's been in their family for a number of generations, are surprised to find out that they can be forced to sell against their will through a partition action. And it's a strategy that land speculators have taken advantage of to acquire land that's usually in a development zone for less than what it's worth. So what this act will do is put in a few due process protections, independent appraisal of the property to find out its true value, a right of first refusal for the current co-tenants to buy out the one who wants to sell, and a strengthened preference for partition in kind for physical division of the property if that's feasible. And finally, if the property does have to be sold, an open market sale, which is designed to bring the highest possible price and make sure that the heirs at least realize the full value of their inheritance. It's working very well in the states where it's been adopted, and recommend that this committee also consider advancing this legislation so that Marylanders can have the same advantages. Lastly, I want to thank Bill O'Connell from the Maryland State Bar. He worked with us to take this Uniform Act and get it into a format that was appropriate for Maryland. So thanks for the cooperation, and we look forward to any of your questions. Thanks.
Well, let me compliment you, Ben. Ordinarily, when uniform law commissioners testify before committees of the legislature, half the members are ordinarily asleep. Everybody's awake. I want to thank you for that, sir. So let's next go to Richard Shore with Gilbert LLP. Richard Shore, welcome to the committee. You have 2 minutes. Is Richard Shore with us? Well, okay, be that way. Let's go to Lisa May with the Maryland Realtors, and we'll see if Richard Shore joins us shortly.
I apologize, Chair Barbe. I was on mute. I didn't realize.
Okay, that's okay. We'll go to Richard Shore. Welcome to the committee. You have 2 minutes.
Thank you, Chair Barbe and members of the committee for allowing me the opportunity to testify today in strong support of the Maryland Uniform Partition of Heirs Property Act. I'm a partner at Gilbert LLP, a boutique DC-based law firm. I've lived in Maryland for, I am scared to say, nearly 60 years. My mother, Suzanne Shore, was a real estate agent here for decades. And my colleague, Rachel Jennings, and I have been working to build coalitions to support enactment of the UPHPA in both Maryland and DC for well over a year. I got involved in this issue actually as a result of my service on the Equity Committee of DC Mayor Muriel Bowser's Reopen DC Advisory Group. I was looking for a way to make a concrete difference, and this issue cried out for reform. The UPHPA is a common sense bill. African American ownership of real property has plummeted over the last 100 years in significant measure because outdated partition laws allow any co-tenant, even if they own a small fraction of the property, to force the sale of their property, often through an auction on the courthouse steps where they receive a fraction of its value. All owners receive a fraction of its value. This property generally represents a significant measure of a family's wealth, and it often holds substantial historic family heritage or other non-economic value to the owners as well. And although the negative impact of existing partition laws has had a particularly pernicious effect on African American real property ownership and generational family wealth, this issue impacts all races, socioeconomic classes, ethnicities, and genders. Importantly, the UPHPA offers a concrete way to address systematic inequities that inevitably result from current partition law without removing the agency of any co-tenant to extinguish his or her own interest in property. The UPHPA seeks to ensure that all owners are fairly compensated in the event of a forced sale, requiring sales through the same mechanisms that I dare say every participant in this hearing today would choose to use over an auction on the courthouse steps of their own home or land.
If you could begin to wind up your testimony, the committee would appreciate that.
Yes, thank you, Chair Barbie. I was just going to say, I hope that this committee will report favorably on this measure, and thank the chair and the members of the committee for their attention to this important bill, as well as the sponsors. Thank you very much.
Not at all. Thank you for testifying. And then finally, the last witness on this bill will be Lisa May with the Maryland Realtors. Lisa, welcome back to the committee.
Thank you, Mr. Chair, members of the committee. We wholly endorse all of the other testimony that you have heard so far on this bill, but just want to add that currently there is a 24-point gap between white homeownership rates and Black and Hispanic homeownership rates in Maryland. And the typical household wealth of a white household is 8 to 10 times that of a Black or Hispanic household. And it's practices like partition sales that contribute to those gaps. As it was mentioned, heirs property is present all throughout Maryland, but the highest concentrations are on the Eastern Shore, in Garrett County, and in Baltimore County, as reported by the Federal Reserve Bank of Richmond. At the end of the day, we just want to say that not having a will should not determine whether or not you receive your family birthright and whether you receive your generational wealth. So as was mentioned, there are a number of states who have put these protections in place, and we sincerely hope that Maryland will join them. Thank you.
Thank you. We do have a number of, and by the way, just to make this clear, nobody is opposing this bill. The first question goes to Delegate Weigel.
Thank you, Mr. Chairman. I just want anyone could clarify for me that this bill only comes into play if someone brings an action and would not preclude, say, heirs from agreeing to sell a parcel of land from one to the other at less than a fair market value.
Yes, sir.
You want me to answer that all?
Sure.
Yeah.
Yes, go ahead. Go ahead, Thomas.
I'm sorry, you're absolutely right. Any of the tenants in common, whether it's a family member or a third party, has the unilateral right to sell their interest to anyone else. The family or the broader group of tenants in common could seek to sell it collectively. So it's only when a partition action has been filed. And a lot of the provisions only apply to the extent that one of the co-tenants seeks the forced sale of the property as opposed to the physical division of the property.
Okay, thank you very much.
Sure.
And the next question goes to one of our friends from the Judiciary Committee, Delegate Williams.
Yes, thank you, Chair Barbie. This question, I don't know if this goes to Mr. Mitchell. Wanted to see if you could elaborate a little bit about the concept of partition in kind in this bill. This bill is really totally modifying the way we deal with partition sales here in the state. So just want to get a little bit more clarity on that. And also in the states where it has been enacted, how has that worked out? I don't know if you have any data on that or just anecdotally with regards to the concept of the partition in kind.
Yeah, so I think on the partition in kind, the overwhelming majority of states, including Maryland, have an ostensible preference for the physical division, the partition in kind, sometimes called the partition by division. However, what's happened over time is that the statutory guidance is very thin, and judges have often then overridden that preference by ordering the forced sale, including in those instances where the physical division was possible. So what the UPHPA does is it reinforces the pre-existing preference for the partition in kind, but it adds real substance, and it adds substance by requiring courts to use a test that we call the totality of the circumstances that includes a number of economic factors, which courts have tended to use, but also non-economic factors such as longstanding ownership in the family, the historical or cultural significance of the property, and whether forcing a sale will have a serious adverse impact on those who are using the property lawfully, including for basic shelter, including maybe forcing them to become homeless or seriously erode their quality of housing. So once again, it supports the pre-existing preference for partition in kind, but then it bolsters that because of the erosion in the practice in the last several decades. In terms of the states, as I indicated, as Ben Orzeski has indicated, the statute is working very well and as intended. So a lot of what we have is we've heard from a number of lawyers and other people in the states that have enacted it into law. So for example, in South Carolina and Georgia, what we've heard is there's been a steep reduction in the number of these abusive partition actions that have been filed, especially by third parties, including developers and speculators. I heard from one of the lawyers in South Carolina who's well known as having filed more of these partition actions on behalf of these speculators. And he told me personally, he's not filing nearly as many because it doesn't make sense under the act. And the other thing we've heard is that as I indicated, the price of the open market sales are yielding is substantially higher than the auctions at the courthouse steps. And that's consistent with the real estate practice. I'll just give you one anecdote and I'll leave it at that. I heard from a couple of lawyers here in Fort Worth, Texas. They resolved a partition action using the UPHPA's open market procedure about 4 years ago. Property sold for $2.5 million. And then they told me that all of the lawyers for the plaintiffs and the defendants got together afterwards, and they all agreed that if they had used the auction at the courthouse steps, which was mandated by the background partition law, the property would have sold for no more than $1 million. Sounds dramatic, that $1.5 million difference, but that's precisely what the real estate economics theory would predict.
Thank you.
Okay, thank you very much. Any further questions for the sponsors or any of the witnesses? Seeing none, thank you very much. That ends the public hearing on House Bill 777. Goodbye to our friends from the Judiciary Committee. And let's go to House Bill 674. Delegate Stewart, you got 4 minutes.
Great. Thank you, Mr. Chair. For the record, I'm Delegate Von Stewart. This is House Bill 674. So HB 674 is really simple. It requires judges to stay eviction proceedings, to pause them when there is a good faith application for rental assistance. This is kind of similar to the bill that we heard from Delegate Williams a couple of weeks ago, except her bill would have created some delay at the beginning of the process. There would have to be an application before landlords even filed for eviction. This bill is a little bit more lenient for landlords. It would require a stay for a judge, but after the eviction process has already started. This idea to pause evictions when there's been an application for rental assistance is not a radical one. From the West, when you got states like New Mexico, Colorado, and Oregon, to the East, where you've got states like Massachusetts and our inferior border state, Virginia. All of these states have adopted similar protections for renters. The federal government, as y'all know, has sent Maryland nearly $1 billion for rental assistance programs, and over 40,000 households have already been helped. We actually have enough money from the federal government to pay off the rent debt of every single tenant in Maryland. And while evictions are down from pre-pandemic levels, which I'm sure the opponents will remind you of, they nevertheless continue. We're nevertheless seeing evictions, and we're nevertheless, and of course, many small landlords are still unaware that this program even exists, and people who would have been eligible for this federal money are being kicked out of their homes. And so I'm introducing HB 674 to remedy the situation. I basically want to funnel more money from federal coffers to landlords' pockets so that thousands more Marylanders can stay in their homes. We have the money to do it. So the bill is important for 2 reasons. One is the one I basically already laid out. I think that it's just fundamentally unfair and wrong to evict someone when we have money available to keep them housed and to make their landlords whole. We shouldn't be punishing tenants or landlords simply because county governments are understaffed. And while it's true that the rental assistance programs in a lot of counties started really, really slowly, painfully slowly, they have been hitting their stride lately in most counties. And more than 6,000 households per month across the state are now being helped, which is way up from when we first started kicking off the program. And the second reason the bill is important is related, because it helps increase the effectiveness of the program overall. The federal government retains the ability to claw back funds from jurisdictions, either counties or states, that spend the money too slowly. We were on that borderline before. And because basically of the potential for an eviction pause in this bill, landlords will be encouraged, but not required, to apply for the funding as soon in the process as possible, which will lead to more and earlier applications. I'll just point out that the opponents will definitely tell you that this bill is going to add a bunch more length to an already lengthy eviction process. And while I'm sympathetic, I'm not concerned about this. Counties already use a triage system where the cases that are farthest along in the eviction process are prioritized. And so if landlords apply for rental assistance at the first sign of a tenant's inability to pay, they're really unlikely to face a lengthy delay from this bill. In many cases, the application for rental assistance will be dealt with by a county before their first court hearing is scheduled, just by virtue of how far along the courts have been delayed. And in their written testimony, a few of the opponents floated the idea of a cap on the length of a pause. I'm actually open to that conversation. I also know the opponents are worried about a tenant applying for rental assistance late in the process, a tenant applying after initially refusing to cooperate with a landlord application. That's one of their concerns. I also don't think this is fair. I wouldn't consider that a good faith tenant application, but I'm also open to amendment clarifying that issue. And just in general, I think we can all agree that we want to spend every last federal dollar as quickly as possible. So I urge a favorable report on House Bill 674.
Okay, thank you very much, Delegate Stewart. Let's go to Corey Warren with the Disability Rights Maryland. Corey, welcome to the committee. You've got 2 minutes.
Hi, great. Thanks so much for letting me testify. My name is Corey Warren. I'm a staff attorney with Disability Rights Maryland. We are urging a favorable report on House Bill 674. My colleagues who are in favor of this bill, I think, will get into more of the details on the statistics on the fact of the matter. We can keep people housed. We have the federal money to do so. But I did want to point out a few things from the disability perspective on this process. One of the things we've been hearing from landlords is a complaint that tenants are not cooperating early on, or that they haven't filed for the emergency rental assistance. Our firm represents people who may just not have the capacity to apply for ERAP until they're in court or they're their day of. This could be because of somebody with a developmental disability. I've represented several people who are unable to read due to an intellectual disability that I've represented in rental court that needed to sit down and actually get the application done then. Allowing a stay in the courtroom proceedings to let people have additional time to participate in these programs is going to make a significant difference, especially for those who may not have the ability to participate early on. So we do urge a favorable report on this bill, and I thank you for your time.
Thank you very much. Let's next go to Katie Davis with the Pro Bono Resource Center. Katie, welcome to the committee. You've got 2 minutes.
Great, thank you. Thank you, Chairman and committee members, for the opportunity to testify. I'm Katie Davis, Director of the Pro Bono Resource Center's Courtroom Advocacy Project. We use staff and volunteer attorney model to provide day of court representation for tenants in rent court and staff a hotline 5 days a week. Since the pandemic began, we have represented over 500 tenants in rent court in both Baltimore City and Baltimore County and worked with hundreds more on our hotline. And when we meet the tenants in court, one of the first questions we always ask is whether they've applied for rental assistance. As the pandemic has worn on, it's more and more common to hear yes, but I haven't heard from them yet. And so then we go and use that information to negotiate with the landlord, encouraging to dismiss the case with the knowledge that payment is forthcoming. And if that fails, then we request a continuance in court to give the rental assistance time to make the landlord whole and preserve the tenant's home. Despite these efforts, our tenants often leave court with a judgment, and then our staff have to pivot to working with rental assistance to try to expedite the payment so they can stay and avoid eviction. So through working with rental assistance, we have managed to keep a lot of tenants housed in this way, but it really shouldn't work this way. As you've heard, there's money available to pay these rent obligations, and no one should be evicted when there's money to pay the rent, especially during a pandemic. Furthermore, no one should even get a judgment when there's money available. These judgments alone can cause families to lose the right to redeem or the ability to secure housing in the future. And for what purpose when there's really money available to pay the rent? So we support House Bill 674 because it will prevent many of these unnecessary judgments and evictions by giving the court the statutory authority to pause that eviction process based on rental assistance. With this authority, the court can put a stop to the number of tenants, like one we detail in our written testimony, who call our hotline in a panic because they're scheduled for eviction in a day or two despite a valid application for rental assistance. Rental assistance employees shouldn't have to hand deliver promissory notes on a Saturday morning to avoid a Monday eviction. The court should have the authority to postpone a judgment when it's clear that rental assistance can step in way before we get to this point. So we encourage a favorable report on this bill, and we ask that you bring Maryland in line with other states that have already adopted similar practices in pausing eviction proceedings based on the ability of rental assistance. Thank you for your time.
Thank you very much. Next, let's hear from Matt Hill with the Public Justice Center. Matt, welcome to the committee. 2 minutes.
Thank you, Mr. Chair, members of the committee. My name is Matt Hill. I'm an attorney at the Public Justice Center. Maryland has over $400 million to pay back rent right now and prevent evictions. Yet we're still having over 700 evictions each month. Why? There are a number of overly aggressive landlords who are refusing to cooperate with local rental assistance agencies. This sets up a nightmarish race between the landlord's eviction process and the rental assistance agency. And in around 700 cases each month, the eviction process is winning. It's time to end the race, and HB 674 provides that structural fix. First, as others have said, it provides the court an authority it has not had before, which is to pause the eviction process for that rental assistance application to finish. That's incredibly important. Second, with the sponsor amendments that will conform this bill to the Senate version, it's going to say that if you want to use a state-funded court eviction process for an eviction, then you're going to have to accept state money for the rent. Third, it aligns the pace of the rental assistance to the eviction process. And I'll just point out fourth that this is a best practice that's been adopted in over 16 states and other local jurisdictions. As Ms. Davis said, no one should be evicted when there is money to pay the rent, especially during a pandemic. Thank you.
Thank you. Next, let's hear from Sherry Glazer with Jews United for Justice. Sherry, welcome to the committee. You have 2 minutes.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Sherry Glazer, and I'm a retired lawyer from District 16, but today I'm testifying in favor of this bill on behalf of Jews United for Justice, a group that organizes more than 6,000 Jews and allies across the state to help win social, economic, and racial justice campaigns that are inspired by our Jewish values. You've heard very eloquently from the other speakers about what this bill will do and the mechanics of it. I'd like to use my time to just tell a very short story that I think illustrates how this bill would help in everyday life. Recently, I attended a forum with Jews United for Justice and Renters United, and some legislators, in fact, were there as well. It was a Protect Our Homes forum, and many people spoke about the pandemic and tenants, about what has happened to them. One woman spoke. She was a tenant from Greenbelt. She was from Sierra Leone. She had 2 school-aged children. She had lost her job during the pandemic and was behind in her rent. Her husband had fallen ill and was lying in a coma in a hospital. Throughout all of this, she did have the wherewithal to apply for emergency rental assistance, but was waiting and waiting. She told her landlord about her situation. Her landlord said, fine, give me whatever funds you have and I'll wait for the rest. She gave him $1,600. That was nearly all the money she had in the world. The landlord took the money, but did he wait? No. He filed an eviction case without telling her. She heard only through CASA. And meanwhile, her husband died and she had no money to even bury him. The eviction was stopped, and it's being worked out now, I understand. But what happened to her was terrible, and it shouldn't have happened. This bill, if enacted in law, would prevent such a situation, possibly, hopefully, by providing for a stay on any eviction proceedings.
Okay. If you could wind up your testimony, the committee would appreciate it.
She asked us, everybody attending the event, to be a voice for her and to be a representative. And we'd like to do that for her, to fight for her and others like her. The committee has the power to help by issuing a favorable report. Thank you for your time.
Thank you very much. Next, let's listen to Matthew Lozak with the Montgomery County Renters Alliance. Matthew, welcome back to the committee. You've got 2 minutes, sir.
Thank you. As the phone rings, I'll have to call you back. Sorry. Good afternoon, Chairman Barbie and Vice Chairman Stein. Sorry for the interruption, and committee members. My name is Matt Lozak, and I'm a co-founder and executive director of the Montgomery County Renters Alliance, which is an alliance of more than 30 community, labor, religious, political, and civic organizations, and thousands of renters. We are also Maryland's first and only regional nonprofit dedicated exclusively to renter outreach, education, organizing, and advocacy. And we are also co-founders of Renters United Maryland, our statewide coalition. The Renters Alliance is in favor of HB 674, and we thank Delegate Stewart and the co-sponsors for this common sense fix to a system intended to effectively deliver government resources to prevent evictions as a result of the pandemic's impact. Over the past 2 years, we have seen and worked with scores of renters facing eviction who qualify for rent relief, but face court action to evict before the relief can arrive. And we've seen some very tragic cases, as has been discussed earlier. We should note that despite the lower eviction rates that some are reporting due to the relief, that these lower rates are due to the relief efforts, court closures, and eviction protection orders that have now expired. That in Montgomery County alone, we still have about 15,000 renters this month who are behind in their rent and facing eviction. And as many of you know, Montgomery County is one of the wealthiest counties in the world. This bill reconciles two disparate processes to ensure the same result, that renters remain stable while awaiting relief in good faith, and that landlords will ultimately be made whole without increasing costly apartment vacancies, damaging families and communities with unnecessary and tragic evictions. We strongly urge a favorable report to the and this common sense fix. Thank you.
Thank you very much. Next, let's hear Robin Moore. Robin, welcome to the committee. You have 2 minutes.
Good afternoon. My name is Robin Moore. I've been residing in the new Northwood neighborhood in a large complex in Northeast Baltimore for the past 2 years and 3 months. In April of 2020, my roommates moved out, leaving me to find a way to pay for the rent on my own. I immediately tried to seek assistance through several organizations, including Salvation Army, who all informed me that there was no funds available to assist me. My landlord has been contacting me every month since April of 2020 regarding the rent. I informed her in November of 2021 that I was seeking assistance through the BCAP program. At this time, the landlord informed me that their organization does not accept funds from this program and would not state why. Should I be evicted, I have nowhere to live. I would end up looking for a shelter. And due to the COVID outbreaks and my medical condition, I feel that that would affect my health. Also, it would place a record on my record as being an eviction, which would make it even harder to seek new residents. I am also aware of other tenants in my complex who are experiencing the same situation. In my opinion, I feel that landlords should not refuse any type of assistance that an organization is offering them to assist tenants in catching up on their rent. I asked that the committee be favorable for, I asked the committee for a favorable report on HB 674. Thank you.
Thank you very much, Robin. Next, let's turn to Jamie Milliman with Maryland Legal Aid. Jamie, welcome back to the committee.
Thank you. Good afternoon. My name is Jamie Milliman. I'm a staff attorney at Maryland Legal Aid in the Salisbury office. Maryland Legal Aid represents low-income people in a variety of matters, which includes landlord-tenant matters. Our Salisbury office represents low-income tenants in the lower shore jurisdictions, Wycomico, Worcester, Somerset, and Dorchester counties. We support this bill and we urge a favorable report, and here's why. In the 4 lower shore counties we serve, it can take just 1 month from filing for a landlord to evict a tenant for non-payment of rent. The hearing is typically set 2 to 3 weeks after the landlord files. After 4 business days, the landlords can then get the warrant of restitution and evict the tenant within a week. This time frame is both pre and post during COVID. So for example, Dorchester County heard 3 cases that were filed on November 4th, 2020. They were set in for hearing just 9 days later on November 13th, and the tenants were evicted just 3 weeks later, 2 on December 2nd and 1 on December 4th. There are similar trends in surrounding counties where evictions occur just as quickly. Our ERAP providers here work quickly and diligently to process the applications and pay rental assistance to the landlord. ERAP takes about 4 to 6 weeks from application until final approval, at which point it can take another week or 2 for the landlord to receive the funds. Additionally, ERAP typically covers the full back rent and 3 months prospective rent. The problem is that as fast as the rental assistance programs are here, the failure to pay rent process and ultimate evictions are even faster. And despite the Court of Appeals order on December 27, 2021, reverting courts to phase 3, which means that failure to pay rent cases are not supposed to be set in, Eastern Shore jurisdictions have continued to hear such cases. So for example, this coming Friday, Wycomico County is set to hear over 100 failure to pay rent cases in the morning dockets. In Wycomico County, also 2 separate cases were filed on December 14th, 2021.
Pardon me, if you could wrap up your testimony,
Yes.
the committee would appreciate that.
Those cases were heard 2 weeks later and the tenants were evicted February 9th. The evictions are happening in Maryland still. They're happening without delays. The bill allows for extra time for the rental assistance providers to pay the landlord, and it would cut down on homelessness and eviction. This is really important while ensuring landlords get what they want, which is to be paid and to prevent homelessness. We urge a favorable report on this.
Okay, thank you very much. Let's next go to Lisa Sarro. Lisa, welcome to the committee. You have 2 minutes.
Thank you, Chairman Barbe and members of the committee. My name is Lisa Sarro. I'm General Counsel for Randall Community Development Services. We are Anne Arundel County's nonprofit housing and community development agency. As part of our role on behalf of the county, we administer the county's rental assistance program. I want to make 2 points for why we really need this bill to pass, and one reminder. The reminder is that this bill would not apply to all tenants, only those low-income tenants that could reasonably and in good faith apply for emergency rental assistance. Most programs are at 80% adjusted median income as a cap on who would be eligible, and many programs, as we get farther into the use of our funds, are reducing that even further to about 50% AMI. So just as a reminder, not everyone that is in the process is going to get a delay on a potential eviction. The 2 points I want to make, the 2 reasons we really need this bill to pass. One, is discussed more fully in my written testimony about the chaos that goes on when there is an emergency eviction that we have to process. There is no way in Maryland to anticipate who is going to be evicted. We try desperately to find out who's going to be evicted. We work with the sheriff, we work with the property managers, but we don't have a way to anticipate it. So most often we know about 2, 3, maybe 4 days ahead of time. That's not enough time usually to process an application. The other thing I really want the committee to be aware of is that without this stay, landlords, a few of them, are finding ways to game the system and get their tenants to the front of the list. And that's making all the other landlords and all the other tenants wait unreasonably, because these tenants that are with the landlords who are routinely scheduling evictions for the exclusive purpose of bumping their tenants up in line, that's happening routinely, and it's hurting the landlords who are cooperating.
If you could begin to wrap up your testimony, the committee would appreciate that.
I sure will, Chairman Barbe. I'm done. We urge a favorable report on this bill. Thank you.
Thank you. Next, let's hear from Dominic Butchko with Maryland Mako.
Good afternoon, Mr. Chair, members of the committee. Thank you for having me here today. My name is Dominic Butchko with MACO. We are urging support of HB 674. As of this morning, counties have assisted over 40,000 households requesting emergency rental assistance, amounting to just under $250 million being distributed. This bill will address a number of issues facing county housing and human services officials with respect to the state's emergency rental assistance program. A reoccurring theme at this past year's winter conference is just difficulty with outreach. Many tenants are saying that they're not aware, even though counties are spending significant time on outreach. So we need more time with getting the word out. County governments have been working tirelessly to identify trusted messengers for this. As you've also heard from the sponsor and many other people testifying, many jurisdictions have been working rapidly to increase our capacity for processing these applications. And essentially, most counties started from essentially zero, from essentially scratch. Also, there have been several other issues contributing to delays, including changes in the federal requirements for different things, as well as a handful of landlords just unwilling to accept rental assistance. This bill is narrowly tailored to the rent debt crisis before us and includes a sunset date in the near future. It prevents our constituents from succumbing to housing insecurity, potentially resulting in damage to our social safety net. Because of these reasons, MACO urges a favorable report. Thank you.
Thank you. Next, let's hear from Larry Ottinger. Larry, welcome to the committee. You have 2 minutes.
Thank you, Chairman Barbe, Vice Chair Stein, and all members of the committee. My name is Larry Ottinger, and I'm president of Our Maryland, a multi-issue hub founded in 2017 to promote a just and sustainable future for all Marylanders. We have over 55,000 Facebook followers and 14,000 email subscribers. And I think we can add here is that we hear from these folks, and this is a priority for Marylanders. And number two, we know that government is, trust in government is precarious. And our legislature has done a great job, but I think for Marylanders not to see this kind of common sense reform to help their fellow Marylanders in a crisis during this ongoing pandemic would be devastating. So I want to add sort of that perspective. You know, it's a fair and common sense and efficient for, you know, all the stakeholders, as we've heard, from landlords to the tenants, to the nonprofit housing agencies, to our courts. This would rationalize and prioritize among the large number of non-payment of rent cases existing now by identifying those that may be resolved through these pending applications for rental assistance, while Maryland has this unprecedented funding from the federal government. So, and I don't want to lose out to Virginia, okay? If Virginia can do it, I know Maryland can. So for our tens of thousands of informed supporters, our Maryland urges the committee to issue a favorable report on HB 674 with sponsor amendments. Thank you for your time and work.
Thank you, sir. And next, let's go to Delfina Tellez with CASA Maryland. Delfina, welcome to the committee. You have 2 minutes.
Hi, Mr. Chair. I will be translating for her.
Okay.
2 minutes.
Go for it.
Okay.
Okay. Muy buenas tardes, señores legisladores. Yo vivo en el condado de Prince George, donde he vivido por más de 12 años. Hoy estoy aquí para pedir que pensemos en inquilinos y personas que rentan como yo. Yo durante la pandemia perdí mi trabajo y hasta ahora no he podido encontrar un trabajo fijo que me ayude a tener la estabilidad que tenía antes.
Good afternoon, legislators. I live in Prince George's County, where I have lived for more than 12 years. Today, I am here to ask you guys to think about tenants and people like me who rent. During the pandemic, I lost my job, and to this day, I still haven't found a stable job to get me back on my feet.
Nuestro complejo de apartamentos comenzó a enviarnos cartas de desalojo que eran ilegales y no de la corte. Pero gracias a casa nos organizamos y aprendimos nuestros derechos y luchamos en contra de las injusticias. Yo estoy para pedirles que apoyen esta ley, que les dirá no a las injusticias del desalojo, los que hemos aplicado para ayuda de renta.
When the pandemic began, our apartment began sending us illegal eviction letters that they would print out in red paper. Thanks to CASA, we organized ourselves as tenants and we learned our rights. I am here today to ask you guys to pass this law that would say no to the injustices of evictions and for all of us who have applied for rental assistance.
Yo apliqué para ayuda de renta en Prince George en octubre del 2021. Estamos en fin de febrero y no hemos escuchado nada. Que los condados tienen muchas aplicaciones y ellos están haciendo todo lo posible para procesarlas, pero necesitamos tiempo. Y mientras ese tiempo pasa, los inquilinos necesitamos protecciones de desalojos injustos.
I applied for rental assistance here in Prince George's County back in October 2021. We are now at the end of February and I still haven't heard anything. I know the county has lots of applications and they are doing their best and they need time. But while that time is passing, tenants need protections against evictions.
Yo quiero que mi hijo asista a la escuela y no esté pensando sobre las cartas que me ha enviado la oficina, como la que recibí ayer, que es un intento de llevarme a corte por la renta que ya apliqué para ayuda de ERAP. Y él se preocupa porque me ve a mí preocupada. Legisladores, por favor, pasen esta ley para proteger a mí, a mis vecinos y a mí mientras esperamos una respuesta de nuestras aplicaciones. Por favor, legisladores, pasen la ley. Nuestra comunidad realmente necesita y nuestra comunidad realmente es triste lo que vivimos porque no hemos podido levantarnos después de la pandemia. Muchas gracias por escucharme. Que Dios me los bendiga.
I want my child to go to school and not have to worry about the letters the office is sending me, like the one that they sent me yesterday saying that they will take me to court for all the rent that I owe, which I have applied for rental assistance. And that is why I worry, because when my child sees me worried, I can see it in his face and he's thinking about this. Legislators, please pass this law that will protect tenants like myself and my neighbors who are waiting for a response from our county in regards to our rental applications. May God bless you all. Thank you.
Thank you very much. We'll now turn to Claudia Wilson Randall. Claudia, welcome to the committee. You have 2 minutes.
Thank you. Good afternoon, Chairman Barbe and members of the House Environment and Transportation Committee. My name is Claudia Wilson Randall. I'm the Executive Director of the Community Development Network of Maryland. And many of our partners are on the front line of the social safety net of evictions. They are working to distribute rental assistance to people across the state. I just urge you to support House Bill 674. I think we need to do everything in the state of Maryland to prevent unnecessary evictions. Maryland has a very high rate of evictions, and we should not treat this in a cavalier manner because it has a lasting impact on people throughout the state, particularly people of color and particularly women.
Police departments in Maryland have gone far beyond the government
People with
databases like
evictions.
Somebody needs to mute themselves.
Are more likely to miss work, miss school, and miss daily living. The stress that eviction causes, the overall anxiety within communities about evictions. Community decline begins with evictions and foreclosures and people being put out of their homes. So we need to do everything in the state to prevent this and give people time for those to process emergency rental assistance applications and for those to go through systems and keep as many people out of this dangerous cycle of poverty and subsistence living. So I urge your support for House Bill 674, and thank you so much for your time today.
Well, thank you. And I believe that ends all the proponents for the bill. So why don't we go to questions if there are any? Actually, Delegate Stewart, I have a question. Does your bill have a sunset?
Yes, it does. I believe that the sunset currently in the bill, basically this bill only exists to the extent that there's money left over from the federal ERAP programs, either ERAP 1 or ERAP 2, those two tranches. Once the money runs out, the bill runs out.
Okay. All right. And there appear to be no, Delegate Holmes has a question.
Thank you, Mr. Chair. And I want to preface this by understanding I'm asking questions because I am the one that's going to be standing on the floor with a microphone in my hand.
I hope so.
Bill passes. The questions are going to be asked. I need to get answers. You've already answered one in terms of sunset. I did not see in the bill where there is a sunset in terms of money running out. And my question was going to be, when an application pending and the money runs out, how does that work? Application is pending and the money runs out. What happens?
Right. And honestly, there could have been a drafting mistake. We had some DLS trouble that was my fault, where the Senate version actually looks a little bit different than ours. But certainly, whether it's in the House version or not, my intent is that when the money is exhausted, judges no longer issue stays.
Okay. All right. And it kind of goes along with some of the other questions that I had in reference to the timeframes. Because the timeframes are taking, Eastern Shore says it's 40. Eastern Shore says that they're taking 4 to 6 weeks.
Right.
But we heard from a participant in CASA who said their time frame is already past 4 months. So I'm questioning how this works in terms of those elongated timeframes as well. So we can have further discussions about this offline.
Yeah, well, it's a great point, Delegate Holmes, because we really have 24 separate situations going on.
Yes,
in some situations, the time to process a rental application is shorter than the time it takes to get through an eviction process. In some counties, it's reversed. And we're just trying to, and whether we have to cap this at a certain number, like I said, I'm open to that conversation. But I think that we can give the counties where it's taking them longer to process evictions a little bit more time so that we can spend this money down a little bit faster. But yeah, I certainly look forward to discussions going forward.
Thank you. Thank you, Mr. Chair.
Not at all. Delegate Jalisi has the next question.
Thank you, Mr. Chair. So just from my understanding, and I think I'm kind of following up on Delegate Holmes' question, is my understanding correct if I say that the stay and all this, what the bill requires, would not happen when there is no money for rental assistance programs?
Yeah, so we'll have to have the sunset conversation. That'll be something that the subcommittee will discuss. Delegate Holmes was saying that the current House version does not have a sunset in it. That's a conversation that's going to be up to the subcommittee, whether or not we sunset this bill when the money runs out or not. Obviously, some state and localities will continue having rental assistance programs that are not necessarily tied to the federal money, right? So one argument would be, well, don't sunset it when the federal money runs out if there are still county and state resources available. So it's a technical conversation, but obviously if there's zero money available in any program and we're staying evictions pending money that doesn't exist, that bill doesn't make any sense, right?
Right. So I say it because it's not a theoretical conversation. In Baltimore County, they don't have any money to give for rental assistance programs. And my last conversation that happened about 10 days ago, they said they anticipate the money coming in March, but they could not give a date of when it will come in. And so because of that, they cannot tell a property owner of when the money would be paid to him or her. So what I'm saying is not just when the money runs out like from the federal government. But if
Right.
a jurisdiction says that whatever money they had for a given 3-month period has run out, then it would not make sense to stay the eviction, because at the end of the day, the property owner is paying mortgages and property taxes and all the other expenses that come with owning a rental property. So you agree that not just when a year down the road, when the federal government stops giving Maryland money, but even as jurisdictions run out of money that is allotted to them, that there would not be a stay on evictions?
Right. No, yeah, and I didn't totally understand your point initially. This is obviously a separate point than when the
in Baltimore County we have
hold on, Jay. Let's.
Okay.
Yeah, so no, but we're in accord, Delegate Jaleesi. I think it's a totally fair point, and once again, this is going to be an issue that the subcommittee is going to have to hopefully look into, right? Because obviously, in one sense, if we don't think that, say, Baltimore County, in your example, is going to get the next tranche of funding for 9 months, for example, maybe it doesn't make sense to have eviction stays, right? But if Baltimore County currently has $0, but we know that the HCD is going to send them a new tranche on, say, March 1, then maybe it does make sense for the provisions of the bills to apply. So I don't want to speak in absolutes, but I certainly have a lot of faith in the subcommittee to work through these issues. But you're totally right to raise this as an issue.
Thank you. Thank you very much. Thank you, Mr. Chair.
Okay, there appear to be no further questions, so let's turn to the opponents of the bill. And first will be Aaron Greenfield with MMHA. Aaron, welcome back to the committee. You've got 2 minutes.
Thank you, Mr. Chairman, members of the committee. Aaron Greenfield on behalf of MMHA. And we are opposed to this bill. Access to rental assistance is a priority for us too. However, this bill creates additional delays in an already historically delayed court system. Just to underscore the current situation, courts have not heard failure to pay rent cases since December of 2021 and will not begin to hear those cases until March the 7th, the earliest. Jurisdictions across the state are experiencing significant delays between a court filing and a hearing, and the time between a court filing and a court hearing for a failure to pay rent case in a number of jurisdictions is anywhere from 4, 6, 8 months, even 1 year. That should be plenty of time for a tenant to submit, apply, and receive rental assistance from the jurisdiction. Maryland's housing providers just simply cannot afford additional delays to an excessively slow process. You would have already heard the slow process in the prior witness who spoke about in Prince George's County applying in October of 2021, and to today's date has not received any of that funding. The issue here seems to be the efficiency by which counties are dispersing those funds. I want to also mention, if this bill is amended to conform to Senate Bill 384, it would require housing providers to accept rental assistance agreements, including any future prohibitions going forward. Our members, our association negotiated in good faith with each of the jurisdictions, and any future changes we would be locked into under this bill. I also might make the point, someone raised Virginia, and Virginia, as a sponsor and I have spoken, is different. They have one statewide agreement versus the multiple agreements we have in this state. With that, I respectfully request an unfavorable report.
Okay, thank you. Next, let's turn to Catherine Howard. Catherine, welcome back to the committee. Are you with us?
I don't believe she is here today.
Okay, then how about Erin Bradley with AOPA?
Good afternoon, Chair Barve, committee members. Thank you for having me. So I think Aaron Greenfield covered many of our concerns. I would just say AOPA and our members have worked with residents since August 2020 to make use of any and all available rental assistance available. However, one of the issues we had with this bill was that it seemed that a person could apply the day of court and hold all court proceedings when, as Aaron mentioned, just the delay in the process, it takes, in the jurisdictions AOPA represents 11 to 14 months to get into court from a filing. So we, as Aaron said, there's certainly time for a jurisdiction to make a determination on the funding. But so with regard to it seeming like you could then file the day of court, halt the whole proceeding when you didn't do anything for the year it took, So I'm saying, so Delegate Stewart, to that point that you mentioned earlier, we did feel that would have been a bad faith application. So we did appreciate your willingness to look at that issue. We still, as Aaron said, there's a significant lag in the larger jurisdictions we represent. And so with that, we don't support this legislation, but certainly appreciated your comments with regard to the bad faith, Delegate Stewart.
Is that it?
Yes, thank you.
Okay. Okay, we have Delegate Healy has a question.
Thank you, Mr. Chairman, and thank you to everyone on the panel here. Mr. Greenfield, I wonder if you could address a question for me. You mentioned that Virginia has one statewide agreement. Is the money distributed by the state in Virginia or through the locals?
I believe it is distributed by the state, but that I do not know. I can only speak to my knowledge of them using one uniform statewide agreement.
And just asking, going forward, usually, is that a better system to have one? Would you like to see like a statewide plan here so that you don't have to negotiate 24 different agreements?
Yeah, I think it would be easier. And I think it's something that I know our association and I believe AOBA has looked at and considered as well. I think it makes a lot of sense to have one standard agreement that all the parties can negotiate going forward on what the terms are. I think it makes a lot more sense. You know, right now it is a bit of a patchwork, and I give the counties a lot of credit. You know, they needed a lot of time and runway to get their systems up and running. And so now I think it's getting there, but a statewide plan at the beginning of the process probably would have made things more efficient.
Thank you very much.
Okay, next question goes to Delegate Holmes.
Thank you, Mr. Chair. Mr. Chair, this question goes to you. I was wondering, Mr. Chair, if we have a report from the State Department of Housing and Community Development with reference to how much money they're distributing, and if we have a report from DHCD in terms of what jurisdictions are receiving how much money, and that would probably help us, Mr. Chair, in determining how these delays are taking place.
So are you giving me a homework assignment where I have to ask them for that information?
I'm glad that you are appearing to understand the question very clearly. Thank you, Mr. Chair.
Okay, Delegate Jalise. Well, yes, we'll try and get that information. I'll have our legal counsel look into that. Legal counsel look into that. Delegate Jalise.
Thank you, Mr. Chair. Again, for my clarification, if the tenant who is behind in rent refuses or fails to apply for the emergency rental assistance program, then they are out of this safety net that this bill is trying to create, right? Because I see a lot of people who just don't apply. And is there a time frame that a property owner needs to give to tenants who are behind in rent to be approved for the emergency rental assistance? These are my two questions.
Is this for me, Delegate Jalise?
Anyone can answer. I just thought that this is what I see, that sometimes, a lot of times the tenants don't apply for rental assistance, even though they are behind and because of not processing.
You know,
I just want to clarify my question, Mr. Chair.
Yeah, no, I understand. It's sort of a question for the subcommittee more than the opponents to the bill. But Delegate Stewart, if you want to respond to that.
Yeah, I'll just take a very quick crack at this issue, because this is what Aaron was just referencing and what I referenced in my testimony here. But the issue here is that sometimes, you know, a landlord or a tenant can apply for rental assistance. This is an issue that's come up in the hearing before. Either can apply, but in the vast majority of cases, and really the preferred case is for the landlord to apply. That's a cleaner, more efficient system. However, a landlord cannot apply unilaterally. You need to work with the tenant. You need tenant cooperation. And so what Delegate Jalise is talking about and what Aaron and I had previously discussed is I think we all want to avoid a situation under this bill where a tenant would initially refuse to comply. And then later in the process, once several months have passed, they put in a last second application and then in order to get a pause under this bill. I don't want to see that. I think that would be a bad faith application for rental assistance. I do not think that would qualify under the bill, but I think if the subcommittee wanted to pursue an amendment to clarify that if a tenant refuses to cooperate at the front end, they can't then get a stay on the back end. I would be open to that sort of amendment.
Thank you. Thank you, Mr. Chair.
Okay, any further questions for the opponents to this bill? If not, thank you very much. That concludes the public hearing on House Bill 674. Let's proceed to House Bill 881. Delegate Wilkins, I'm presuming that you're here.
Yes.
And if you are, you have 4 minutes. Welcome to the committee.
Yes, thank you so much, Mr. Chair, Mr. Vice Chair, and all members of the Environment and Transportation Committee. I am, for the record, Delegate Janelle Wilkins, and I'm pleased to present HB 881. This bill is a statewide enabling bill. It gives Maryland counties the direct and clear authority to pass their own local just cause eviction provisions. As you know, I previously introduced a similar bill that applied only to Montgomery County. But with so much interest from several jurisdictions and Baltimore City passing a just cause bill recently, the bill before you is a statewide enabling bill. It allows jurisdictions to craft and pass their own just cause provisions with the flexibility to develop policies that work for their communities. At its foundation, just cause is about the right to stable, secure housing. We know too clearly from this pandemic that having a stable home is a lifeline. Housing is critical for health, to access employment, school, transportation, food, safety, childcare. And when someone loses their home, every single one of these necessities spiral. The fact is that when a resident has a stable home, they can make long-term decisions and have access to all of their critical needs. So what is just cause? It requires a landlord to provide a reason at the end of the lease if they choose not to renew. Currently, with just 60 days notice, a landlord can displace a resident at the end of a lease for absolutely no reason. And renters have no path to keep the roof over their head. At a time when rents are skyrocketing and a lease non-renewal can really put a family in a very difficult place in terms of finding an affordable place to live that suits their needs. I also want to point out that just cause is not a new concept. It is a tested and sound measure used all across the United States and the world. Just cause is the law in Washington, D.C., New York City, the state of Connecticut, the state of New Jersey, Seattle, Washington, Boston, Massachusetts, Germany, France, Portugal, Austria. Many places utilize just cause eviction. I urge a favorable report on HB 881.
Thank you very much. Let's proceed to by the way, we have 21 witnesses signed up on this bill. I believe 48, and well, I don't know. Let's just go through them. Zafar Shah is first. Zafar, welcome to the committee. You have 2 minutes.
Thank you.
Zafar?
I'm sorry. Thank you, Chairman Barve and members of the committee. Public Justice Center seeks a favorable report on House Bill 881. We support just cause and the idea that tenants who follow the rules should have the opportunity to stay housed and put down roots in their community. Recently, I became defense counsel for 2 sisters who rent in a large multifamily building in Baltimore City. And they actually literally have grown up in the building, first in their mother's apartment and then later returning as young adults where they each were leasing their own units in the building. In October, although they were each current on the rent and had no record of delinquency or lease violations, the landlord decided to non-renew them and sued each sister for tenant holding over. So why would the landlord want to do that? In a typical situation like this, the tenant will not know why, and at trial, the judge will not ask why. That's because our current no fault or no cause policy on lease non-renewals means that in most cases, tenants have no trial defense. It's just about the number of days in the notice. So here's the twist in this particular case. The building was financed through the low-income housing tax credit. And federal regs require the landlord to have good cause to terminate, not just a 60-day notice. In this case, the reasons stated were patently discriminatory. One sister was the victim of domestic violence. The other sister was being put out because she was a family member of someone who was a victim of domestic violence. Because of just cause eviction policy applicable to this property, my clients had a defense. They had a way to stop unfair displacement from the place where they were putting down their roots. PJC believes counties should have a clear authority to provide that kind of protection to their renter households, to be free from arbitrary and discriminatory lease non-renewals. So we ask for a favorable report on House Bill 881.
Mr. Chairman, you are muted.
Thank you very much. I understand Will Jawando is here from the Montgomery County Council. I'll take him since he's here and he's an elected official, but it's a 2-minute limit.
Thank you. I appreciate that, Chair Barbe. Good to see everybody, and good afternoon. I'm Will Jawando. I'm an at-large member of the Montgomery County Council, and here to give testimony in strong support and ask for a favorable report for HB 881. I want to thank Delegate Wilkins for introducing this. As has been stated, we know the importance of stable housing. I listened to the last testimony on the last bill, which would be an important tool as well to keep people home. We know it's the effects on children when you move around too much. We know the income. In Montgomery County, we're approaching, we're over 40% of folks who are renting, disproportionately Black and Brown communities who are disproportionately rent burdened, spending 30, 40, 50% of their money on rent. So these are homes. These are not just a transitory group. It's really important that they stay stable, particularly as we try to recover from the pandemic. We know that we're seeing here in Montgomery County on the ground right now. I passed a rent stabilization bill during COVID, which is in effect during May till May, where you can only have a certain percentage increase based on inflation. We are seeing tenant holdover cases increase. We are seeing people go around that law for stable tenants that have been in the homes 10, 15 years, that are now being asked to leave at the end of their lease. That's another reason we need this protection. People need to be stable in their homes for safety, for health, for wellness, and to achieve their full potential. And so I would hope that you consider that and give us this tool in Montgomery County, which we would use immediately to make sure that we can keep people in their homes. The entire council supports this bill. And I would ask that I'm testifying in my individual capacity, but in previous years, we have supported this bill to get this authority. So appreciate the time and thank you, Mr. Chairman.
Sure. I knew I'd regret it if I let somebody get ahead in line. It turns out there are quite a few elected officials. I'm going to take the rest of the people in the order in which they signed up. We're going to hear from Lindsay Bowie, and then we're going through a number of elected officials in the order in which they signed, elected officials and candidates for governor in the order in which they signed up. So let me go to Lindsay Bowie first, and then we'll go to Nick Mosby and Mark Elrich in that order, and then the others will be after. So Lindsay, welcome to the committee. You have 2 minutes, ma'am.
Hello, and thank you. Thank you to the committee for hearing my testimony. I am in favor of this bill. My partner and I and our small children are renters, and we live in Gaithersburg. I'd like to start by thanking Delegate Wilkins and the co-sponsors for introducing this important legislation that can make a real difference in the lives of many renters. The stability of a home for us and our neighbors is extremely important. We have formed deep roots in our community. Our children attend local schools. Our family is close by. And we see ourselves not just as temporary visitors, but as permanent long-term residents. Here in Montgomery County, we have local officials and people running for office who support protecting renters from landlords refusing to renew a lease without providing a valid reason. But if our legislature fails to permit our county to enact just cause eviction protections, families like ours, along with senior citizens, veterans, working people in general, we are all in constant threat of being told to leave our homes with just 60 days notice. As a month-to-month tenant ourselves, that leaves us wondering each month, will such a notice arrive on our door? Our family needs to know that our home cannot be taken away from us at any time for any reason that is not revealed. We are good neighbors who pay our rent. We deserve to live our lives free of anxiety that our son or one of his friends will have to change elementary schools, not by choice, but for no good reason. That's why I encourage the members of this committee not only to support Delegate Wilkins' Just Cause eviction bill, and I encourage your colleagues to do as well. Thank you.
Thank you very much. Next, let's go to former Delegate Nick Mosby. Nick, welcome to the Environment and Transportation Committee. You've got 2 minutes.
Thank you, Mr. Chair, Chairman Barve, as well as Vice Chair Stein, and all the honorable members of the House Environment Transportation Committee. I'm Council President Nick Mosby here to urge a favorable outcome for House Bill 881. We all know, and we're going to hear probably over and over again, the impacts of what COVID-19 has placed on every square inch of Maryland, from the Eastern Shore to Western Maryland to places like Baltimore City and Montgomery County. We know one of the huge outliers associated with the impact was related to housing and housing insecurity. What we also know is that exacerbated current conditions that disproportionately have impacted Black and Brown communities all throughout our state. But what was really, really interesting is during COVID-19, the folks that were our essential workers that we were putting on the front lines to keep our state moving. In response to the growing need of housing security, the council here in Baltimore immediately introduced legislation packages to address some of the housing needs back in January 2021. That legislative package included adjusting rental late fees, establishing security deposit grant program, and of course, looking at providing relief for renewal of residents' leases through Just Cause. The legislation specifically addresses the eviction loophole that allowed hundreds of our city residents experiencing economic hardship to have housing insecurity issues. In July of 2021, data show that evictions from that hardship doubled. And that's when we took swift action. Now, we will hear today that the sky is going to fall with Just Cause, that it's bad policy, that it's anti-business, but that is not what we were able to uncover during post-passing of that legislation here in the city of Baltimore. It provided a essential needed relief for residents, again, without causing undue hardship. Our Just Cause legislation did not prevent a landlord from evicting a tenant that had violated the terms of their lease. It didn't stop landlords from to address the concerns of fellow tenants. And I'll just ask you to pass it. Thank you so much, Chair.
Okay, thank you very much. Again, I want to inform everybody, the reason I'm strictly enforcing a 2-minute time limit is I have 94 witnesses on 11 bills. So, and I'm always the last person to leave the committee. Next, County Executive Mark Elrich is with us. Mr. Executive, welcome to the committee. You have 2 minutes.
Thank you. I'll go right in. So first, I want to say I strongly support this bill, which is going to help protect tenants, enables them to stay in their homes while also allowing termination of leases for certain causes. I first want to make the point that the bill simply enables local jurisdictions to enact just cause eviction. I got involved in this years ago when I was on the Tacoma Park City Council. When we discovered we could not do just cause locally, we began working at the state level to bring about this bill, and I'm glad to see Janelle continuing this work. Rest assured, there will be robust discussions at a local level about how to proceed, but we need the ability to have that discussion and to enact appropriate legislation. Just cause is necessary to prohibit retribution, and tenants have faced retaliation and retribution for simply lodging complaints about the inadequacy of housing. I speak to this from experience. When I was in Tacoma Park and did a lot of tenant organizing, we would go into buildings and find that people who raised complaints said, my apartment has mice, I can't get repairs done. They would get letters from the landlord evicting them. In the old days, landlords used to say, I'm evicting you because you called the housing department. Their attorneys eventually told them you can't do that because the state has retaliation laws. So the landlords learned not to say that in the letter. They just simply said you're being evicted. We found that had a chilling effect on other tenants in the building, because once they knew that somebody who'd raised complaints was evicted, they were unwilling to raise complaints themselves. And we cannot have people living in substandard conditions because of fear to bring these to the attention of the housing department. So I would encourage you to please enact this bill or pass this bill forward. There are definitely legitimate reasons for a landlord to terminate a lease, and any just cause legislation would specify that. However, we need to protect tenants who are speaking out about unsafe and unsanitary conditions. People have a right to decent housing, and we have a responsibility to protect that right. So I support this legislation. I recognize the importance of providing tenants with housing stability and security. Thank you for the 2 minutes this morning. I understand the length of your agenda. Thank you very much.
Okay, next, Tom Perez. Welcome to the committee, Mr. Perez.
Thank you so much, Mr. Chairman and Vice Chair Stein and members of the committee. It's great to be with you again. Thank you for your leadership. Delegate Wilkins, thank you for your leadership. I come to you as both a former local elected official and a former federal official who chaired the President's Interagency Council on Homelessness. I also come to you as the husband of a wife of 33 years who has spent the last 27 years working with people experiencing housing insecurity. These are issues that have been near and dear to my heart. When I was the chair of the Interagency Council on Homelessness, when I was labor secretary, we traveled all over the country. We learned what was going on. I'm here to strongly support this law because what we saw was jurisdictions that had provisions like this were jurisdictions where there was more housing security. Because becoming unhoused is not just a symptom of poverty, it is often a cause of poverty. Housing first models work. That's the number one lesson I learned from being the chair of the Interagency Council on Homelessness. When you house people, you can help address all of a myriad of issues: healthcare, jobs, transportation, mobility. You talk to people who are working in schools with kids who are economically challenged, they will tell you mobility rates are huge. When you don't have these just cause provisions, mobility rates get worse. Housing first works, and laws that enable people like this provision to stay in their apartments promote stable employment. They promote staying in school. They promote success. Success starts with housing stability. And so I want to say thank you to all the people leading this effort. I want to say thank you, Mr. Chairman, to you and to the Vice Chair for your longstanding leadership. Success indeed starts with stability, and I urge the committee to issue a favorable report on this bill. Thank you for allowing me to testify. I have 0 time left.
Thank you very much. Next, John King is before us. John, welcome to the committee. You have 2 minutes, sir.
Thank you so much, Chairman Barve, members of the committee, and Delegate Wilkins for your leadership on this issue. My name is John King, and I'm here today as a former teacher, principal, and United States Secretary of Education for President Obama to implore you to support this important legislation to ensure that no one is stripped of their home without just cause. Housing is a human right, and we should do everything in our power to ensure everyone has safe, reliable, and affordable housing. I was proud to join with Renters United Maryland and CASA last fall in a sleep out to protest Governor Hogan's misguided decision to prematurely abandon the COVID-related eviction moratorium. The connection between eviction and homelessness could not be more stark. In a 2019 study, more than 20% of homeless people surveyed said that eviction had been the cause for their homelessness. In the wealthiest state and the wealthiest country in the world, with nearly 40% of residents living in rental housing, we cannot allow this to happen. As a lifelong educator, I've seen firsthand the devastating impact of housing insecurity on students' academic and socio-emotional well-being. In fact, research has shown that experiencing homelessness and housing insecurity is associated with higher rates of chronic absenteeism, lower academic achievement, and lower rates of graduation from high school. Students who are experiencing homelessness and housing insecurity are disproportionately students of color, students with disabilities, English learners, LGBTQ students, and pregnant students. Without question, greater housing stability will yield better educational outcomes, healthier communities, and a more equitable future. Together with other sensible measures like raising the fee for eviction filings and funding the right to counsel in eviction hearings, this bill would advance the principle that housing is a human right, and help ensure renters are given the rights and respect they deserve. I urge a favorable report on HB 881.
Thank you very much. Let's next go to Annika Dunbar-Gronke. I hope I got your name correct.
You absolutely did. Thank you so much, Chairman Barve. And thank you to Delegate Wilkins and to the entire committee. My name is Annika Dunbar-Gronke, and I'm here today as a Skadden Fellow with the Fair Housing and Community Development Project of the Lawyers Committee for Civil Rights Under Law, which is a national organization based in Washington, D.C. that aims to secure equal justice for all through the rule of law. And my project specifically works to fight housing discrimination through enforcement of the Fair Housing Act, impact litigation, and community-based strategies. My job in particular involves, among other things, providing direct legal representation to tenants in housing court and supporting tenant-led organizing for low-income Black people in Baltimore. Because of this work, the Lawyers Committee for Civil Rights Under Law urges the committee to move HB 881 favorably so that local governments can act with clear authority to protect vulnerable low-income tenants. On our read, the change provided in this bill is important for three reasons. First, it will allow local legislatures to strike a balance between the interests of landlords and the serious local need to ensure that folks in our communities get and are able to maintain stable housing. Housing stability is necessary to build strong, healthy, and vibrant communities and is an important indicator of a fair housing landscape, something that Baltimore and Maryland sorely needs. Second, Maryland's current no-cause system for lease non-renewals is insufficient to protect renters. In Baltimore City, we are seeing that tenants will often face retaliatory filings, or they'll have a failure to pay rent case where they scramble to come up with the money to pay, or they'll face a breach of lease case that a tenant will rush to cure in good faith, only to turn around and see a lease non-renewal for a unit that they would like to stay in and where they have done their best to be a good tenant. No-cause non-renewals mean that community membership is constantly in flux. Families are under constant threat of displacement, and many good folks can easily be trapped in a cycle of housing instability and eviction. Finally, House Bill 881 is simply good governance. It allows localities to respond to what is best for their own constituents, the constituents that they see at the supermarket, who they see at city council meetings, and who they see at church, who they see at community events. And good, smart governance is really something that everyone should be able to get on board with.
If you could
so again,
yeah.
Okay, I was just about to. You beat me to it. So in conclusion, I just want to urge the committee's favorable report on the bill. Thank you.
Okay, next, Council Member Jolene Ivey, former delegate to the Maryland House of Delegates. Jolene, welcome to the committee. You have 2 minutes.
Thank you so much, Mr. Chair, and thank you to Delegate Wilkins for putting this bill in. Housing availability has not kept pace with our population growth, and at the same time, more than half our renter households in Prince George's County are housing cost burden, 51%. Our county is on the cusp of extraordinary growth, and we want to make sure all of our residents benefit. For example, the development of the Blue Line Corridor, the continued expansion of the Woodmore Town Center, and the redevelopment of the former hospital site are all exciting opportunities for our county. We should balance all of this wonderful activities with the protections for renters whose only fault is committing to a rental complex that decides to go upscale and displace the residents. As always, a resident who is not being a positive member of their community should expect for the rental management company to prove they do have just cause to exclude them from their community. Most of us can agree with that. And with the goal of continuing stable living for renters, I support House Bill 881. Thank you.
Thank you very much, Jolene. I, as a former member of the Ways and Means Committee, you did a great job of coming under 2 minutes. I love it.
Oh, I know brevity is definitely something you appreciate.
That's right. Patricia Lopez is next. Patricia, welcome to the committee. You have 2 minutes. Andrew Child.
Yeah, Chairman Barve, I will be translating for her. Is that okay?
It is okay, but let me just say something. The last time this happened, the witness went over 4 minutes. So as a courtesy to people who have difficulty expressing themselves in English, I'm willing to do that. But I just want to state for everybody on the committee and everybody else who wants to testify on the 11 bills we have before us, just be aware of that, okay?
Hola, mi nombre es Norma Patricia Lopez y soy residente del condado de Montgomery.
Hello, my name is Norma Patricia Lopez, and I am a Montgomery County resident.
Cuando llegó la pandemia perdí mi trabajo y me atrasé con el alquiler. Sin protecciones para los inquilinos, como una moratoria de desalojo, he tenido que tomar decisiones financieras difíciles para mantener la comida en la mesa y un techo sobre mi casa.
With the pandemic hit, I lost my job and fell behind on rent. Without tenant protections such as an eviction moratorium, I've had to make tough financial decisions to keep food on the table and a roof over my head.
Como madre soltera de 3 hijos, me he enfrentado a una montaña rusa, dolorosa y emocional de innumerables amenazas de desalojo por parte del propietario y la preocupación constante de si terminaré o no en la calle.
As a single mother of 3, I have faced a painful and emotional roller coaster of countless eviction threats from my landlord and the constant worry of whether or not I will end up in the street.
Antes de la pandemia tenía una posición excepcional con el dueño de mi propiedad y había renovado mi contrato de arrendamiento varias veces. Sin embargo, a pesar de solicitar asistencia para el alquiler a través del condado y obtener la aprobación, mi arrendador se negó a renovar mi contrato de arrendamiento sin dar otra razón que no fuera que estaba en su poder para hacerlo.
Before the pandemic, I was in an exceptional standing with my property owner and had renewed my lease several times. However, despite applying for rental assistance to the county and getting approved, my landlord refused to renew my lease, giving no reason other than that it was in their power to do so.
Antes de mudarme, vi que nuestro arrendador había puesto mi unidad en alquiler por el doble de la tarifa. Eso fue difícil de aceptar, ya que no era digno de ser inquilino porque no obtuve un ingreso que compita con el valor del mercado actual.
Before moving out, I saw that our landlord had placed my unit up for rent for double the rate. That was hard to accept. Was I not worthy of being a tenant anymore because I did not make an income that competes with the current market value?
¿Es justo que mi arrendador ni siquiera me haya ofrecido la oportunidad de quedarme y pagar la nueva tarifa?
Is it fair that my landlord did not even offer me the chance to stay and pay the new rate?
Nada te prepara para tener esa conversación con tus hijos y explicar por qué ya no podemos quedarnos en la casa de su infancia.
Nothing prepares you to have that conversation with your children and explain why we can no longer stay in their childhood home.
Es por eso que estoy aquí hoy, para que ningún otro residente de Maryland en mi situación tenga un destino similar. Solicito que este comité emita un informe favorable sobre el proyecto de la ley de casa 881.
And that is why I'm here today, so that no other Maryland resident in my situation have a similar fate. I ask that the committee issue a favorable report on House Bill 881, and thank you.
Thank you very much, and thank you for keeping to the 2 minutes. I and the committee greatly appreciate that. Next, let's speak with Patricia Lopez. Patricia, welcome to the committee. You have 2 minutes. Patricia?
You just did Patricia Lopez.
Oh, that was Patricia Lopez. Oh, I'm sorry. Yes, so it is. William Roberts, welcome to the committee. You have 2 minutes. Will?
Good afternoon. Good afternoon, Chairman Barve, and good afternoon, committee members. I'm William Roberts, chair of the Montgomery County Renters Alliance. We are an alliance of more than 30 labor, community, religious, and political and civic organizations, and thousands of renters. We are also Maryland's first and only regional nonprofit dedicated exclusively to renter outreach, education, organizing, and advocacy. And we're here today in favor of HB 881 that will simply authorize local jurisdictions to enact just cause protections for their renting residents in whatever form they choose, if any. We're especially grateful to our friend and colleague, Delegate Janelle Wilkins, and the 14 other sponsors from around the state, as well as other elected officials and renters and advocates from around the state who represent the broad support for this measure today. As an organization, we've supported just cause legislation for more than a decade, urging the state to catch up with others, including New York, New Jersey, California, and the District of Columbia that have long-standing renter populations. As Maryland's population of renters has grown from 23% from back in 2007 to nearly 40% today, it's time for the General Assembly to grant this fundamental protection that says no one should be evicted from their home without a good reason. And we oppose any concept, of course, that contract law is made in a vacuum, without federal, state, and local laws governing what provisions a contract can contain. So we hope the legislature will finally find and embrace the understanding that, stable, quality, affordable housing is a right, and that the absence of that has a substantial, financial, social, and humanitarian impact and cost for all of us. So we stand here in support of HB 881, ask for your authorization to allow local jurisdictions to simply choose again to enact those renter protections in whatever form that might come. It's long time to stand beside renters and give them this protection. Thank you so much.
Thank you. Next, let's turn to Glazer Reyes with CASA of Maryland.
They're not present today, unfortunately.
Not present. Okay. How about Natalie Branch with Maryland Legal Aid?
Hi, yes. Thank you, Chair Barve and committee members. My name is Natalie Branch, and I'm an attorney with Maryland Legal Aid in Montgomery County. Legal Aid represents low-income folks across the state, including tenants in a wide range of housing situations. As we've heard, under current law, landlords essentially have an unrestricted pass to evict lease end and month-to-month tenants for any reason or none at all, so long as 60 days notice is given. This leaves the majority of our clients perpetually subject to displacement at a landlord's whim and especially susceptible to retaliation and discrimination. After getting notice of non-renewal, if a tenant isn't out of their home fast enough, they face an eviction in court, an eviction case in court that's nearly unwinnable, with almost no defenses so long as notice was given. This issue has only been exacerbated by the pandemic and the last year and a half. I've advised or represented nearly 50 families facing eviction in this type of situation, and only 3 of those families had any legal defense. It doesn't matter if they'd never missed a rent payment or broken any rules at all. On the flip side, we also often see landlords use the tenant holding over statute as a backdoor to evict when they do believe there's an issue, whether it's unpaid rent or breach of lease, circumventing the protections and due process afforded by Maryland's other eviction statutes. This system incentivizes landlords not to renew leases and instead let all tenants go month to month so they can more easily be ousted at any time. But it's not the only way. Just cause, as we heard, does exist in some places and situations, including in limited circumstances here in Maryland when required by subsidies, as mentioned by Mr. Shaw. In our experience in these cases, landlords are much more willing to work with tenants to resolve potential issues and only evict in more serious cases. Finally, of course, it should be noted that landlords still can and do evict in these cases. By no means does a just cause requirement make it impossible, but it does create a fairer and more balanced process, leading to fewer families out on the street. Maryland Legal Aid urges a favorable report on this bill. Thank you very much.
Thank you. Next, let's turn to Liz Walsh. Liz, welcome to the committee. You have 2 minutes.
Thank you, Chair and members of the committee. My name is Liz Walsh. I'm District 1 Council Member from Howard County, and I'm here to testify in strong support of HB 881. In May 2020, a unanimous Howard County Council, 4 Democrats and 1 Republican, passed rental stability protections just about as extensive as we thought we could legislate at the local level. No late fees could be charged, no rents could be increased against any residential tenant in the county, including those living in our mobile home parks, for the duration of the then existing state of emergency declared by the governor through however long that state of emergency lasted and 3 months after its end. Howard County's Rental Protection and Stability Act lapsed in November 2021. For those 18 months that law was in effect, these modest protections added to a number of others put in place by our local, state, and federal counterparts. Eviction moratoriums mandated by state court, the governor, and federal agency, and rental payment relief aimed at both tenants and landlords, all of them combining to keep our communities stable and whole. I will share with you what specifically prompted me finding and filing rental protections just in my Howard County. It wasn't just the always worry of the generations deep destabilizing that certainly results from even one single eviction, or even the then overwhelming unknown of what new and immediate harm eviction also might exact in the midst of a public health nightmare. It was the calls my District 1 office got almost immediately, just weeks into that first pandemic shutdown in spring 2020. From the grown children or the neighbors of decades-long tenants about our very eldest constituents, some 80 and 90 years old, great-grandmas and grandpas who'd raised families, lived most of their lives in homes they just happened to rent from others in my Ellicott City. These were good tenants, never missed a payment, and now in the midst of this once in their lifetime pandemic, they had nowhere particular to go and no good way to go about it. Now they had 60 days to extricate their lives from their longtime homes for no particular reason, perhaps, for no just cause, just got a notice from a landlord to get out.
If you could wrap up your testimony, the committee would appreciate it.
I still get those calls today. Thank you, Chair Barve and the entire Environment and Transportation Committee for considering this enabling bill. I strongly support HB 881.
Thank you very much. Next, let's turn to Chris Perry. Chris, welcome to the committee. You have 2 minutes.
Good afternoon, Chairman Barve. Can you hear me okay?
Yes, I can.
Good afternoon. Also, Vice Chair Stein, committee members. My name is Chris Perry, and I'm a senior citizen and Vietnam veteran. My wife, Kathy, and I are long-term renters in Silver Spring, Maryland. My wife and I have rented our home for over a dozen years and hope to continue to do so for as long as we can, provided our rents do not increase unreasonably beyond our fixed incomes, and provided our landlord does not decide to give us 60 days notice to vacate our home for no justifiable reason. Seniors like us increasingly depend on our homes to be stable. As we grow older, we spend more of our time on healthcare, routine housekeeping, and in giving back to our community. Aging in place, it's often called. The idea that those who rent our homes should be seen as temporary residents who at any time should be asked to pack up and move is not only unreasonable, but hazardous to our health and damaging to our community's overall welfare and prosperity. Kathy and I are renter activists. We believe in speaking up when building conditions need improvement. But we are in constant fear, like all renters, that we do not mean, excuse me, that to do so would mean landlord pushback, being tagged as problem renters, and possible eviction without cause. We ask you to move this legislation on to the General Assembly. You don't have to agree with just cause protections, but you should agree that the people of each jurisdiction should have a right through their elected representatives to enact just cause protections to the degree that they see fit. As you can see today, the request for this authorization is statewide. We are not college students living in a dormitory or tourists staying in a hotel or Airbnb. We are permanent voting residents who have a stake in our communities and our homes. We strongly urge a favorable report on HB 881.
Thank you very much. Next, let's turn to Tisha Guthrie. Tisha, welcome to the committee. You have 2 minutes.
Yes, thank you very much. My name is Tisha Guthrie. I am a member at large and also on the steering committee for Baltimore Renters United. I urge a favorable report for HB 881. My lived experience as a Black woman, as a woman with a disability, as a licensed social worker, and as a renter, and as a sister of a renter, informs my advocacy around housing and renters' rights. For decades, the nation has denied its obligation to pressing forward in affordable housing and making good investments. No state in the union has enough affordable housing for the demand. And as a result, we are now in a crisis. In December of 2020, in the midst of a global pandemic, after 9 years of maintaining a flawless rental record and with investing in his own property and the property in which he rents, my brother was given 60 days notice to vacate the premises. After paying for repairs and requesting nothing of the property owner, my brother was invested financially and emotionally in his home. The fact is that such abrupt and unwarranted behavior
is unethical and is inhumane, but it's not illegal. And my brother had no legal recourse. He is not alone. There are many people, many neighbors, many residents in our state who face certain similar circumstances. I urge a favorable report for 881, not just for myself, not just for my brother, but for all those who are part of our community. And as has been indicated earlier, our Maryland is becoming more and more of a renter state. So I seriously urge a favorable report for 881. Thank you.
Thank you very much. Next, let's turn to the person who I believe is the final witness in favor of the bill, and that's Corey Warren. Corey, welcome back. You have 2 minutes.
Hi, thank you once again for letting me testify. Disability Rights Maryland seeks a favorable report on House Bill 881. Just cause eviction is a incredibly important bill for local jurisdictions to be able to enforce at the local level. Tenants with disabilities are overly impacted by landlords suddenly pulling away a lease and giving 60 days notice. People with disabilities are overly rent burdened, even more than the general population. Right now, it's about a rent burdened by 157% for somebody whose only income is SSDI, meaning that if somebody was suddenly to be told that they no longer were allowed to stay, they would have to find a security deposit as well as additional funds to move, which for many of the people we represent is simply not the case. We have also seen landlords discriminatorily not renew leases across the board. Generally, what we have seen is if an individual is requesting a reasonable modification or accommodation in their unit, oftentimes instead of paying for grab bars or a ramp, a landlord may simply just choose not to renew a lease in order to avoid paying for the additional costs of making their unit accessible. I think last time I checked, about 57% of all fair housing complaints are disability related, and these are things that we just see over and over again in our practice. And allowing just cause and requiring an explanation of why somebody's not getting a lease renewal will help provide some of those protections that people should have under the Fair Housing Act, but often find themselves being discriminated against through this loophole. So that's my testimony, and I thank everyone.
Thank you very much. We have a number of questions. I'd like to start though. Delegate Wilkins, I have 2 questions. The first is your bill, does it allow a property owner to terminate a lease at the end of a lease if they want to turn the building into a condo?
Thank you for the question, Chairman Barve. So in terms of that question, the bill is just enabling. So a jurisdiction would be able to create their own just causes. So that could certainly be one of the causes. And the idea is that at the local level, jurisdiction could have that conversation around whether or not that should be a cause. Now in the bill, we list out some examples, and these are the examples that we see most often in the just cause bills that currently exist. So there are examples in the bill, but a jurisdiction will be able to.
Okay, all right. Well, you answered my question. I appreciate that. I do have a second question, and that is this. So as you know, because we've debated this in the Montgomery County House delegation, in our building, we had a problem with a person who was a smoker. And so we asked the property manager to evict them, and they said, we don't want to spend $6,000 evicting them, but their lease runs up in 5 months, so we'll just not renew their lease. And that's what they did. They didn't renew their lease. We had to wait for 5 months. But in any case, my reading of your bill is that in that situation, the property owner would have to tell the tenant, you're smoking, we're not renewing your lease. And then assuming that the tenant disagrees, saying, no, we don't smoke, then that's going to end up in court. Am I correct or incorrect in that?
So, Mr. Chairman, this bill does not do anything as it pertains to breach of lease. What you're describing to me sounds like a breach of lease. And so in Montgomery County, I don't know if it's the same for every jurisdiction, but in Montgomery County, a breach of lease can be evicted and taken action upon within 30 days. So I actually would be concerned that the landlord is waiting 5 months to address that issue. This bill doesn't prevent a landlord for someone who's smoking, for someone who is breaching the lease, for them to take them to court. And so I would say that sounds like something that immediate action should be taken. However, because this bill is an enabling bill in terms of how the current bill would impact that, a jurisdiction would craft the exact provisions of just cause. And in this scenario, at the end of a lease, the landlord have to provide a reason. And how it works if a jurisdiction decided to—
Well, Delegate, it's more than a reason. It's the fact that if the property owner and the tenant disagree, then that disagreement is going to have to be adjudicated in some fashion, right?
Well, as you know, Chairman Barve, for any tenant to be removed from the property, to be evicted, that has to go to court. So actually, my direct response to your question is if there is a disagreement and the landlord wants to remove that tenant, the only way to remove a tenant now in Maryland is to evict them. As you know, you have to go to court. It's a court process, a legal process. So this bill doesn't change that. If a tenant is on the premises and a landlord does not want them there, they have to take them to court. So that same process that currently occurs would still occur in terms of the legal process that is an eviction. The difference with this bill theoretically is that the landlord would have to provide a reason, and now a tenant has the opportunity to hear the reason why they are being displaced, and in a court proceedings to be able to discuss that. So that's the sort of the shorter answer to your question.
So the answer is it would be adjudicated, and we're not talking here about an eviction. We're talking about the non-renewal of a lease, and all those disagreements would have to go to court.
No, I'm sorry that I'm not being clear, but let me try to say this a little bit clearer. Okay. If a landlord would choose not to renew a lease, all they have to do is provide notice. The only times that this would go to court is if it became a tenant holding over case. So that's why I'm saying that the response to your
tenant
question,
disagrees.
That's right. That's why I'm saying that the answer to your question is no. If a landlord chooses not to renew.
I think the answer is yes. If the property owner gives notice and the tenant disagrees, then that will go to court.
But it's not, Mr. Chair, it's not just if they disagree. It's if there's an actual tenant withholding case that is filed.
Right, but the whole bill only takes place after the lease is up, right?
I don't understand.
What I'm saying is that the purpose of this bill is to compel a property owner to enter into a new contract unless they have a compelling reason not to. And so by definition, I think this bill doesn't, if I have a 2-year lease with my property owner, this bill really only goes into effect after the lease is expired and I'm month to month, right?
The bill is in effect throughout the entire lease, because when the lease is not renewed, that is when they have to provide notice. So we're sort of changing the scheme. I would not say that this bill is just something that applies after the lease is not renewed, because we're sort of changing the paradigm, Mr. Chair, around what it looks like to have stable housing. So it's not just a bill that only applies.
But forgive me for being concerned about, things like the operation here. My understanding, and and I believe I'm correct, I could be wrong, I'm frequently wrong, but my understanding is that if you have a 2-year lease, you've got a 2-year lease unless you violate it and the landlord takes you to court. But at the end of that 2-year lease, if you're month to month, under current law, the landlord can choose to not renew your lease and ask you to leave at the end of see, I had always understood that this just cause, if you call it just cause eviction, but I think it's just cause non-renewal. I have always taken your bill, I've understood it to say that after your lease is up, they cannot refuse to renew your lease unless they have a just cause.
Correct. That's absolutely correct. That's
Okay,
absolutely
we're in
correct.
agreement.
So let me go. Can I just go through it very quickly so that we can, hopefully this will make sense. So for everyone on the committee, I think we're going a little bit back and forth, might be getting confusing. So let me try to say this simply. At the end of a lease, under this bill, a landlord simply has to provide a reason and provide their existing notice they have to list a reason that is outlined, and the jurisdiction would decide what those acceptable reasons are. Now, if a tenant stays for some reason, tenant withholding case, then the landlord has to file to evict, and that's when it would go to court. So what I'm trying to convey, Mr. Chair, is that this bill is not creating every single time someone doesn't want to renew a lease that they're in court. That is not what that's not what's going to happen. The landlord has to provide a reason. And if it ends up being a tenant withholding case that ends up in court, that's the only time that there would be sort of this court adjudication that you are mentioning. That's the distinction that I'm trying to make. Hopefully that makes a little more sense.
Okay, we've got some questions. Delegate Chalisi has the first question for either the sponsor or any of the advocates. Delegate Chalisi, you need to unmute yourself.
I think my question has been answered.
Okay.
You asked all the questions.
Okay. Delegate Ruth is next then.
Thank you, Mr. Chair, and thank you, Delegate Wilkins, for bringing this really important bill. I believe you mentioned that there are number of other jurisdictions around the country where this type of law is in effect already. And I just wondered if we have data on places that have just cause evictions that would show the impact of that.
Sure. Thank you so much for the question. I just really want to reiterate that we have so many examples of jurisdictions across the country that have just cause eviction. So again, our neighbors in Washington, D.C., New York City, the entire state of Connecticut, state of New Jersey, and these are not enabling bills. This is mandatory. This is the law in these states. And what we are seeing is no negative repercussions. We have combed through, we've contacted a few jurisdictions to check in. Early in my work with this bill, we worked with Washington, D.C. around crafting it several years ago. And so what we are seeing is just added protections, added stability. We're seeing that landlords get used to doing this, that is just a step of providing a reason for the most part. And it's something that they sort of becomes the natural way of doing things and how evictions work. So in terms of specific data, I can definitely follow up with you with different numbers and things like that we found, and if you're looking for actual numbers. But we're seeing positive responses around just cause in other places. And I think it's important to note that this is a well-studied issue and it is the law of the land in other places.
Great, thank you so much.
Okay, next question goes to Delegate Wells.
Thank you very much. So I guess my question is more about Baltimore City, because I know that, and I think the council president spoke to this, but I know that there was some challenges legally to the Just Cause bill in Baltimore. So I wanted to know, what does this legislation mean for what we're trying to do in my jurisdiction specifically? If anyone could answer that question.
Well, actually, I think the city of Baltimore was not able to pass enact their bill because they didn't have state legislative authority, which is why this bill is before us.
Yeah, if I could, Chairman Barve,
Sure.
The city did pass the bill. It was not signed by the mayor on advice of their law department that their power was potentially preempted by the fact that there is a tenant holding over statute. And there's this legal tension here of whether the eviction procedure under 8-402 of real property is, so expansive that it would occupy this legal area of whether a city or a county can state what the terms of non-renewal are. It's an eviction procedure, so it deals with after the expiration of the lease. The city council's prerogative was to look at it as, well, what are we doing before there isn't any eviction procedure? There was a court challenge. It went to the circuit court and then to the Court of Special Appeals. And I think that is emblematic of why this bill is necessary, just as you said, Chairman. If counties want to legislate in this arena of lease non-renewal and just cause, they would want to do so without having to have their lawyers go up to the Court of Special Appeals.
Well, Zafar, Maryland is a state that by some estimates has an 88,000 unit deficit of housing units. And most of those deficits are in affordable rental housing. And we have jurisdictions in the state of Maryland that have had very pro-tenant laws for decades and decades, and they've also had no new housing construction in those same jurisdictions. I mean, are you at all concerned that a law like this might exacerbate an existing problem with respect to the availability of housing? Because most of the Northeast of the United States, and Maryland and Montgomery County are no exceptions, we don't have enough affordable housing because people aren't building it anymore. Are you at all concerned that this kind of a law would exacerbate that underlying market imbalance?
Well, I think it's a concern in theory, Chairman Barve. And when you look at examples of just cause in other jurisdictions, they've at times been paired with rent control or rent stabilization measures. So they're sort of integrated. This bill doesn't do that. So we're really looking at something that is a different animal. If you look at, there are examples where, for instance, you have massive development success in suburbs of New Jersey, in places like Jersey City, where there's actually a state law requiring just cause, and you can look at that over several decades because that law has existed since 1974, 1976, I believe. And so you're not seeing deterrence of development merely because of just cause policy. And then on the the side of affordable housing development, a lot of the financing for those developments, as I was speaking to in my testimony, already involve the requirement for just cause, and those developments still do occur. So I don't think that the weight, sort of the theoretical deterrent to development really outweighs the positives of keeping people in their units. If they're affordable, landlords can still, manage to raise the rent as they need to based on inflation or property taxes and what have you. We've had that discussion in this committee. That just cause is not in this instance tied to rent stabilization. And really one of the, I think, benefits of this bill compared to just a statewide bill not enabling is that it allows local legislators to decide how they want to tailor this policy. If they want to tailor it to, for instance, properties that are not new development, that are 30 years old, they could do that as they wish to in their local legislature.
Are you saying there's no rent control in New Jersey?
No, I'm pointing out that there is a just cause law that you can look at development in New Jersey in over a long period of time, and there has not been, because of just cause, deterrent to development there.
Okay. That's good. Delegate Healy has a question.
Thank you very much, Mr. Chairman. My question is.
Anne, we're having difficulty hearing you. Could you either speak closer to your microphone or you definitely need to unmute? There you go.
Okay, I used the
Sure.
bar and it didn't quite work. So sometimes it does, sometimes it doesn't. But my question is about the idea of state law versus local enabling legislation. Because the example you gave in New Jersey is a statewide law. And I'm wondering if it wouldn't be better as a matter of public policy to have, if we're going to go down this route, to change the way when the lease runs out, that the conditions under which that happens should be consistent from county to county, so that what's a good cause, so a good cause in Montgomery County might not be a good cause in Prince George's County, or vice versa. If they're each one is developing their own list of what's a good cause to require that the person be allowed to stay in the apartment. So my question for the advocates is, have you looked at this rather than leaving it up in the air and letting each county come up with their own rules? Have you looked at doing an actual statewide bill that lists what is a just cause so that we can talk about it? Because there are a lot of questions about what is a just cause. And I'm not sure yet from all the discussion we've heard yet, what might be a just cause that you could use. And if there is a universal understanding of that, then we can have a statewide bill. That's my question. So Delegate Wilkins, I guess you're the sponsor. Have you thought about that?
Yes, and thank you so much. That is an excellent question. First, to answer a part of your question, some examples of just cause are listed in the bill, and just to name a few of them, a substantial breach of lease, a tenant that is disturbing the peace and quiet of other tenants, tenant who's engaging in illegal activity, a tenant who without reasonable cause refuses to grant the landlord access to the leased premises, if the landlord is seeking to recover possession of the leased premises. And I think there are 7 that are listed in the bill, and these came from other states and jurisdictions that have just cause, sort of a compilation of what we've seen in terms of the patterns of what causes are provided. And in terms of the statewide versus the local enabling, I surely will leave it to the wisdom of this committee, but I would not object to a statewide mandatory bill as well. However, we did go with the local because we understand that allowing this to be an enabling bill so that jurisdictions, as you said, in Prince George's County, there might be specific factors that you all want to think about that make more sense, or maybe you all might want to apply it only to certain types of rental properties based on the types of community and rental properties that you have. We understand that there might be various reasons to have a different type of just cause in each jurisdiction. And it's also not unprecedented in Maryland to have landlord-tenant law that's a little bit different in the different jurisdictions as well. So that was some of the thinking that went into it. Thank you. That was a really great question.
Thank you very much, Delegate. My other question is, the other issue is if a landlord decides that this building is getting old and we need to go in and do major renovations. So when the tenants are finished with their 2-year lease, we're going to vacate it gradually and rehab it and then put it out again to rent later with new appliances, and maybe the wiring was done, or the heating system was fixed, or it went electric and got rid of the gas, all kinds of options. So how would this bill affect that situation?
Another wonderful question. Thank you. That is listed as an example. Renovations are an example of just cause in this bill. But again, a jurisdiction would be able to decide what the best causes are that work for their community, since this is enabling. But that is one of the ones that is also listed as a just cause in the bill.
So I'm sorry, does that mean that that could be different from county to county, or is your list of just causes in the bill, is that a floor statewide, and then the locals can do something above and beyond that?
The locals would completely be able to decide on what the causes would be.
Okay, thank you.
Thank you.
Okay, there appear to be no further questions. Thank you very much. That ends the public hearing on House Bill 881. Let's go to House Bill 688, sponsored by Delegate Chilisi. Delegate Chilisi, you have 4 minutes to present your bill.
Mr. Chairman, I apologize if I'm way off mark on this, but did we hear from the
Oh,
unfavorables
wait,
on
no,
this bill?
no, believe it or not, we didn't hear from the opponents of the bill. I was just so anxious to move on. Okay, we do have 3 people signed up against the bill, and you're not off the mark there. Frequently, I make boo-boos. So, first we have Bob Enton, Catherine Howard, and Aaron Bradley in that order.
Okay, well, thank you very much, Mr. Chairman, members of the committee. Robert Enton on behalf of the Maryland Multi-Housing Association, which is a statewide organization representing landlords from all over the state of Maryland. So I looked it up, and this is the 4th year that the sponsor has had a bill dealing with just cause evictions. In 2019, 2020, and 2021, it was a Montgomery County only bill. And that bill failed overwhelmingly in this committee because this committee made the decision that this was an inappropriate law for Montgomery County, and I would assume for any county. It had been a statewide bill. I can't imagine the result would have been any different. I think that's just the reality of this situation. What this bill does, when I look through the real property article, for example, when I look at retaliatory evictions. When Montgomery County wanted to have a different standard for Montgomery County for retaliatory evictions, and they do have a standard, there's a state standard, but then they did what most jurisdictions do, is they come down to Annapolis with a local bill, and we do have a preference for local courtesy, but that's not always the case, because we have 188 members of the Maryland General Assembly going to the Maryland Constitution are elected to decide these issues. So here you have a situation where a Montgomery County only bill has failed for 3 years in a row. And now you're going to have each jurisdiction in the state with absolutely no oversight whatsoever by the Maryland General Assembly will be free to adopt anything they want as a just cause eviction bill, period. Anything they want. And I just can't imagine, and I've been coming here for a while, I can't imagine that this committee or the state of Maryland would feel that that's appropriate. This is an important public policy to decide. So therefore, I will wrap up. Thank you very much, Mr. Chairman. So without going into the details, which Ms. Bradley will do about how the bill works, I think the committee's familiar with that, and we would urge an unfavorable report. I'll be happy to answer any questions.
We'll turn to Catherine Howard next. Catherine, welcome to the committee. Are you here?
She is still not here.
Still not here. Then we'll go straight to Aaron Bradley. Aaron, welcome, and you have 2 minutes.
Thank you. Committee members have heard from AOB on this issue several times in the past, and I've repeatedly shared how infrequent non-renewals are and that less than 2% of evictions are for anything other than failure to pay rent. But last year, AOB supported HB 104, a bill creating new notice requirements for non-renewal of leases because the association understands the difficulties associated with being left unhoused on short notice. However, we oppose the way just cause laws go about it. It's important to remember that just cause laws aren't about notice to tenants or even notice to the court about why a resident's lease was not renewed or a housing provider seeks to terminate a holdover tenancy. We also interpret the bill as Chairman Barve does. Just cause laws limit a housing provider's rights by requiring them to continue a tenancy unless the housing provider can prove to the court one of a limited number of reasons to let a lease end. A housing provider is likely to let a lease expire and choose not to renew if, for instance, a resident is a habitual nuisance to neighbors or neighbors report to property management that a unit is engaging in illegal activity, but residents are too intimidated to call police and certainly won't give evidence in court. The housing provider cannot plead specific facts demonstrating the cause, so the housing provider has no recourse in that instance. AOBA doesn't discount the serious ramifications of residence displacement, but each tenancy is unique and comes with unique challenges. We should maintain the flexibility in how those challenges are addressed. And I'm done, so any questions?
Oh, okay, yes, the first question is Delegate Stewart.
Thank you, Mr. Chairman. I'm having deja vu all over again. Mr. Enton, I feel like we've lived several decades chatting about this bill. And I actually really enjoyed the back and forth between the sponsor of the bill and the chairman of this committee. I thought it was interesting. And it brings something to mind that I've always felt about this bill, which is that it kind of plugs a loophole in my mind around retaliatory evictions, which you brought up, which is why I'm directing the question towards you. I've always struggled to figure out that without putting this essentially this burden of proof on the landlord to prove a just cause, I struggle with how a tenant would ever prove a retaliatory eviction. So my question for you is, first, how would you prove it, without absent a mind reading device or something from the future, how does a tenant prove in court a retaliatory eviction?
I think it's very simple, Delegate Stewart, quite frankly. The retaliatory eviction laws have been on the books for a long time. It's enumerated what it means. And I'll give you a prime example. I'm a tenant. I've complained to the landlord over and over again about the leaking roof in my apartment, okay? And now the landlord wants to evict me, whether it's for failure to pay rent, whether it's for tenant holding over, whatever it is. And I go to court and I say to the judge, I say, I've documented, I have complained, on 6 different occasions, and give the dates and what the complaint was. I've always paid my rent on time. Okay. And this non-renewal, this eviction proceeding, however you want to characterize it, is a retaliatory eviction. I made a complaint to the city or the state that my rent was raised because I'm a minority. I mean, you can go down the list. If you feel that the retaliatory eviction law needs to be somehow updated, then fine, let's have a bill to update the statewide retaliatory eviction law. And at the same time, you can look at the Montgomery County eviction law. That's not what this is about. This is about the fact that the lease is over, okay? The lease is over. We don't require the tenant to stay there when the lease ends, okay? Unless they have certain grounds for leaving. And likewise, I think from the landlord community, if as the example that was given, you have a tenant that is constantly, you're getting complaints about from other tenants, or the tenant that's leaving his trash in the hall, whatever it is, now you're going to have to go to court and prove that it was not on it, that it was on account of one of the enumerated, and who knows what every county is going to put in their statute if you leave it up to the local government. I can't see why you want to leave it up to local governments and rather than have the state set this policy.
Is discovery allowed in a tenant holding over case?
I don't know. I don't know whether you get to file, in district court, you can't take depositions, but you can file up to 15 interrogatories. I don't know whether maybe Aaron, Ms. Bradley, or we'll get you the answer to that, whether or not there is discovery.
I think the answer is no. Of course, like a good lawyer, not that I actually am one, I'm pretending to be a good lawyer. I kind of knew the answer, but when I asked it, so the answer is I know. So there is no discovery, but I do have a question for you that I don't know the answer to, and obviously, Ms. Bradley, if you could follow up too. I just find it so hard with the burden being on the tenant, who is, as we all know, unrepresented by an attorney in upwards of 95% of the cases. I just can't imagine how a tenant would ever win one of these retaliatory eviction cases. And of course, Mr. Hinton, I look forward to putting in a bill next year and working arm in arm with you on passing an update to the retaliatory eviction law. And I very much appreciate you offering that. I will reach out to you in April with some of my plans. But until then, I just have a request. It's less of a question, more of a request, if I could, Mr. Chair. If y'all could just send me the case number and I'm sure there is one. So it's not a gotcha question. If y'all could just send me the case number of a bill where the tenant had the burden of proof to prove retaliatory eviction and they were pro se and they won. That just one case, that would help ease my concerns.
Sure. Delegate Stewart, can I send you information from the Montgomery County Office of Landlord Tenant? It didn't go to court, but it was investigated by the Montgomery County Office of Landlord and Tenant. Is that
okay? All right, send me whatever you got. I appreciate it.
So can I just respond very quickly? And that is to say that I think that the real issue here is that to consider as we consider this bill this year is the fact that the Maryland General Assembly enacted a right to counsel bill in landlord-tenant cases last year. And there are a number of bills this year to find the funding for that. And so I do think that we are going to move the ball clearly forward to provide counsel in landlord-tenant cases. And I think people will be represented by counsel. And when they explain to their counsel what their history is, that's an argument that's going to be made if they want to challenge the landlord's eviction proceeding because they're a tenant holding over. Then I think that will be dealt with, Delegate Stewart. And we never had a problem with that.
And I appreciate that. And I obviously supported the bill last year. I actually am not 100% sure if the right to counsel is available in these in affirmative claims. I think it may only be for defensive ones. So it would be a question, and it may actually be a question of the enabling legislation of this bill, whether or not you could get funding. But I, of course, agree that this is the kind of thing I would like for people to be represented and get funding for. So I appreciate it.
Thank you.
Okay, the next question goes to Delegate Foley.
Thank you, Mr. Chair. I'm not a lawyer. I'm not even a mediocre lawyer or whatever Delegate Stewart said he was. but I'm trying to understand. First of all, I like the idea of a just cause and the burden of proof that just cause brings, particularly when it comes to evictions. I think evictions are a very serious action to take on someone's part. But my question really relates to the fiscal note. The fiscal note says that the otherwise, after listing the just cause requirement, otherwise the bill may not be interpreted to alter the rights of a landlord that seeks relief under Title 8, Subtitle 4 of the Real Property article. So is my understanding correct that the process remains the same in terms of access to court and who goes to court? It's just what is needed to prove the case. Do I have that correct? Maybe that's for Mr. Enton or Ms. Bradley.
I'm not sure. Maybe I have to get back to you on that. I think that, the bottom line is that if the tenants fail to pay the rent or done something else that would breach the lease, then it doesn't impact those types of cases. I think that's probably what it's saying.
Okay, thank you.
All right, there appear to be no further questions for the opponents well, actually, I do have one question for either Bob Enton or Aaron Bradley. Is this just cause eviction or just cause non-renewal?
Well, it's interesting you asked that question because it's worded, if you look at the title of the bill, and I raised this question with my client, we used to see bills about local just cause eviction, okay? Just cause eviction before the title of the bill was changed to something more kind of, global, like, tenants' rights or something. So, but this year it changed to just cause termination. And, I thought about that. I asked my client about it. I talked to Ms. Bradley about it. And I think the answer is based on the testimony, and I've read this bill, believe me, 25 times. I think the bottom line is it's the same, has the same effect. And that is whether it's tenant holding over or whatever, or whether it's just cause termination. If once you terminate, then you're going to evict. So I think I think it has the same impact ultimately that the bills in the past have had.
So just looking at the bill text, if I may, Chairman Barber, if I may respond, just looking at the bill text, it literally says a complaint filed under, you have to have a statement of the just cause for the non-renewal of a lease. It says throughout that it's about the non-renewal of a lease or the termination of a holdover tenancy. So it's both. It's if you choose to not renew the lease at the end of the term, it also applies, as the bill says throughout.
Well, what do you know? Everybody's right. And on that note, we're going to move on to the next bill. Thank you all very much. Let's move on now, finally, to House Bill 688. Delegate Jalisi, you have 4 minutes to present your bill. Jay?
Thank you, Mr. Chair.
Okay.
For the record, I'm Delegate Dr. J. Jalisi, and I'm presenting my bill HB 688, which is about the buyer identification in residential contracts of sale. Chairman Barbe, Vice Chair Stein, and my colleagues in the Environment Transportation Committee come before you to introduce a bill that is aimed to protect victims of domestic violence, racial discrimination, and any other home buyer who may have a legitimate fear of her or his safety, security, or of fair treatment. The bill authorizes the buyer to mask the buyer's identity when entering into a contract of sale for a single family residential property that is executed through a real estate broker, but the identity of the buyer is disclosed to the broker during the process. The bill applies in the future and does not have any effect or application on any residential contract of sale executed before its passage or October 1, 2022. And thank you for your time. That's basically the bill I have. I request a favorable vote.
Okay, believe it or not, only you are the only person signed up to testify in favor, and only one person is signed up to testify against. So any questions for the yes, Delegate Ambry has a question for the sponsor.
Yes, thank you, Delegate Lisi. Just want to, this bill sounds really familiar to a similar bill we had last year from, I believe, Delegate Bridges. Wanted to get some understanding on any differences between this bill and last year's bill, and
I don't know the difference. I just put in my bill.
Okay.
Thank you.
Any other questions for the sponsor? If not, we'll turn to the let's see. Oh, there are two people. No, there's only one person signed up to testify. Lisa May with the Realtors is signed up in opposition. Lisa, welcome back. You have 2 minutes.
Thank you, Mr. Chairman and members of the committee. We are signed up in opposition to this. It is not because of the intentions that the sponsor is trying to address, but really just the nuts and bolts, the practicality of this bill. Removing signatures from legally binding contracts creates a lot of confusion, a lot of questions as to whether it still complies with, for instance, federal law, with mortgage lending requirements, with Maryland's code on the, for instance, the statute of frauds. So, you know, again, this is a very important topic because yes, discrimination does happen in housing cases. And we are sensitive to that, but whatever solution we come up with needs to also leave an orderly and predictable real estate contract process behind. So we have had some discussions with the sponsor already. We will continue to do so. But in terms of the bill as it is currently introduced, we must request an unfavorable report.
Okay.
And I'd be open to any amendments they might suggest to make it acceptable to them.
Okay. Any questions for the opponent to the bill? All right. Seeing none, that ends the public hearing on House Bill 688. Now let's turn to House Bill 705. Oh, that guy again, Kumar Barve and Dana Stein. So, you know, I guess if you're a lawyer, every problem looks like a lawsuit. And if you're an accountant or a business person, every problem looks like a market imbalance. So this is my contribution to the ongoing debate of what really ails the state of Maryland with respect to affordable housing. The purpose of this bill is to require the Maryland Department of Planning and anyone else who would be working with them to provide an annual report that has to do with the number of the state of housing in the state of Maryland, which would include such things as the number of new housing units that exist in our state by a county by county basis. I've heard it said that we have an 88,000 unit shortage of housing. And I've heard it also said that, if anything, that is a low estimate. I've heard people saying that, oh, you know, in Baltimore, they're building apartment buildings all over the place. And when you ask what kind they are, invariably they're apartment buildings that really cater to upper middle class folks, not the people who really are most in need of good housing. And so the purpose of this bill is to really begin the process of doing a complete inventory of housing in the state of Maryland, because, you know, we have these fights between landlord property owner advocates and versus tenant advocates. And to me, this, and I've witnessed this now for, well, this is my 8th year witnessing this. And to me, it seems like a rather sterile attempt to define who the bad guy is. I'll tell you my bias. I'll tell you what I think it is. I think that average citizens in the state of Maryland simply do not want affordable housing in their neighborhood and in their school cluster. I think the very same people who are so concerned about all of the racial ills in our society will be the first people to go to DEFCON 1 when somebody tries to put affordable housing in their neighborhood. Don't get me wrong, I love seeing all the Black Lives Matter signs in my district. I love them all. I agree with the sentiment. I consider myself to be a supporter of that movement. But you know what? The best way to pick up people who are of color or poor, regardless of their skin tone, is to build decent housing everywhere in the state of Maryland. And before we can do that, we have to know what we're looking at, because as I learned in business school, and as I'm sure everybody who's gone to business school has learned, if you can't measure it, you can't improve it. And that's why I've introduced the bill. I realize that some of the, we're going to have to flesh out the details of what ought to be reported and how often it ought to be reported, but that's my motivation. I want to measure the problem so that we as a committee can solve the problem. And I'm going to go to the, strangely enough, when the chairman of a committee has a bill like that, nobody signs up in opposition. Imagine that. So we're going to go and recognize 3 people who signed up in support of the bill. And of course, I or they would be happy to answer any questions. The first is Robert Enton, who has signed up in favor of the bill. You have 2 minutes.
Thank you very much, Mr. Chairman. And I hope you'll note, based on what you said when I got started in your committee today, this is the second bill that I'm favoring today. And on behalf of the Maryland Building Industry Association, we're in strong support of this. You know, I've been coming in front of your committee on behalf of the landlords. I come in behalf of the builders. I come in for the bankers who make mortgage loans. And I think that what you're trying to achieve here is really relevant to so many bills that your committee hears and so many policy issues that the General Assembly deals with, because it's a critical issue, and it impacts mortgage lending. Like I say, it impacts landlord tenant, it impacts the building of homes. And we just think this is an excellent idea. We look forward to working with you to flesh out, details. But I think it would be really, really instrumental in helping us to deal with bills such as the bills that you're hearing today. So that's why we support it. Thank you.
Okay, next let's turn to Lisa May on behalf of the Realtors. Lisa, welcome back to the committee.
Thank you, Mr. Chair and Mr. Vice Chair, for bringing this forward. Lisa May with the Maryland Realtors. As was mentioned, we do have a housing shortage in Maryland, but trying to pinpoint exactly what that number is can be very difficult, because a lot of the housing research is conducted at either the national or the metropolitan statistical level, which doesn't really lend itself to getting a true picture of what is going on within Maryland's borders. We at the Maryland Realtors have what we think is a very conservative estimate that we are 82,000 units short. If you look at the housing needs assessment that the state put out in 2020, it's 85,000 units just for low income residents. So when you start throwing in factors like affordability, location, housing type, the population that would need to be served by these units, that number can increase exponentially. And we really do need to address this housing shortage. Defining it is a great place to start so that we can move forward. So we very much ask for your favorable report.
Okay, and finally, Claudia Wilson Randall is with us. Claudia, who are you representing? And welcome to the committee.
Hi, good afternoon. My name is Claudia Wilson Randall. I am the Executive Director of the Community Development Network of Maryland. And
now I recognize you.
For accommodating me as I try to stretch between online and in person. I just want to urge your favorable report for House Bill 705. I think it's really, as I heard my colleagues and partners talk about, it's really important that we start working towards the 85,000 units that we need in Maryland in order to address the need for affordable housing throughout the state. I also do want to just highlight the Maryland Housing Needs Assessment. It was completed in 2021, and that should be a level-setting conversation for the state in terms of what are the needs for housing across the state of Maryland and who needs it most. And this is an issue, as I see it, this is not just an issue for one part, but it's an economic development issue statewide. As long as we have jobs that pay $25 an hour or less, we have got to address that. And we want a state of opportunity. And for the last 2 years, this legislative body spent a lot of time arguing about Kerwin and education financing. Hey, the education system is not going to be able to do it all. We're going to need to address communities and neighborhoods and land around schools. We need to have decent places for children to grow up and have an opportunity at a good, productive life in the state of Maryland. So I urge your favorable report for House Bill 705. Thank you very much.
Okay, you're welcome. Well, the first impertinent question will go to Delegate Ampry. I'm joking, of course.
Thank you, Mr. Chair. Really appreciate this bill. It's something near and dear to my heart as well, as far as getting more housing opportunities across our state. And I think you eloquently put the whole concept of a lot of people want to enjoy an omelet, but don't want to crack the egg, right? So
yep.
I appreciate that. So my question, looking at the bill, I know you said there's more work to do as far as figuring out exactly how you want to put forth the metrics. Wanted to see if you all you'd be willing to add like more of a historical equity lens to the assessment year after year, right? Or maybe in the initial assessment, because I think part of the housing issues that we have go beyond just, looking at what we have right now, but it's also important that we analyze like what has happened before. Like, is there more of an onus on certain communities and maybe do even more because of prior history? So is a historical and equity analysis something you'd be willing to add to the bill?
Yeah, it is. I think there's no such thing as too much information or too much relevant information. I just wanted to begin the discussion and the work here and now. So yeah, I would very much welcome that kind of inclusion into the fact finding.
Awesome, thanks.
Delegate Healy, class of 1990.
That's right. Thank you again. I really appreciate this bill. I think it's something that is seriously needed. My question is about, what kind of housing are we going to study? Is it because I know for patterns that are happening that people don't talk about much, where families share, they rent a house, and you have 2 or 3 families living in the house because that's all they can afford when they have more than 2 or 3 people in their household. And if you've got a family with 4 or 5 or 6 children, finding residential housing is extremely difficult, and especially even more so if you're low income, but even middle class people have a hard time if they have big families. So I was wondering if that is something that you're going to be looking at as well.
Well, I would like to. Yes, to answer your question, I mean, I'm aware of that because there are many many houses that are being rented in Montgomery County that I'm aware of personally that have 3 families living in them. I know that when my mom was a single woman, working for the Indian Embassy in the 1950s, she rented a room from a person who lived, had a house that her landlady had paid off the mortgage or was close to paying off the mortgage that she got during, the Depression years. And, it was a very cheap accommodation for my mom when she was starting out. And these are exactly the kind of accessory, that's not accessory dwelling unit exactly, but it's a part of something that we don't have enough of for people who are starting out. And so, yeah, I definitely want to know about details like that, because I think it's important for us to have a clear inventory, as I've said, of what's available.
Thank you.
Delegate Terraza.
Yeah, thank you, Mr. Chairman. I think this is a great idea to have an inventory, like you said, a measure of what we have. And along the lines of Delegate Ampry, I'm wondering, I don't see the words affordable housing in here, and I'm wondering if you'd be willing to.
Yeah, no, I mean, my view of this is I really would like to know first of all, because believe it or not, I've been chairman of this committee for 8 years, and I really haven't focused on what the proper gradations of housing categories there are and how we should split it out. I want to know everything from, the person in the mansion all the way down to a person renting a room. If it's possible to get to that level of detail, I think the state of Maryland ought to be annually compiling that information by county.
Right. So like the income, like what income those units are aimed at. So I think obviously that could be used for that.
Yeah, the bill as it's written right now doesn't have much of a fiscal note, and I'd like to maintain that as much as possible. But I think that, I'm going to be biased in favor of more information rather than less information.
Yeah, same here. Thank you.
Okay, any further questions? If not, thank you very much. Thanks for treating me so fairly. That concludes the public hearing on House Bill 705. Let's go to House Bill 720. Delegate Chanel Branch. Is this the first time you've been before our committee, or do I just have a bad memory, Chanel?
Nope, it's the first time.
Okay, well, I probably also have a bad memory too, but welcome to the committee, and you have 4 minutes for House Bill 720.
Thank you, Chairman Barve, Vice Chair, and members of the Environment and Transportation Committee. For the record, I'm Delegate Chanel Branch, and I come to you today to ask for your support for House Bill 720, Real Estate Brokerage Services and Termination of Residential Real Estate Contracts. This bill will require a real estate broker or an escrow agent to distribute trust money to a purchaser within a certain period of time. If the purchaser terminates a real estate transaction under the terms of a contingency clause in the contract of sale for residential real estate, this bill will provide transparency, provides transparency and resolution to the transaction process of the trust money deposit, which many refer to as an earnest money deposit. An earnest money deposit is an amount of money given to the buyer in a good faith to show that they're interested in purchasing a home. These funds are collected to protect the seller in the event that the buyer decides to back out of the sale. The deposit is typically around 1 to 3% of the sale price, and it is held in escrow until the sale is complete. This bill would allow a buyer to receive their earnest deposits back in a timely manner if a home has a certain unresolved deficiencies. This is an important, it is very important to have this necessary protections in place to resolve the matters such as this one. But however, if a dispute arises over the earnest money deposit between the buyer and the seller, both parties have the right to settle them in court. I would just like to mention that this bill passed the House last year, but in the form of a work group. And since then, I have worked with the Maryland Realtors and brokers to resolve the opposition that they spoke about last year. So today I just asked for your consideration of a favorable report for House Bill 720. Thank you.
Thank you. And also signed up in favor with amendments is Lisa May, why don't we turn to her, and then we'll entertain questions for the sponsor and Ms. May. Lisa, you're on.
Thank you, Mr. Chairman, and thank you to Delegate Branch for bringing this bill forward. As she mentioned, oftentimes earnest money deposits accompany a contract for sale. And when you are a first-time buyer, you have scraped together maybe just a couple of $1,000s to try to bring this purchase forward. And when a transaction falls apart and that money is held up, you can't just go and scrape together another $1,000 or $2 to try to make a purchase on another property. It's all that they have. And also with these disputed accounts, they can sit with a broker or with a title company for years and years and years because they can't dispose of them without the agreement of both parties. We want to address both of those issues with this bill. So when a buyer exercises very controlled contingencies and exercises them properly within the contract, this would automatically release the deposit money back to that buyer. And then it will also cut down on some of the court disputes and some of the disputed accounts that the brokers or title companies have to hold on to indefinitely. So those are the two goals of this bill. As we mentioned, we had a one-word change that is in our written testimony. It is page 7, line 1, just to outline that these contingencies are the exclusive ones to which this process would apply because they are the more straightforward contingencies that someone can exercise. So with that, we ask for your favorable report.
Chanel, what did you do to me? I mean, we've got 14 people with their hand up to ask questions. Okay, it's the oldest hazing ritual in the legislature. What can I say? In any case, who has an actual question? Nobody. What do you know? Oh, well. Okay, Chanel, you made it out of my committee unscathed. Nobody's signed up to testify against your bill, so you're free to go, Chanel. Good to see you here.
Thank you.
Okay, let's turn to, oh God, what a rogue. Delegate Bridges, 762, House Bill 762. Here we go. Former member of the committee. Welcome back, man. How you doing?
Thank you. Thank you for welcoming me to the committee. This is a great committee. Let me get that out of the way before I start. You all are a great committee. Don't give me a bunch of questions.
Thank you. That you've sucking up skills well from the chairman. So
no, I definitely appreciate it. To the members of Environment and Transportation, Chair Barbie, Vice Chair Stein, thank you for the opportunity to present House Bill 762, which you actually heard last year. It's the residential contract of sale or the home buyer identification bill. This is actually an updated version of the bill that you heard in this committee last year. We've gotten a few amendments that I was actually told by the amendments office you may not have. So I'll explain what those amendments are, and I'll make sure that I get those over.
Hey, let me interrupt. Somebody needs to start the timer, and Bridges, you just are the beneficiary of a slow timer, so go for it. Continue.
I love it.
Yeah.
So I just will make sure that I get those amendments to you, but I will explain those amendments. This is, again, about protections for sellers and buyers, which we really don't think go far enough in terms of acts of discrimination that you'll hear from our panel. Of course, it's a policy of the state to provide fair housing throughout the state. However, I still contend that names of individuals can reveal a person's culture and ethnicity, which can lead to a person or families being discriminated when purchasing a property. So a person can argue that discrimination based on an ethnic sounding name is a form of discriminatory treatment, but to prove that, the burden is really on the buyer, so that the seller, on the buyer to prove that the seller intended to discriminate. Without a showing of intent, a successful lawsuit can be problematic if a buyer feels they have been discriminated against. If you can prove valid reasons for turning down a potential buyer, such as that he or she could not discriminate the financial ability or wasn't willing to post a deposit, then the sellers are safe. But sellers can actually reject higher offers without one of those reasons. And it's on the buyer to prove that it could have been because of the name. So as a result of the hearing last year, we have amended the bill to adhere to some of the concerns that this committee had, such as there was a concern that the bill was to permit buyers to be able to elect whether or not to be identified on a residential contract of sale. The intent of this bill is for the name of the buyer to be prohibited so that the bill will be applied uniformly and consistently for all buyers on residential contracts of sale. So the removal of the buyer's name fields from the residential contract of sale and associated addenda also simplifies that application. Last year, the Attorney General's office stated that they were concerned over entity purchases. This amended bill specifically states that the bill is for residential home buyers and will not apply to commercial or investment purchases, nor for purchases by entities. Also last year, there were assumptions that offers to purchase would not contain necessary initials or signatures. This amended bill does contain language to allay those concerns. The residential contract of sale, though not containing the name of the home buyer, will contain the necessary initials and signatures to support a valid contract once executed by the seller. Also last year, the questions about whether there might be fraud by a buyer who is not identified in the contract of sale. This version of the bill, the buyer would execute a document with the buyer's broker. An exclusive buyer agency document would support this. In the event that there's unrepresented buyer, a document verifying the identity would be required. So again, Mr. Chair, we have an opportunity to make this right. I'm going to try to keep bringing this back until we get it right. And hopefully this is the year, but we have the opportunity to make sure that people are chosen based on their ability to purchase and not by the backgrounds or based on a name. So I do have some real estate executives here who can answer some more specific questions as part of my panel. And I do hope that you will look favorably upon this request. I know I have Kimberly Kepnes, Julia Frazier, and Rory Murray from the Maryland DC Credit Union Association who are here to support the bill as well. And I'd be more than happy to take questions.
Sure. Well, are they here only to answer questions or are they here to testify?
I believe they want to testify as well.
Okay. In that case, Kimberly Kepnes, you're the next. You're the next contestant. You've got 2 minutes. Welcome to the committee. Kimberly?
Hi there, can you hear me?
Yep, I can hear you now.
Thank you. Chair Barbe, Vice Chair, honorable members, thank you for allowing me the opportunity to testify in front of you again about removing the home buyer's name from the residential contract. I'm Kimberly Kepnes. I'm an associate broker with Monument Sotheby's International Realty. I'm one of the sponsors. I think what we're here today to answer is this question of whether our current fair housing laws are enough to protect home buyers when they're negotiating with home sellers. We don't think the law is adequate to address the challenges that technology has created in our industry. Chief among the challenges is the power of Google. As a 30-year realtor, I know I have very few home sellers who are not very interested to know everything they can about a buyer. And in fact, many of them take great pride in sharing all that they have been able to uncover. Some of that information might be familiar. They came from the same place, went to the same school, maybe share friends. Some information, though, might not be familiar, or worse, give pause, create doubt, and result in bias. And we hope and encourage as realtors that sellers only make decisions based on price and terms, but we know when there's a choice, personal information gets in the way and it can result in decisions that violate fair housing. And in practice, realtors have been recommending for years love letters. You may have even written a love letter of your own, including a photo about you. In practice, though, in the United States, these have come under fire because they do threaten fair housing. And Maryland Realtors has recently prohibited, as of October 1st, 2021, any Maryland Realtor from utilizing a love letter for their seller clients on behalf of a buyer client. By removing names from our contracts, it ensures that it protects home buyers and it protects home sellers from bias, whether it's implicit or otherwise, in a way that the current law doesn't have.
If you could start to wrap up your testimony, the committee would appreciate that.
Thank you.
Delegate Williams,
Okay.
I'll just skip her because she's in another.
Okay. Next, let's go to Julia Martin Frazier. Ms. Frazier, welcome to the committee. You have 2 minutes.
Thank you so much.
Good afternoon, Chairman Barvey and members of the committee. I'm Julia Martin Frazier, a licensed realtor. Thank you for the opportunity to speak here today. We as realtors work with all kinds of people, and it is our duty to represent them equally and fairly. Our code of ethics directs us to work on behalf of every protected class. We must guide our sellers and buyers to follow this code as well. And the very name of a person could potentially indicate the existence of one of these protected classes. When an offer to purchase a home is presented to our seller clients, one of the first bits of information they even see is the name of the prospective buyer. And immediately the stage is set for bias, implicit or otherwise. Names tell stories. And the potential danger is that these stories could influence a seller to potentially exclude a buyer from purchasing their home. I'll briefly give you an example. In a multiple offer situation, my buyer's client's offer was declined, despite being told that our offer was the strongest and would be accepted. It was only until the names of my clients, Chuko Ibuko Amuna, Chuko Nanso Amuna, and Cynthia Torres Delgado, were presented on the contract of sale when they learned that they had not won the bid. As in the case of many instances of implicit bias, this is difficult to prove. Therein lies the sensitivity of this issue and the need to remove even the shadow of a doubt that any bias is at play. Winning a bid in this very competitive market is difficult enough, let alone having to overcome the potential discrimination that our current contract process allows. I thank you for your time and consideration of this important legislation that would level the playing field in the home buying process. Thank you.
Thank you. And next, let's hear from Rory Murray.
Chairman Barvey, Vice
with
Chair.
amendments.
Yes, favorable with amendments. Chairman Barvey, Vice Chair Stein, Rory Murray with Providence Strategies here on behalf of the Maryland and DC Credit Union Association, the 70+ credit unions that are headquartered in the state of Maryland and their 2.2 million members. We did oppose this bill last year. However, we are favorable with the amendments. The credit unions support any and all efforts to decrease discrimination in housing opportunities. The Sotheby's folks, to their credit, seem to have identified a potential gap in home buyer protections. And in their conversations, they've been very generous with their time with me. And in conversations with them, I honestly couldn't believe some of the stories. I hadn't really thought of it until they had started discussing it with me. Our issue last year, that there was a little bit of ambiguity in the language, and we requested for our comfort just to clarify that other documents related to the home buying process, i.e. documents with lenders, would not be shielding the home buyers or the sellers' names for obvious reasons. So as I said before, the proponents were more than generous with their time. They listened to our concerns and they amended the bill to help us out. So once again, we think, from our perspective, this is a good bill. If people are being discriminated against due to their names, and there's something that can be done about that, we think something should be done moving forward. Thank you for your time.
Thank you. We only have one person signed up in opposition, so I'm going to allow her to testify, and then we can ask questions of everybody. And that's Lisa May, who's with the Realtors, is signed up in opposition to the bill. Lisa, welcome back. You have 2 minutes.
Thank you, Mr. Chairman. And again, as with the prior buyer ID bill, our opposition has absolutely nothing to do with the scope of the problem that we are seeing in the marketplace. In fact, we would have likely given word for word testimony to match that of our realtor members who are here today. Really, our disagreement, or at least our concerns, has to do with the specific nature of this bill. We are taking a look at the amendments. I believe that we still have some concerns even with the amendments that we have seen so far. Again, we just want to make sure that we are keeping real estate contracts and all of the other related materials valid, legally binding, and that we have a very orderly process for real estate contracts. As mentioned, we have worked on our own on some fair housing issues. In addition to banning love letters, as was mentioned before, we have added explicit statements to our buyer and seller representation agreements that remind those members of the public that fair housing laws apply to them as well, not just to agents. So we are very serious about this issue. We are going to keep working on this issue. And hopefully we can get to a place where we have amendments on this bill that make sense. But as it was introduced and as we stand right now, if nothing were to change, we would have to ask for an unfavorable report. Thank you.
You're on, Mr. Chair, you're on mute.
You're on mute, Delegate.
Well, maybe I didn't want you to hear me. Before I go to the questions, let me just say that if I remember correctly, Delegate Bridges, the last year's concern was that it was logistically difficult to arrange all of this without really gumming up the works. Do you feel and you're aware of that, right?
Right. So I do feel like we've gotten to a point where, in speaking to the folks from Sotheby, that we can actually get not have names because of technology at this point, right? So a lot of times now, when we actually go to sign things, sign documents online, you can sign those documents electronically, and you can use your initials rather than putting your full name on there. And I think that hopefully doesn't gum up the issue if everybody is using the same uniform type of contract when you move forward with purchasing a property. Again, we're also willing to work with those in opposition. I think we want to get to a good point with this bill. And I think we've come a long way from last year, but if there's still opposition, we're willing to work with whoever is in opposition to make sure that we get it over the final hoop.
Okay, first question goes to Delegate Ruth.
Thank you, Mr. Chair. And thank you, Delegate Bridges, for bringing this bill. So just a quick clarifying question, because it's a little confusing because we just saw another bill that appears to have identical text. And I know you said you're amending it, but this bill as introduced is a bill you introduced last session. Is that correct? Thank you.
Yep. It was introduced the same way. However, it should have not have been the same bill as last year. It's something that we didn't catch until very late. And so the amendments were sent in, but obviously if you don't have those amendments in front of you, I'll make sure that we get them back from the amendments office and send them to you.
Thank you so much.
Okay, next question. Next question goes to Delegate Marvin Holmes.
Thank you, Mr. Chair. Good to see you, Tony. I'm Delegate Bridges. Good to see you.
You too.
Yeah, I do recall you and I having large discussions about this last year. And I'd like for you or someone, even perhaps someone from Sotheby's, can explain how the nuts and bolts works. I'm kind of like Kimberly. I've been in business for 30 years too. And you're having the contract being signed by client A. And now you're having the lender documents being signed with the person's actual name. And the way I'm reading the bill, when you're having the client sign the buyer's contract with the broker as client A, that somehow is supposed to translate to the title company, everyone else, as the actual person. And I just don't know how that works. And that's why I'm asking the question, Delegate Bridges.
Yeah, if I can let maybe Kimberly talk about that. I know that we took out the client A and client B portion in the amended bill, which again, you probably do not have in front of you. And so, Kim, if you can explain that a little bit for us.
Thank you. I'm sorry that the House, the representatives don't have a copy of the bill as amended. We did amend the bill. There was a confusion about whether the bill would apply to all buyers. And practically, we, after meeting with Maryland Realtors from the prior session, we submitted modifications to the bill so that the buyer's name, the field on the page of the contract of sale would be removed. The buyer would still sign a contract of sale. The offer to purchase would be fully signed by the buyer. The buyer's name would just not appear on that document. And so the seller would be focused on the price, the term. Once the contract was agreed and it's ratified, we provided an amendment that the buyer's name will be added to the contract of sale directly under the date of contract acceptance. So we effectively are looking to remove the buyer's name from the purchase documents, and the buyer's name will be provided. The amended provision says within 24 hours of ratification, the buyer's name gets inserted onto the page 10 of the contract under the date of acceptance. And that gives the lender the transparency the lender's looking for. Of course, it doesn't impact the recordation of the deed. So practically speaking, a buyer would be meeting with their realtor, executing a buyer agency agreement, signing and hiring that agent, or signing a document to their identity, and then making an offer to purchase, signing the offer to purchase either in hand or electronically. And once that contract is accepted, their name would be added to the contract of sale within 24 hours.
So if I may, Mr. Chair, the way it sounds is that the initial offer would not have the buyer's name on it, but then documents would have to be substituted after the agreement, after the purchase price is agreed upon, to add the real buyer's name to it. Is that what I'm understanding? Something like that?
We just added to page 10 under date of acceptance. So date of contract acceptance might be tomorrow, and then the buyer's name would be inserted at that time.
Okay. Thanks, Tony. I'm Delegate Bridges. Thanks a lot.
Okay, next question goes to Delegate Stewart.
Thank you, Mr. Chairman. Delegate Bridges, great to see you back in the committee as always. So I think I asked this exact same question last year. I think you may have already mentioned it. But I think it maybe is one of the amendments you mentioned, but I just want to clarify that one of the amendments basically makes this client A, client B language only available to individuals rather than corporate entities. Is that right?
Yes.
Okay.
Right. This is not about those corporate entities or
Yeah.
you know, that was a big one from last year that we decided this should be all about the home buyers.
Yeah.
Right.
Yeah.
This is
Awesome.
not about those corporate entities.
Great. Well, I agree with that. And I love the intent behind this, and hoping we can get this through this year. Thank you.
Next question goes to Delegate Healy.
Hey, I'm a little confused because we don't have the amendments. So please, Delegate Bridges, I'm glad to see you. And I try to just get my head around what's being proposed here. And the last round of questions helped me a lot, but I still have a couple questions. One is about how you verify that the person has the money to buy the property. I mean, that they have sufficient funds or have a loan or have whatever, financing that they need when you don't know who they are, or somebody must know who they are, right?
Right. Well, if you don't mind, I'll let Kim answer that.
Oh, sure.
You're right. Yes.
Thank you, Delegate Healy. It's a great question. The bill would not impact the relationship between the buyer and the buyer's chosen lender. And it would not impact what practically is provided by the buyer's realtor in terms of some kind of support for their financial capacity. That would remain. We would have some support for financial capacity for the buyer from the buyer's lender. That's an important part of the criteria for a seller to make sure that they're working with a qualified buyer. So that would not change. What would change would be revealing the name of that buyer to the seller. And we would propose that the communication of that information is to the seller's realtor or in a mechanism that doesn't include specifically the name of that individual, but gives the ability for that to be verified. We think that's important too.
Okay, and the last question I have is along this idea of corporate, because some people do create LLCs to protect them for business reasons, even though they're individuals or they're just, brother, sister, family members that are buying a house. And would they be kept from the protection of this?
One of the amendments specifically states that the bill is for a primary residence for residential real estate, and it excludes entity purchases, commercial purchases, purchases for investment. And so the intent of the bill is directly and specifically for a home buyer who intends to occupy as a primary residence. If that home buyer creates an LLC, it would not apply to that home buyer.
Okay, and what happens if I happen to live in the suburb, near the University of Maryland. There are a lot of people buy single family homes and rent them out to college students. Happens all the time. So, and they may buy them, they may live in them first and then turn it over, or they may not. They may just change their mind after the consummation of the deal. So, what kind of protections are you that you're not really dealing with investors?
Well, that's an interesting question because intent, we can't always know the intent of the buyer. So I think what we've tried to do by amendment is to address the most obvious of those, and those being those purchasing for investment, those purchasing with an LLC or commercial purchases. 5-unit purchases wouldn't qualify. And so I think while we can't know the intention of every purchaser, I think we've done what we can, and we'd certainly be interested to hear how else we might be able to draft the bill by amendment to create those further protections.
Thank you very much.
Thank you.
Next question goes to Delegate Silaberte. Barry, you need to unmute yourself. There we go.
All right, thank you, Mr. Chairman. I like to believe that I'm on the train to Realville. And it's kind of ironic because last night I was looking at the names of 2 people who just purchased a property of mine in North Carolina. The ink was just basically still wet. And quite frankly, Mr. Chairman, I don't care if they were Chi-Chi and Chon. The bottom line is, did they have the assets to buy the property? Were they supported by a credit report, et cetera? Names are totally, absolutely irrelevant. And I, as I say, I'm approaching this from a little different perspective. I've sold a number of properties. I don't care what the names are. Do you have the credit report? Do you have the down payment? Can you substantiate it for the bank?
Well, that is dangerously close to debate rather than question asking, but I'll accept it
Isn't
anyway.
that a fact?
Apparently, in your instance, it is a fact.
Thank you, sir.
Okay. Delegate Clark.
Thank you, Mr. Chairman. Delegate Bridges, good to see you again.
See you as well.
Just a couple quick questions for you. One, I believe.
I think you muted yourself
Somebody did. Yeah.
I apologize. That was a misclick by me. I apologize for that.
Okay, go ahead, Delegate.
Did I hear earlier this only applies to primary residential property? It wouldn't apply to second homes, maybe resort homes. And that wouldn't necessarily be an investment or a commercial endeavor, but just as a secondary home, say on the Eastern Shore, that you were going to spend part of the time at and part of the time at your other home.
What is the intent is really for a residential property. And so even if it is your second home, well, the intent is really for your residential property, the home that you plan to purchase and live in.
Well, couldn't you make the argument you're going to live in either one from different times of time? And there's a lot of cases that I know a lot of real estate agents have 2-3 houses around.
I know a lot of elected officials who that was the case for.
And I will tell you that I do, and I'll tell you why I do like the idea of not having to put the name on the contract, because couldn't you say that if the people know you, that they might not be as inclined to take your first offer if they know who you are.
Especially if your name is Delegate Tony Bridges.
Yeah, well, yeah, they want to come back and hit you up for a little bit more money, and they feel that maybe you'll cough it up too. So there are advantages both ways.
All right, let's move on to DFH. Dave, you're next.
Thank you, thank you, Mr. Chair. My question is to the sponsor of the bill, Delegate Bridges. You heard Delegate Ciliberti talking a little bit about his position. Is that not the goal? Isn't that not the audible place that we'd like to be?
That is definitely.
We want to all be as evolved as Delegate Ciliberti.
Yeah, it's all about zeros and ones, right? So, but I guess the point of your bill is that's unfortunately, that's just not where we are quite yet. Is that correct?
No, yes, that is absolutely correct.
Right.
We are not in a place where that is universally the accepted rule.
Delegate Ciliberti is just so far beyond us. Thank you.
Thank you.
Okay, and on that uplifting note, we will conclude the public hearing on House Bill 762 with the earnest hope that we shall all be as evolved as Delegate Ciliberti in the near future. And with that, okay, so I understand Delegate Williams, who was next, is unavailable because she's testifying in some other committee. So we're going to go to House Bill 927 and 928 offered by Delegate Polakovich-Carr. A woman who has to put up with incompetent district mates, which it's a shame, really. Julie, are you there?
I'm here. Thank you, Mr. Chair. And there's no putting up with me. I'd say it goes the other way. Well, good afternoon, colleagues. For the record, I'm Delegate Julie Polakovich-Carr, here to present House Bill 927. This legislation aims to increase the amount of affordable housing in Maryland by donating or selling excess state-owned properties for reuse as affordable housing. Maryland currently lacks 85,000 affordable housing units, with an additional 97,000 units needed within a decade. Every region of our state has affordable housing needs, and solving our affordable housing crisis will take a multi-pronged approach. Among the policy solutions outlined in a 2021 report commissioned by the Department of Housing and Community Development was promoting affordable housing on state-owned land. Land is often a substantial part of the cost of developing affordable housing. By providing land for free or at a discount, the state can reduce the overall cost of building housing, thereby helping to keep future rents or mortgage payments lower. The state of Maryland owns more than 14,000 pieces of real property and disposed of 32 excess properties last year. This bill would require the Department of Housing and Community Development to look at each state-owned property that is identified as excess and determine if the property is suitable as affordable housing. Under the bill, buildings or land could be considered suitable for affordable housing if they are located in a priority funding area, are not located in a park or sensitive natural habitat, are of sufficient size, and have access to utilities and suitable ingress and egress. Any properties that are deemed suitable for affordable housing could then be donated or sold to a nonprofit or for-profit developer for use as affordable housing. If an affordable housing buyer is not identified, the real estate would be sold at auction and the proceeds would be sold to the Rental Housing Fund, which supports the creation and rehabilitation of affordable housing. Notably, this bill maintains local control over zoning and the development review process for any proposed affordable housing development. At least 4 other states, plus the District of Columbia, have enacted similar efforts to create more affordable housing in their jurisdictions. Finally, I will be offering a sponsor amendment to correct a drafting error. The amendment will make clear that local governments maintain their existing priority for purchase of state excess properties, and that the disposition process proposed in this bill would only occur if there were no government uses identified for the property. The amendment will allow nonprofits to buy land, not just receive a donation of land, and will conform the definition of affordable housing to our state's LIHTC program eligibility. In sum, every Marylander deserves the opportunity to live in housing they can afford. HB 927 would help us make progress towards this goal by creating more affordable housing in the state. Thank you.
Okay, well, it appears that nobody's opposed to the bill, so I'm going to go through all the proponents of the bill and then we'll entertain questions. So next, we have Tom Cole with YIMBY, Maryland. Tom.
Thank you very much, Chairman Barbay. Tom Cole on behalf of YIMBY, Maryland. Maryland has a housing crisis, and in order to solve it, the state is going to have to participate in it. In addition to all of the stats cited by the sponsor, the committee should also know that 3 out of 4 low-income families do not have a subsidized unit to live in. And this is only going to get worse. As was just cited, over 97,000 low-income families are projected to be coming to Maryland in addition to the 85,000 unit deficit that we have, and that's over the next 10 years. So what we need is innovation. We cannot just rely on low-income housing tax credits. We cannot just rely on inclusive zoning regulations. We also need to allow innovation in the market. And one of the ways that we can do that is to take out the high land costs. SSTAT just recently released its tranche of assessments, and land costs have increased 12.7% for residential properties over the last 3 years. And that's already an inaccessible market that's just getting worse. And I want to just cite one innovator for this when you're thinking about this bill. The name of the company is called Vessel. They don't have any projects in Maryland yet, but what they do is they land lease or they buy for $1 state or locally owned land, bring prefabricated multifamily housing that is all LEED Platinum Plus. And then what they do is they take the equity that they would otherwise get from it and they pass it on to the residents. This is how we build wealth for our low-income families and affordable housing. And they do this without low-income housing tax credits, which means they can normally provide more units than what those other projects can normally provide. So when you're thinking of House Bill 927, think of innovation, because we aren't going to solve the housing crisis using the tools we have right now. We need new tools like this bill. Thank you.
Wow. Okay. Thank you very much. Let's proceed to Miranda Williams with the Maryland Affordable Housing Coalition. Miranda, welcome to the committee. You have 2 minutes.
Hi, good afternoon, Chairman Barvey and members of the committee. My name is Miranda Darden, and I'm the Executive Director of the Maryland Affordable Housing Coalition. MAKE is an association for affordable housing developers working in Maryland who primarily use the Low-Income Housing Tax Credit Program. I'm here today in support of House Bill 927. I know you all agree that Maryland has a shortage of affordable housing, so I'm not going to spend much time discussing the needs in our state, the 8th most expensive state for housing in the country. There are very few parcels of undeveloped land left for sale that are zoned and suitable for multifamily housing. So my developers have to get very creative to find properties they can build on. For example, the former Wiley H. Bates High School in Annapolis was redeveloped by Anne Arundel County into a multi-use facility and includes 71 units of senior housing. In Montgomery County, a developer built 149 affordable apartments above the Silver Spring Library. And in Arlington, a developer worked with a church who wanted to help with their affordable housing crisis, and they built affordable housing on top of their church building. These are all examples of local governments and mission-driven organizations working creatively to build more affordable housing. And this bill would be a creative approach the state could take to finding a solution to our lack of affordable housing. If there is state-owned land that could be used to build this housing, this bill would set up a process for identifying those properties and making them available to developers. We think this is a great idea. While we always need more funding to make these projects work financially, finding affordable land would be another great way the state could help provide some solutions. Thank you very much to Delegate Polakovich-Carr for her creative bill, and we encourage a favorable report.
Thank you very much. Next, let's turn to Marianne Dillon with the Housing Initiative Partnership. Marianne, welcome to the committee. You have 2 minutes.
Thank you so much, and good afternoon, Chairman Barvey and Vice Chair Stein and members of the Environmental and Transportation Committee. I am Marianne Dillon. I'm the co-chair of the Legislative Committee of the Maryland Affordable Housing Coalition, and I'm also Executive Director of Housing Initiative Partnership, a nonprofit housing developer and counseling agency that serves both Montgomery and Prince George's County. I'm here in support of House Bill 927. Without a doubt, the hardest part of developing affordable housing is getting site control, actually acquiring a parcel of land suitable for affordable housing. We're competing with private developers who can move quickly and pay all cash, often at premium values, to acquire vacant land for development. At the same time, we're now experiencing unprecedented increases in development costs, especially construction due to supply chains disruptions and overall inflation. Further, interest rates are rising and the pricing for low-income housing tax credits is dropping, all creating further strains on our slim development budgets. Requiring state departments to identify and offer suitable surplus properties for donation or sale to affordable housing developers is an important first step in creating more opportunities for affordable housing development. I urge the committee to recommend approval of House Bill 927, and thank you for your consideration.
Thank you very much. And let's go to Claudia Wilson Randall, who is also in favor of the bill. Claudia, welcome back. 2 minutes. Claudia?
She is not here at the moment.
Well, okay then. I think I can deal with the heartbreak. All right. Well, in that case, let's go to the questions. First goes to Delegate Healy.
There we go. Hello. Welcome to the committee and thank you for this bill, Delegate. I just wanted to ask a couple of questions. They're kind of like two sides of the coin. One is, how do you keep this from creating concentrations of poverty? If you have, you turn over a big piece of land and then it gets developed for low-income housing, how do you stop that from becoming a concentration of poverty, which is one of the things that creates more social problems? That's the first question.
Thank you, Delegate, for the question. I'll say this bill envisions that there will be many different sizes of affordable housing that can be developed. In some cases, there are state properties that are very small and would only be suitable for, say, a single family house. In other cases, it could be a larger piece of property that would be affordable for, say, an apartment building with dozens or more units. So I think it depends a little bit on the piece of property. I would agree in general that I think that mixed income housing is the ideal goal. The legislation right now does not speak to that, just because I anticipate that there will be relatively few pieces of property that will be available in any given year. And as we've heard from testimony from others, that there will be a lot of competition potentially and interest in those properties. But I'm certainly happy to continue to talk to you, and if that's something that you're interested in, a direction you're interested in going.
Okay, thank you. And the other side of the coin is about how do you keep it affordable? I mean, somebody buys, this is built with nonprofits, but somebody buys it to live in it, and then they want to turn around and sell it at the market price, which gives them a big killing, basically, because of the premium value of real estate now.
Yeah, it's unfortunately we don't have anyone from Habitat for Humanity who's testifying today, although they do have some written testimony in support of the bill. I believe with organizations like that, they do include like restrictive covenants in terms of the for sale model. So if they are selling, there is a time frame associated with how long the owner needs to stay in the property, else it has to be resold for another.
Yeah, I'm aware. With the tax credits, there are long-term controls over it because but this is a different model. So I just want to see how you think that can be controlled as well.
Yeah, I'll say in the case of rental housing, my anticipation would be that developers that would be participating, say, through this process would also be taking advantage of the state's LIHTC bonds, which do have those restrictive covenants in terms of timeframes for how long the property has to stay affordable.
Thank you so much.
Yeah, I don't know if it's appropriate for me to butt in as a recipient, but HIP also develops for sale housing, and we always have restrictive covenants that generally go on for at least 15 years. And you're using public subsidies to go and develop the for sale housing, and those all come with restrictive covenants as well.
Thank you very much.
You're not butting in. The questions are for all the people who've testified.
Okay. And I particularly, HIP is one of the groups that's in my district and I have a long history with, so I'm very happy to hear from you.
Okay, next question goes to Delegate Sheila Ruth.
Thank you, Mr. Chair, and thank you, Delegate Polakovich-Carr. So affordable housing is obviously really important, but green spaces as well. And I just wondered if there's any requirement that if there's green space, and I know you said parks are protected, but sometimes green space is not a park, but maybe it should be. Is there any requirement that the state look at the conservation value of land before they authorize it for affordable housing?
Yes, if you look at page 3 of the bill, lines 4 and 5 has kind of an obscure reference to another part of state code, but actually that part of state code lists a number of green space type areas that would be protected and therefore would not be suitable for affordable housing. So that includes parkland, sensitive habitats like wetlands, et cetera. And it's actually a fairly long list of types of environments that are already have protections in terms of the surplus disposition process within the state and are mirrored in this bill.
Great, thank you.
Okay, next question goes to Delegate Boyce.
Thank you so much, Mr. Chair. And I want to go off of Delegate Ruth's question just a little bit. I think the question was more about, like in a case in Baltimore City, land was leased by a group who started urban farming. 2 years later, now the city is saying, hey, we want the property to build affordable housing. And so now it's a bit of a fight because they've made very large establishments of a very big and robust farm where they were, not only growing produce, but being able to give away and sell produce. Now they are going to have to move. So I think that's something that may be a concern. That's the only thing I wanted to put out there about that. I wanted if Mr. Where is he? Mr. Cole, I believe.
Yes.
To talk a little bit more about the vessel group that you mentioned.
Yeah, I'd love to hear about that too.
Yeah, sure. They do not yet have any projects in Maryland. They're based out of New Jersey. But I emphasized in my testimony innovation because that's what you're doing if you allow land costs to be taken out of the equation. And to answer some other questions, those covenants, the legislation, the section that is being amended by this legislation already provides that covenants are put on for certain preservation properties. You could absolutely, the state could negotiate covenants for affordability, and Vessel does this when it negotiates with local governments. It primarily works with local governments to find these parcels as small as 1 acre. Because they have prefabricated multifamily housing, their supply costs are also kept low. So they approach affordability. Affordability customarily is approached with subsidy, which makes sense, but we need to do it in as many ways as we can. And they approach it more in terms of taking the land costs out and then keeping the material costs as low as possible.
So remove land costs and materials, and which is why it's prefab.
Correct.
Okay. Okay. And where is this done? You said they're out of New Jersey, but where else have they?
So they have projects in New Jersey and Connecticut, and I'd be happy to actually follow up with you, and I can send you more of their information. They're not a client. I'm not testifying on their behalf.
No, I'm just saying you mentioned it. It was interesting. Yeah. I wanted to hear more about the concept and how they do what they do, but also thinking about questions like Delegate Healy's question about sometimes affordable housing ends up becoming something where it's low quality or less quality versus saying that we need affordable housing because costs to live and expenses are high, and it's leaving behind people who otherwise are not making enough to meet the market rate housing. And so that they deserve good housing and quality housing. So I'm always just talking about the balance between the two. And then my last question, Mr. Chair, if you don't mind.
Go for it.
Delegate Polakovich-Carr, you mentioned very specific numbers earlier about the number of properties or the number of units potentially needed. That's been a big question all day today about numbers and exact numbers. And I'm just curious about where you received your number from. I think you said 84,000, almost like, I think you almost approximately quoted it. And then you said 87,000 of something else.
Yes, I think it's 85,000 and then 97,000 over the next decade. Those came from a report that DHCD had commissioned that came out in, I think, December of 2020. And I'm happy to share a link to that report with you. But that was their analysis of the current situation.
And that was analysis of what is needed, not necessarily, I think, to the point we heard earlier, what properties could be available to meet this need.
That's right. That's how many housing units are needed.
Thank you.
Next question goes to Delegate Wyville.
Thank you, Mr. Chairman. Delegate Healy touched upon my question a little bit, but I was kind of curious. So if a property is labeled as excess sold to a nonprofit, what's to keep that nonprofit from just flipping that and making money and using it for something else? So I know you talked about restrictive covenants, but does this bill actually place restricted covenants on the sale so you're assured that it's used for affordable housing?
Thank you. Great question. The bill does not specifically say that. I'd be happy to include that in my sponsor amendment if that's a concern from the committee.
All right. Thank you.
Okay. Delegate Lehman.
Thank you, Mr. Chairman, and thank you, Delegate Polakovich-Carr, for bringing this bill. I think it's an excellent idea. Also, point of privilege, personal privilege, Mr. Chair, I want to say hello to Marianne Dillon. It's wonderful to see her looking well. She does great work. She and her group do great work in Prince George's. So Delegate Polakovich-Carr, could you say a little bit about the normal process of the state right now surplusing property? And so does it right now under the law have to offer first to county and local governments property before it, before whatever it is, a building or land gets offered to the whole wide world? And then if that's the case, would the bill be creating a process sort of inside of that current system, if that's the system where the focus is, only where the buyer is committed to doing affordable housing, if that makes sense?
Yeah, happy to talk a little bit about what the current excess disposition process is. So right now, state agencies are under a standing order to look for excess real estate, basically. And then those get flagged to the Department of Planning, which then goes through a due diligence process to see, one, if there's any other state agencies that want to reuse the property, and then also to see if there's any local governments that want to reuse the property. And I believe local governments have a certain amount of time in which they need to respond by. This bill would then add a step after that's already happened. So assuming that there's no governmental use that's identified, because those would still maintain their priority, and then look at, okay, could the land be used for affordable housing? If yes, then we're going to try to dispose of the land for affordable housing. And if no buyer or suitable use comes forward there, it would get auctioned and the money would be dedicated for other affordable housing projects. If the land is not suitable for affordable housing under this bill, and in fact, the last step under the current law, the current disposition process is that the land is competitively sold. Ultimately, the sale does have to get approved by the Board of Public Works. That remains the same under this bill as well. So it actually is a fairly lengthy process. There's a lot of agencies and steps involved in terms of getting to that final point of sale.
Or I'm sorry. In other words, it doesn't like sort of interrupt the existing structure. It fits, into it, but under, the third or fourth step down of what exists now.
Yes, I'd say that's a good way to describe it. It adds a new step in that existing process.
Okay, great. Thank you. Thank you, Mr. Chairman.
Okay, yes, absolutely. Delegate Terraza has the next question.
Thank you, Mr. Chairman. So a couple of things. First of all, thank you to Delegate Polakovich-Carr for bringing this. I think affordable housing is so important, and looking at these state properties is, I think, certainly a great idea. And I know we've talked a bit offline about this. One of the quick question, I heard you say something about LIHTCs or LIHTC properties. Did you say that you have an amendment to restrict this to LIHTC or to things that were affordable to the same price range? What did you say about LIHTC properties?
Yes, and sorry for being brief there in my oral testimony on that. My sponsor amendment is going to address the definition of what affordable housing means on page 2 of the bill. Basically, right now we define it for both rental and for homeownership properties. The sponsor amendment is going to adjust the definition as it relates to rental properties so that it just corresponds better with how our state's LIHTC program works, because there is a wider range of incomes that are eligible under the LIHTC program than what we've accommodated in the bill as introduced.
But LIHTC is actually usually you have low and moderate income, and LIHTC is usually low income. So that confuses me a little bit.
Yeah, and I'm happy to defer to one of the other housing folks. Maybe Miranda has a better answer in terms of who's eligible under the LIHTC funding now.
Yeah, so we had talked about removing the 30% of income as rent, because that's the piece that does not correspond to the LIHTC program. LIHTC does only serve households at 60% of the median income and below, but the rent is a set number that the federal government sets, and it's not based on a percentage of your exact income.
Okay, so you're not talking about restricting this to LIHTC tax credits. Okay. So my next question is there a map somewhere? Do any of the advocates have a map of these state properties, where they're located? Have any particular projects or ideas of where these properties are located? Can you name any?
I'll say in the absence of the advocates having anything to weigh in there, unfortunately, does not appear to be a map. Department of Planning is responsible for keeping this centralized list of what all the properties are, but they have not mapped that. There is a list that is publicly available that folks can look at, and I'm happy to share with people.
So, and Mr. Cole, it's good to see you. Good to see you, Howard County. And do you know where they are in Howard County? Because my experience is that state properties tend to be in industrial areas. Do you know where they are in Howard County?
No, I don't. And part of the reason why I think this is so important is because it does let people that are better equipped than myself to evaluate these properties, evaluate where they're located. And I think the way the sponsor has written this bill, there are certain criteria in terms of deciding whether or not this property would be suitable for housing. And it's not just any old housing. I mean, you know, we know there is property next to the Jessup Correction Facility that is state property, but it likely would not be suitable under the criteria set forth in the legislation.
So would anything in this legislation prevent, so one of my concerns is similar to Delegate Healy's, but it also includes putting this, one of the things I worry is that we're going to concentrate affordable housing and that we're going to put it away from other housing in industrial areas. Because my experience with state property that we had in Howard County is all the state property I knew about that was being disposed of was all in industrial areas. So I'm wondering if there's something in this legislation or that we could add to this legislation that would prevent us from doing that.
Well, you know what? I think this is very close to subcommittee work, subject matter. So why don't, forgive me for interrupting you here. I'd like to, unless you have a different question, let's go on.
I do have, can I ask one more question?
Yeah, sure. Go ahead.
So is your anticipation that these would be 100% affordable housing, or that they would be mixed income? And is there some, I guess, is that in the legislation, or what's your anticipation with that?
The bill as drafted would be all affordable housing, 100% affordable housing on the property.
Okay. Okay, thank you.
Okay, and let's go to Delegate Marlon Ampry, and I think that'll be the last question for this bill, and then we'll go on to Julie's next bill.
Thank you so much, Mr. Chair, and I'm really thankful for thank you for bringing this this bill forward. I really care about getting more housing opportunities across our state. We know we're in dire need. And Mr. Cole, don't be stingy on that information. I would love to also, when you copy me, when you send that over to my colleague Regina, I would appreciate that information. But my question is more so, one of the issues that we have was discussed earlier with the chairman's bill. Is when we want to put in more affordable or mixed use housing in certain neighborhoods and communities that are advocates for such, they don't want it in their backyard though. So my question is more so, how will this bill address the location of these lands if they are in places where they're locally zoned, where it can't be that there is a affordable housing or whatever you want to put, whether it's a mixed use affordable housing situation. How does this bill address that? Sorry, I haven't had a chance to look at the bill, but how would this bill address that issue? Because I can see that being an issue, especially if people want to start, to avoid, if this goes into place to avoid, they want to start even just zoning around these lands now to prevent affordable housing being put where a current state land is. So I just want to hear your thoughts on that.
Yeah, thank you for raising that. I'll say I served in local government before I was in the legislature, and share some of your concerns about that if a jurisdiction really wanted to prevent affordable housing from coming, that they could try to take efforts in advance. The legislation doesn't exceed or bypass whatever the local zoning and master plans are. So any affordable housing project that did manage to secure land from the state would still have to go through the normal development review process and be subject to the local zoning in the jurisdiction. We don't change anything into that effect.
Thank you so much.
Okay, it appears there are no further questions for, so that ends the public hearing on House Bill 927. Let's move then to Delegate Plavkovich-Carr's House Bill 928. Julie, you've got 4 minutes.
Thank you, Mr. Chair. House Bill 928 would protect Marylanders from discrimination in housing based on their immigration or citizenship status. Maryland is an incredibly diverse state, home to more than 915,000 immigrants. Notably, more than half of immigrants in Maryland are naturalized citizens. Yet we do not have specific safeguards in state law to protect immigrants from discrimination in regards to housing. Unfortunately, there are egregious examples of Marylanders facing discrimination and harassment by their landlord because of their actual or perceived immigration status. Tenants have been threatened by their landlord that if they didn't pay their rent, or if the tenant reported unsafe housing conditions, that the landlord would report the tenant to ICE or law enforcement. And it's not just undocumented immigrants who face this type of harassment. Immigrants with legal status and even US citizens face this harassment. This legislation would bar landlords from screening prospective tenants based on their immigration or citizenship status, and would prohibit landlords from disclosing or threatening to disclose a tenant's citizenship or immigration status. The bill also provides tenants who face discrimination legal recourse through the Maryland Commission for Civil Rights. 4 other states have enacted similar protections. Additionally, the legislation makes immigration status and citizenship status protected classes in our state's housing anti-discrimination laws. Maryland law currently prohibits housing discrimination because of race, color, religion, sex, familial status, national origin, marital status, sexual orientation, gender identity, disability, or source of income. In some cases, national origin as a protected class protects against discrimination on the basis of immigration or citizenship status. For instance, guidance from the U.S. Department of Housing and Urban Development states that, quote, people cannot be denied housing opportunities because they or their family are from another country, because they have a name or accent associated with a national origin group, because they participate in certain customs associated with a national origin group, or because they are married to or associate with people of a certain national origin group, end quote. However, the boundaries of national origin protections have been the subject of debate in the courts, especially whether the perception or misperception of a person's national origin or immigration status is protected under current law. To that end, you'll hear today from the Maryland Commission for Civil Rights, which has had discrimination cases that fall into this legal gray zone. This uncertainty has led some jurisdictions, including Prince George's County and the city of Annapolis, to update their anti-discrimination laws to add immigration status and citizenship status as protected classes. Lastly, I've requested a sponsor amendment, which addresses the concerns raised by MMHA and the Commission for Civil Rights in their testimonies. The amendment makes clear that a landlord can respond to an inquiry from a law enforcement agency during the course of a criminal investigation, and also defines the terms immigration status, citizenship status, and national origin. Thank you.
Okay, let's go to the first witness in favor, Gabriella Dixon-Larata with the Public Justice Center. Are you new to our committee? Welcome.
Thank you, Chairman. Yes, I'm here on behalf of the Public Justice Center. And thank you. Good afternoon to the Environment and Transportation Committee. My name is Gabriela Dixon-Larata. I'm a paralegal on the Human Right to Housing team at the Public Justice Center. Nearly every day, I speak with renters who are harassed by their landlords, usually because they are behind on rent or have asked the landlord to make basic repairs. For immigrants, the harassment often comes with an added layer of racism and xenophobia. This includes the use of racial slurs or threats of deportation, even when the landlord has no information on the tenant's immigration status. The Latina community of Maryland has been one of the hardest hit by the pandemic. Thousands of families suffered substantial loss of income and have not yet recovered. Many more have lost family members, as Latinas are almost twice as likely to die of COVID as white people. Many landlords are aware of how much their immigrant renters are struggling. They take advantage of the fact that this community has limited access to resources and support that would enable them to assert legal rights and demand habitable housing. They exploit this inequity and wage harassment campaigns that are so disruptive to the renter's life that it forces them out of their home, saving the landlord from having to evict them through the courts. Imagine someone with the key to your home pounding on your front door every day, hurling slurs, yelling for all your neighbors to hear, threatening you and your children with physical violence. This same person forces you to live alongside rats and cockroaches without heat in the winter, or with a basement so infested with mold that you and your family develop respiratory infections. When asked to remediate the housing defects, they make fun of you for not speaking English and tell you that if you're so unhappy, then you should just get out. You live in constant fear of a legal eviction, which would force you to uproot your family and disrupt your child's education. My clients don't have to imagine these scenarios. I have heard from countless tenants who just want their landlord to be held accountable for racist abuse and predatory business practices. HB 928 would achieve that. PJC urges the committee's favorable report on HB 928 because it addresses ever-present discrimination and retaliation against immigrant renters. Thank you.
Thank you. Let's go next to Ashanti Martinez. Ashanti?
Good afternoon. Yes.
Okay.
Good afternoon, Committee Chair Barve and committee members. I'm Ashanti Martinez on behalf of CASA. CASA is here to register testimony in support of HB 928, which updates the state's housing discrimination policy, bringing protections one step closer towards housing justice and strengthening the rights of Maryland's immigrant community. CASA is the region's largest immigrant rights organization, serving over 120,000 Black and Brown immigrant and working class families. Over the last 30 years, CASA has worked with hundreds of thousands of Marylanders on renters' rights and housing issues through organizing, advocacy, and legal services. Our mission is to create a more just society by building power and improving the quality of life in working class and immigrant communities. Establishing explicit protections for citizenship, immigration status, and national origin is essential for protecting immigrant renters and preventing exploitation of families who share varying immigration statuses. The COVID-19 pandemic has illustrated the ongoing housing crisis that tenants face and now show how critical secure housing is in the health determinants and life outcomes of our residents. The passage of HB 928 would align Maryland with several other states, including California, Colorado, Illinois, and Washington state, in protecting against discrimination and renting for Maryland's most marginalized residents. Welcoming communities are a hallmark of Maryland, and HB 928 ensures that we continue to live up to that promise. Another key provision of the bill would prohibit landlords, and others from weaponizing a resident's citizenship, immigration status, and national origin by barring any sharing of this information with federal immigration authorities. HB 928 is the right solution for updating our state's housing discrimination policy by deterring bad actors from discriminating against citizenship, immigration status, and natural origin. CASA strongly supports this bill and respectfully urges a favorable committee report. Thank you so much.
Thank you. We have two witnesses who are signed up favorable with amendments, Aaron Greenfield and Glendora Hughes. So let's go first to Aaron Greenfield and Glendora, and then after that, we'll entertain questions. So Aaron, you're up next, 2 minutes.
Thank you, Mr. Chairman, members of the committee. Aaron Greenfield on behalf of the Maryland Multi-Housing Association. You have our written testimony and we are favorable with amendment. We worked with the sponsor on an amendment to permit housing providers the ability to respond to an inquiry from a law enforcement authority during the course of a criminal investigation. We appreciate this friendly amendment. With that, respectfully request a favorable with amendment report. Thank you.
Very well then, we'll go to Glendora Hughes.
Good afternoon. Yes, good afternoon, Mr. Chair and Mr. Vice Chair and members of the committee. Glendora Hughes from the Maryland Commission on Civil Rights. We wholeheartedly support the House Bill 928 with the amendment. We work with the bill sponsor concerning the amendment. One of the things that we pointed out that in our statute, state government article Title 20 does not have a definition of national origin as it does of other protected classes. And that would be helpful in terms of providing clarity for all parties involved, as well as providing guidance and definitions to citizenship and immigration status. In terms of the commission and handling these types of cases, some of them fall in the crack that don't quite fit national origin. And you have persons who are US citizens or discriminated against because of the way they look, by their name difference, or that they are Latino, they're Asian, and they are treated differently simply because, and ask for proof of citizenship because of that perspective, or policies that are applied differently simply because of their surname, a person's surname, or a person's having English as a second language. This bill will cover those gaps and provide protection for citizens who would fall in those categories, and US citizens, people who are actually citizens, not having to deal with discrimination because of the perception that they are not citizens. And also the interconnection of assumptions that their immigration status as well is in question. So for those reasons, the Maryland Commission on Civil Rights wholeheartedly supports House Bill 928 with the amendments that we shared with the sponsor. Thank you.
Thank you. Do we have any questions? It appears not. And so that ends the people who are signed up in opposition are not testifying. So that ends the public hearing on House Bill 928. Let's go to House Bill 932. Delegate Stewart.
Thank you very much, Chairman Barve, Vice Chair Stein, Delegate Siliberti, and other illustrious members of the committee. Good afternoon. I'm Delegate Vaughn Stewart. This is House Bill 932. We have had a few controversial bills today, but I'm happy to report that this is not one of them. This bill would close a loophole to ensure the success of our rental assistance programs in the state. Currently in Maryland, as I'm sure a lot of y'all are aware, tenants have the right to so-called pay and stay, which means that if they can pay the rent owed that they owe after a writ of eviction has been issued, but before they're physically removed from their home, then they can stay there. Unfortunately, there has been a very small number of landlords who have argued in some of our counties that tenants cannot pay and stay if they pay the rent with rental assistance funds. So in other words, tenants are being approved by rental assistance programs before they're physically evicted, but landlords are refusing to accept the money. And their legal hook, this is their argument, a check from a county government is not listed as a quote unquote acceptable form of payment under state law. Current state law lists the acceptable forms of payment as, and I quote, cash, certified check, or money order. So this bill is very simple. It adds checks from county governments to that list to plug this loophole. I'm happy to report that there are no opponents to the bill. Some of the advocates that you'll hear from do have a proposed amendment, which clarifies that by accepting a county check at the sort of the last minute here at the 11th hour, that the landlord is not signing a contract with the county for the purposes of administering their rental assistance program. And I think I'm open to that. I believe that I'm on the same page, that we're all on the same page, really, that we just want a county check to be treated the same as if the check were from the tenant for the purpose of this pay and stay, this pay and stay right. That's it. I urge your favorite report on House Bill 932.
Before I go to the next witnesses who are signed up in favor of this bill, are there any other loopholes that need plugging? What about, I mean, because we before you were here, we passed that bill that was the Home Act, which basically ended discrimination based upon source of income. Is your bill broad enough?
Well, it's a good point, Mr. Chairman. Certainly, maybe throughout this hearing process, maybe we'll hear from some other folks who, I mean, cash certified check or mail order seems pretty broad, but I don't know. I mean, these days with cryptocurrency and whatnot, maybe you're right. Maybe I'm not thinking big enough here.
Well, I'm not a big believer in crypto.
I'm not either. I kind of refuse to have my name put on a crypto bill, actually.
Yeah, right.
But
no, I get that. Did you get an attorney general opinion before you?
Yeah, I'm happy to. We'll do a thorough review so we don't have to come back next year.
No, I'm asking if you had done this before doing the bill.
Oh, no, we don't have any attorney generals. Okay. You're saying whether or not it's legal for them to do this?
Yeah, I mean, it sounds to me like it shouldn't be legal right now, but I mean,
yeah, I would agree. I'm happy to try to get a last second AG opinion. I agree. I think that the law is really not on their side, but at the same time, I don't want to have to wait for litigation to play out.
Yeah, okay. Well, let's go to Joanna Miller of the Montgomery County Government. Joanna, you're welcome to the committee. You have 2 minutes.
Thank you so much, Mr. Chair and members of the committee. My name is Joanna Miller, and I am the project manager for Montgomery County's COVID rent relief program. I'm here representing Montgomery County government and to request your support for House Bill 932. This bill expands the allowable forms of payment that landlords are required to accept to include government payments. It is an incredibly helpless feeling for our team anytime we see anyone evicted, but especially so when that eviction happens because a landlord refuses to accept the check in a tenant's hand just because it was issued by the county. We have unfortunately seen this happen multiple times, and we need your help to close this loophole before more landlords can exploit it. Given the amount of funds currently flowing for eviction prevention, we need to ensure that those funds are honored and accepted as payment to redeem the property. Thank you for your consideration.
Yeah, thank you very much. Next up, Zephyr Shah. Zephyr, welcome back.
I believe Zephyr is absent at the moment.
Okay, well, that's, if you could pick one to be missing from, this is the one, I guess. Dominic Butchko, Mako.
Good afternoon, Mr. Chairman, members of the committee. Dominic from Mako. Mako urges a favorable report. I don't want to repeat what everyone else just said, so please vote favorably on this one. Thank you.
Okay, Andrew Rabinowitz with Legal Aid.
Thank you, Chairperson, members of the committee. And thank you for the opportunity to testify in support of House Bill 932. I believe this is a wonderful piece of legislation that is proposed to expand the form of payments landlords and mobile park home operators are required to take when offered by the tenant. I'm Andrew Rabinowitz. I'm the supervising housing attorney for Maryland Legal Aid, and I'm here testifying at the request of Delegate Stewart. The harm this bill seeks to address is a harm that's all too familiar to clients of Maryland Legal Aid. Tenants in these situations are facing imminent eviction because a judge has issued a judgment has been issued against them in a failure to pay rent action. This means a judge has already determined that the tenant owes the landlord money. The tenant will be evicted if they don't pay the landlord. However, if the tenant pays the landlord prior to the eviction, they can redeem the property, they can remain and keep their home. As stated prior, there is a huge loophole that we need to close here. In these cases, tenants are reaching out to branches of government-related entities, and they are being offered assistance. However, these situations when the tenant comes to the landlord with these government funds, as opposed to cash, the landlord has the opportunity to choose to reject these funds. And this exposes our clients to homelessness. If this bill is enacted into law, this harm will be eliminated as the landlords will have to accept these funds and they will prevent future homelessness. For these reasons, we ask for a favorable report on House Bill 932, and thank you for having me.
Okay, and the last witness is Aaron Greenfield, favorable with amendments. What's your amendment, Aaron?
So thank you, Mr. Chairman. Aaron Greenfield on behalf of MMHA, as you mentioned. Our interpretation of the bill is that housing providers' acceptance of such a check, presumably to accept rental assistance in this case, would not require the signing of a contract. So our amendment would point that out in page 2, line 5. You have our written testimony that speaks to that amendment. As I've mentioned before, housing providers have entered into current rental assistance contracts because they were able to negotiate the terms in good faith. We just have a concern that by accepting a check, any sort of coincidental or coinciding, I should say, requirement would dispose of those good faith discussions, particularly if they accept them down the road and their terms that we don't agree to in any form. I know that we spoke with the sponsor about this particular amendment and he's amenable to it. So for those reasons, we would respectfully request a favorable report with that amendment.
Yeah, it sounds like you can work it out. So there appear to be no questions. And there are no opponents. So that ends the public hearing on House Bill 932. The only bill remaining to us would be Delegate Williams' bill, House Bill 803. Delegate Williams, are you in the House?
I am in the House, Chairman Barve.
All right, you're up for 4 minutes.
Oh, wow.
Yeah, I know.
Okay,
what a
well,
luxuriant amount of time to deal with, huh?
Yes, I'm not used to this. So good afternoon, Chair Barve, Vice Chair Stein, and members of the House Environment and Transportation Committee. I am Delegate Nicole Williams here testifying in favor of House Bill 803, known as the Residential Property Foreclosure Filing and Adjudication of Counterclaims. This legislation would simply provide a homeowner who is facing foreclosure an opportunity to present any counterclaims or cross claims that they may have against the plaintiff. For most Marylanders, the purchase of their home is their greatest personal investment. And we saw during the pending COVID-19 pandemic that for some Marylanders, the ability to continue to pay their mortgage and to protect their greatest investment was in peril due to job loss or reduction in hours at work. While on the state level, we know that the Homeowner Assistance Funds is there to help struggling homeowners, the fund does not curtail the filing of foreclosure proceedings. And in fact, with the expiration of the Federal Consumer Financial Protection Bureau moratorium on foreclosure sales for federally backed mortgages that expired on December 31st, the number of foreclosure filings just in the month of January increased dramatically than what we had seen over the past several months. This bill is just simply an effort to acknowledge what we will see continuing to come down the road with the expected uptick in the number of foreclosure filings within the state. And what this bill does, it simply grants homeowners a right that any other defendant would have in any other civil proceeding in our court system, the option to file a counterclaim within 15 days after the post-filed mediation, also known as loss mitigation in the foreclosure process, if that loss mitigation proceeding is not successful. And so in doing so, proceedings can be evaluated in the same manner as it would under the current Maryland rules and adjudicated by the fact finder. This bill builds on previous foreclosure reforms that the General Assembly has enacted several years ago and will provide a homeowner with another opportunity that they might not initially exercise upon being served with the initial complaint. A lot of times a homeowner will agree to do loss mitigation, hoping in good faith to really try to come to an agreement with the lender, and they don't want to lose their homes. But if for some reason that's just not able to occur, they should be afforded the opportunity to bring forth any claims that they may have in the same case that is being heard before the court about the same property at hand. And this is going to be so true, especially for pro se litigants, which the majority of defendants and the majority of the foreclosure cases you see here in our state are pro se defendants, to be quite honest with you. And so by affording homeowners with this additional opportunity in the event of a foreclosure, we can ensure that home ownership is something that is sustainable for more Marylanders as we continue to work to emerge from this pandemic and even moving beyond the pandemic. And for these reasons, I urge this committee to give a favorable report to House Bill 803.
Well, I guess I saved the second most controversial bill for last, didn't I? So let's go through all the proponents of the bill, and there are 11 people signed up in opposition and 11 in favor, 13 in opposition. We're going to go through all the witnesses who are proponents. We'll go to questions for them, and then we'll go to the opponents to the bill. So we will start with, and let me also say, it is 5:20. I'm going to be especially Teutonic about enforcing the 2-minute testimony limit. So we'll go to William Steinwiedel with legal aid. William, welcome to the committee. You have exactly 2 minutes.
Hi, this is William Steinwiedel from the Maryland Legal Aid Bureau. I'm a staff attorney in the Foreclosure Legal Assistance Project. I thank Chairman Barr, the committee, and Delegate Williams for having us testify on this bill. Maryland Legal Aid supports House Bill 803. This House bill clarifies a confusion in the law and makes it clear that you can bring a counterclaim and a jury trial in a foreclosure case. This is very important because a lot of times first the servicer changes from one at the beginning of the case to later. So they may not have known, they may not have been able to file a notice of error or other complaint, and the foreclosure case may be the first opportunity that they can do that. Also, evidence may be discovered in the mediation that can be proceeded in litigation, but they may not have known before. And the only power the mediator has is they can continue at one time over the objection of the other side. So allowing a counterclaim would provide more ability to explore important issues in a foreclosure case. Also, sometimes it's rare, but there are times where a foreclosure was incorrectly filed. I did represent one client where it was incorrectly filed, and we discovered that. But for other reasons, we couldn't perform affirmative litigation, but maybe we could have pursued a counterclaim if that option had been available. So for those reasons, Maryland Legal Aid supports a positive report on House Bill 803. Thank you.
Mr. Chairman, you are muted.
Well, my mistake. Philip Robinson is next. Thank you for coming to the committee. You have exactly 2 minutes.
Good afternoon, Mr. Chair, Mr. Vice Chair, my good friend Dana Stein, I've known for more than 2 decades, and my hair has only grown grayer in the time we've known each other. I'm happy to be here. I'm an attorney in Maryland, in Silver Spring. I represent your constituents that Marianne Dillon and HIP tried to help, and you heard from her in a prior hearing, and they come to me. This bill, House Bill 803, is pretty narrow. Its only effort is to clarify and uniform and make fair and equal in every jurisdiction what the common law already says. The common law holds that a borrower may file a counterclaim in a foreclosure case. However, not every local jurisdiction honors the common law. And this effort has been attempted to be fixed in the Rules Committee. It's been attempted to be fixed by certiorari petitions to the Court of Appeals, and the courts haven't addressed it. And as you've heard with other issues this session, the judiciary is taking a hands-off approach. So what the bill is attempting to do here is very narrow. Simply put in the statute that you enacted 12, 14 years ago, a provision that permits a homeowner to file a counterclaim like in every other civil proceeding in Maryland. But different than the common law, the counterclaim has to be timely. The common law says, under the Christian case that's cited in the bill, that it can be filed untimely, and that may create problems. So as my good friend Mr. Enton said earlier, what we're attempting to do here is to create fair and equity. Fairness in that the same rules apply in Washington County, Montgomery County, and Prince George's County, because not every jurisdiction, and as you'll hear, not every jurisdiction permits counterclaims, but we don't really allow local rules. And this helps the lenders because they know the rules are the same across the state. This helps purchasers who are purchasing properties because they know the rules are the same across the state. And we're only asking in the bill that the counterclaims be permitted when they're timely. And we urge a favorable on House Bill 803.
Thank you very much. Let's turn to John. John Gable, who is representing CLSPGC, which please start out by telling us what that acronym stands for. And you have 2 minutes.
Thank you very much, Chairman Barv, Co-Chair Smith, and the rest of the committee. The acronym stands for Community Legal Services of Prince George's County, which is one of the primary pro bono legal service providers in Prince George's County, as well as neighboring counties. Prince George's County is in favor of this because, as previously stated, this is really just about fairness. Many of these counterclaims are, in fact, about the behaviors of lenders and go directly to misdeeds that they have done. And the only relationship between the lender or servicer and the homeowner is the mortgage, and this relationship is at the very heart of the foreclosure. It is absolutely the most related form of transaction you can think of. And yet some jurisdictions insist on separating these things, causing added expense to homeowners. And where these things are separated, homeowners are often left no choice in terms of protecting their home and getting their issues actually heard in a economically feasible manner than to go straight to the bankruptcy court, which is sort of, scorched earth approach, which really shouldn't have to happen. Our residents should be able to go to the courts of Maryland for justice, for access to justice. And at a time when our society and many people just question the impartiality of our institutions, its commitment to equitably serve all of our constituents, I can't think of anything more important for anybody to do than to do everything in their power to make sure that at least our justice systems are fair and allow the entire story to be heard. And with that, we urge that you all report favorably on Bill 803, and thank you very much for the opportunity and your time.
Thank you. Let's turn next to Elizabeth Johnson.
Thank you very much. Good afternoon, Chairman Barvey and committee members. My name is Liz Johnson, and I'm the housing chairperson for the Prince George's County branch of the NAACP and a homeowner in the county. First, let me say that the Prince George's County branch of the NAACP supports House Bill 803 and asks for a favorable report. House Bill 803 will allow homeowners a path to file a counterclaim to assert their defense to foreclosure. In Prince George's County, we have a special interest in the passing of this legislation because our county has been ravaged and decimated by foreclosures. As the housing chair, I have heard countless stories from homeowners who felt that there were many unfair occurrences in the foreclosure process, including the fact that the homeowner is rarely even heard by a judge. Many people have not gotten the opportunity to assert defenses such as predatory lending, reverse redlining, the failure of the bank to comply with the mediation requirements, unclean hands, and the inability of the financial institution to foreclose due to the lack of standing. Court records will show that we here in Prince George's County have lost over 75,000 homes since the great 2008 downcline. Many of these foreclosures can be traced to predatory loans, the loans that were rained down on the people of Prince George's County. Those foreclosures accent the loss of our generational wealth, and it points directly to the predatory loans such as no doc, adjustable rate, no income, no job, and it's led to a great deal of wealth extraction from our community. And as many of you know, the corporations are now moving in a mighty way across the country, acquiring homes for rental purposes. And once again, Prince George's County is in the bullseye. So give our citizens a fighting chance by reporting this legislation favorably out of the committee. Thank you very much.
Thank you. Wow, right at 2 minutes. Good.
I timed it.
Marceline White.
Well, great news. Marceline White and Isidore Stern will be very quick as they're absent.
Okay, how about Keisha Monroe? Is Keisha Monroe with us?
Yes.
Ah,
Chair
okay.
Marvin.
Welcome to the committee. You have 2 minutes.
Thank you. Members of the Environment and Transportation Committee. My name is Keisha Monroe, and I'm here in my personal capacity as a mother, sister, daughter, and homeowner in Maryland, urging your favorable report on HB 803. This bill is intended to help those homeowners who have legitimate defenses to foreclosure and opportunity to pursue legal claims against the mortgage actors who ignore their duties in the foreclosure action commenced against them. My family was involved in an action that involved this issue when my mother passed away. Because the practices are inconsistent from case to case and court to court, I underwent some fear, frustration, worry, and extreme amount of stress that could have been avoided. Because of this situation, there were several flaws revealed in the law. I discovered that even though the Maryland Court of Appeals long ago held that homeowners like me could pursue counterclaims in a foreclosure when they have just and legal claims, the state circuit courts have not followed that precedent. Some circuit courts do not permit homeowners such rights and opportunities as a matter of practice. For example, Montgomery County has established an administrative order identifying the procedures for a foreclosure case when a homeowner pursues counterclaims. But in other jurisdictions like Prince George's County, there seems to be an unwritten rule and a bias that permits homeowners with identical claims from obtaining the same remedy and rights. The law and the court procedures are supposed to be equal and fair to all, and not just to some in some parts of the state and not in others. HB 803 is a simple bill that ensures all homeowners have a limited right to pursue timely counterclaims in a foreclosure action under Maryland law. HB 803 is needed to permit homeowners the right to pursue claims in one action when they are being threatened with a wrongful foreclosure. It just isn't equitable. Mr. Enton is also a good friend who stated earlier that the rules and procedure should be fair and equitable no matter where you live. And I agree. Thank you for allowing me to be before you today, and I ask that you please vote favorably on HB 803.
So many people quoting the august Robert Enton. Okay, Adele Penny is the last proponent to testify, and then we will go to questions, entertain questions for all the proponents. Thank you. Adele Penny.
Good evening. Thank you, Chair, Committee, and Ms. Williams for bringing this Bill 803 to fruition. I'd like to thank you for allowing me the testimony to favor the bill HB 803. My personal experience with the contents of this bill is an official cry from your constituents, sisters and brothers, and our community. Support HB 803 and vote it out of committee. Its presence with enforcement should bring a decline of the theft of homes, real estate, and massive land grabs that impoverish our community. To my understanding, HB 03 with enforcement should ensure factual documentation that would give time to shed light on false documents. Documents that would that are hastily panned through by the con of white collar crime. It is impossible to ignore or to understand the massive travesty that puts and keeps our people and communities in decline. HB 803 is a step when enforced to halt the steal of our generational wealth and with the rights that belongs to us. Please support House Bill 803 as I do. Thank you.
Thank you. Let's go to questions for the proponents. The first question goes to Delegate Healy, followed by Delegate Stein.
All right. Thank you very much, Mr. Chairman. This bill, thank you, Delegate Williams, for this bill. And I wanted to ask Mr. Gable from Community Legal Services of Prince George's County a couple questions. How long have you been with that organization?
I started working with them part-time in 2013. At that time, their staff attorney who'd been doing foreclosures retired, and they were worried that the program would die. And well, I already had my own practice, so I started part-time with them so we could stretch the budget as the support for foreclosure programs was declining, so that we could keep additional staff members. And I came on full-time only with the onset of COVID.
Oh, okay. Thank you so much. You probably know my husband, who used to be the executive director, Neil Conway. Okay.
I do. I know Neil very well.
I wanted to ask you about this bill and what was said about Prince George's County courts not following the common law, whereas in Montgomery County they do. And I wanted to understand, is that your experience? We just heard testimony about that.
Let me explain sort of the crux of it. What's happening is a question of judicial discretion, okay? and that is Maryland Rule 14, which governs judicial sales and foreclosure. Okay, sets forth a set of procedures under Rule 14 to 11 for homeowners to address a foreclosure, to request a stay or dismissal of it. Okay, and the question is whether or not a valid defense to the foreclosure is being promulgated or put forth by the homeowner. Okay, so the question is, usually judges are thinking about this in terms of the debt that is owed, or whether or not the secured party is actually the secured party, right? And what's going on is, for example, I had a case where I had a homeowner whose house was broken into and burglarized by agents of his lender prior to sale, ostensibly to inspect the home prior to sale. This caused damage to the home, which of course would decrease the property value, in addition to the loss of almost all of his personal property. There was a police report, there were ample records that it had happened, and you know, the court was unwilling to deal with that as any sort of offset, any sort of credit, anything that had to do with the debt that could be owed. This is related at all, even though the only reason that that happened at all is because of this privity of contract from the mortgage between the secured party servicer and my client. So it's those kinds of things. It doesn't technically fit within Rule 14 to 11. Judges don't want to hear it. And that's kind of where we're at, but it's part of the whole picture. And I think clients need to be able to present the whole picture of what's going on, because there's more to a foreclosure case than the ledger.
Okay, thank you very much for that answer. I just want to add
I just wanted to kind of add in, if it's okay, Chairman Barvey.
Go ahead.
Just to
make it quick because we have.
I know it's late. Just to also add, I mean, this is also an effort in judicial economy as well. I think it is actually advantageous for our judicial system to hear everything that is related to the property all in one hearing, as opposed to requesting two separate hearings on the matter that's related to the same property. So that was the only thing I was going to add.
Thank you very much.
Okay, next question goes to the Vice Chair.
Thank you, Mr. Chairman. I guess this question is for Delegate Williams or Philip or any other advocate. I understand what your counterclaim language, what that section of the bill is aiming to do. But what's not clear to me is Section 2, which talks about that it's our intention to affirm the holdings in two particular cases from some time ago. So I was wondering if Delegate Williams or Philip or anyone else could explain sort of what that would do, what we would be doing in affirming those holdings.
I can take a stab at that real quick. So if we all remember from 10th grade government class, we borrowed the common law from England. The common law is court-created law. So in the Christian case, the Fairfax Savings versus Christians, the Court of Appeals held that a borrower can file a counterclaim in a foreclosure case. In the Higgins case, the Court of Appeals was talking about sort of a wonky legal issue, but the merger of equity and law. And that when you bring a legal issue, the right to foreclose, because they violate, in this context, maybe federal law or state law, and you have a claim under the Consumer Protection Act, or the Debt Collection Act, those claims go first. And the reason is we want to preserve the right to a jury trial so that the jury members can make those factual findings before a judge makes the equitable decision of whether it's right to foreclose. So when I referenced earlier the common law, that's what the common law is. It's stated in Fairfax and Higgins, hasn't been reversed by the Court of Appeals. But what has happened is that some circuit courts have ignored that, primarily Prince George's County, not permitted counterclaims in a foreclosure case, whereas Montgomery County, sometimes in Baltimore City, sometimes in Baltimore County, Washington County allows them, but it's different practices all over. So that's what that provision's there to do, is to affirm what the common law is. That's what you knew when you passed these statutes a long time ago. It's the same common law, hasn't been reversed.
Okay, that's helpful. Thank you.
I have a question for Mr. Robinson. Mr. Robinson, so you want to pretty much give everybody who doesn't pay their mortgage a right to a jury trial?
No, no, Mr. Chair.
Well, what would be if I don't pay my mortgage? What is a legitimate legal reason for me not to do so? Give me an example.
Well, there's no legal reason not to pay the mortgage, but in this space, there are statutes that govern activities. So I'll give you from an actual published case.
Well, hold on. I didn't pay my mortgage. What legitimate reason would I have to ask for a jury trial? Because, if I don't pay my electric bill, they're going to turn off the electricity. If I don't pay my water bill, they're going to turn off the water. This is because I didn't pay my bill. What fact is in question here?
The fact that's in question is the right to foreclose. The right to foreclose is they have to follow the procedures that the General Assembly has enacted, that Congress has enacted, that the Consumer Financial Protection Bureau has enacted. And in most cases, they do. You're going to hear from my colleagues in a minute that then they'll recognize and they'll answer your question that very few homeowners appear and have legitimate defenses. So this bill is dealing with those homeowners where there is an irregularity, there is a violation of the statute, the regulations, and the law governing the right to collect, and that the homeowner has a legal claim that they can pursue, and they are entitled under the Constitution to a jury trial.
Well,
so we have
my understanding, and I'm not an attorney, but my understanding is that juries are finders of fact when a fact is in question, whether I murdered somebody or I hit somebody with my car. But when it comes to me not paying my rent or my mortgage or my electric bill or my water bill, what fact is in question?
If you look at the current statute, the fact is, were they entitled, as you've heard with lots of other bills related to tenants today, were they entitled to some loss mitigation that they were wrongfully denied? Depending on how they were wrongfully denied, that may be a violation of Maryland law, and it may be a violation of federal law. We have all this federal assistance to help homeowners as well as tenants that you've already heard about today. And if they didn't follow the procedures, they didn't comply with those laws and regulations governing their activities, that can create, I'm not saying it does in every instance, a cause of action. And what the bill's attempting to do is allow those homeowners who timely file a counterclaim the right to pursue that counterclaim in the same action where the foreclosure is proceeding. But if they don't file timely, the bill's not authorizing the counterclaim. And we were pretty precise on that to address what I think will be the concerns from Mr. Enton. The current common law, the Christian case, and I think it's footnote 22, says a counterclaim could be filed at any time. How it proceeds is complicated. So we're as an advocate for homeowners in this case, I'm giving up that file at any time and say for common sense and to make the rules fair and reasonable across the board, that it has to be filed timely. And the statute spells out when that time is, the same time that's in the statute now for motions. So there are lots of defenses to a foreclosure if a homeowner's in default. That's the precise question in a foreclosure, not if they haven't made payments. But if they have an unsustainable solution, they can't afford the property, then they likely don't have legal claims or defenses, and they don't appear in the foreclosure cases, as you'll hear from my colleagues coming up.
Well, I mean, if
homeowners
we pass this bill, aren't we more or less inviting everyone to file a claim in court?
Well, that's something that my friend will say in a moment. I am absolutely certain. But we know before COVID, there were about 5,000 or 500 foreclosures filed a quarter. Statistically, very few homeowners, less than probably 10%, 5% appear in the foreclosure case, and very few file motions. They might appear to go to mediation. So you set up a whole statutory scheme.
Yeah, I know. As a result of the laws we passed, it takes over 500 days to foreclose on a property in some cases.
In some cases it may, and that's also following the Fannie and the Freddie Mae and Freddie Mac guidelines,
right,
that the statute is keyed off of. So nothing here is going to change that. Now what happens when when a
No,
counterclaim is,
actually, I don't think that's right. I think by inserting a jury trial, it's going to lengthen it. I would think, wouldn't it?
well, and I'll be happy to answer that. It theoretically could, but what happens in the case law that you would be affirming here, Christian says there has to be set terms. So what happens in most of my cases is there's some terms where I can do this for my client. There's some terms set for what has to keep the stay to prevent the foreclosure from going forward. The homeowner wants to pursue this avenue. They have to pay their taxes. They have to pay the insurance on the property going forward. Many times they make payments into the court registry representing the principal and interest that's accruing on the loan while they're pursuing their counterclaims. So all of those terms are normally laid out, and that's what's referenced in the Christian and the Higgins case that would be affirmed here, and that's equitable. So that the equity there is the lender loses nothing by the delay because there's money in the court registry, the property remains insured, and taxes continue to be paid by the homeowner. And if they can't meet those basic conditions, then they may not get a stay. Maybe in that instance, the foreclosure goes forward. But that's where we come back to the Christian case. The court has to make that determination. But we don't, what the bill's attempting to do is avoid the complete situation that happens in some jurisdictions that say, okay, we don't have the same rights for our homeowners in this jurisdiction than Montgomery County residents do, and just knocks them out of the box.
Okay.
That's not fair. That's
Okay.
not equitable. This bill's really narrow to deal with this minor issue. Very few homeowners appear in a foreclosure case. Notwithstanding what my friends will say in a moment, the whole world will not come falling down.
Okay.
If I may, Chairman Barb, I have a specific example that I think will illuminate this for you very clearly.
Okay.
I have a client who I represented who was paying $1,800 a month on his mortgage and had negotiated what is called an escrow waiver on his mortgage. That is, he would directly pay his insurance and his taxes and just pay only principal and interest to the lender. He had it signed by the lender, all parties agreed, and he paid his mortgage fine and dandy for 5 years. He was current at the time that he saw that one of his business ventures might start getting a little rocky. He placed a call to his servicer and inquired if he might be eligible for loss mitigation. That servicer, with no notice to him, with no signed documentation, with not a single piece of ink from my client, instantly imposed an escrow impound, changing his monthly payment from $1,800 a month to $2,200 a month, approximate dollar value. My client paid $1,800 a month, then 3 months later received notice that his mortgage was accelerated and that he was now in default, and they were going to proceed to foreclose against him. He saved his mortgage payment of $1,800 a month every month in his savings account for 6 to 8 months, something like that, before he ended up hiring me, and continued to pay his insurance and continued to pay property taxes to Prince George's County and was current with all of those fees. And yet still the servicer proceeded to foreclose, insisting that he was in default under a term that it had manufactured. And my client was unable to bring this as an argument, along with his evidence of all of his funds, in circuit court. This bill would allow that argument to at least be heard. That's the kind of thing we're talking about, not someone who's not paying anything, not someone who's not saving anything. I'm talking about someone who is complying with the contract that he negotiated with the other party that has been violated.
Okay, next up, Bob Enton.
Thank you very much, Mr. Yeah, I'm here. It's been a long day. Thank you very much, Mr. Chairman. I'm glad to have been referred to by all these people as their friend. That makes me feel good. I don't feel too good about this bill. I know I have a limited period of time, so I'm just going to try to focus on a couple points. First of all, you have to read the bill. The bill goes way beyond what the proponents have said. This bill, and I've never seen this language in any other bill, if you look on page 2 in lines 4 through 5, says by statute that a counterclaim is going to proceed under Title II of the Maryland rules. We don't refer to the Maryland rules in our statutes because the rules are adopted by the Rules Committee of the Court of Appeals, and they can change from time to time. And you heard, I think, Mr. Robinson complain about the fact that the Rules Committee hadn't responded to this issue. That's number one. Number two, when you look at the bill, what you will see is the language beginning in page 6 that has the motion to stay. And under Maryland law, every borrower in a foreclosure has the statutory right to file a motion to stay and allege whatever defenses they want. And the judge has the discretion to go ahead and rule that, yes, this foreclosure is stayed. And if you don't like that decision, then you can take an appeal. And if Mr. Robinson can make his arguments that he's referred to. Finally, I would say that what's unparalleled here is this just doesn't say you have the right to a jury trial. This says the foreclosure proceeding cannot go forward until this counterclaim for money damages, okay? Not necessarily a claim as that the foreclosure was wrong, a claim for money damages where if a right to a jury trial is adjudicated. So just to tell you very quickly that what this bill does, in my opinion, is turn Maryland into a judicial foreclosure state. And I will tell you that when you look at judicial foreclosure states and their timelines, for instance, a judicial foreclosure state, which, and I'll wrap up, I know I hear you, but just let me just say this very quickly. We made it very clear that we enacted pages and pages and pages. Here are the rules for consumer protections. But secondly, we will become a foreclosure state. So in Indiana, the length of time for a foreclosure is 1,653 days.
Mr. Chairman, you're muted.
Hey, Bob, I'm going to have to cut you off.
Okay, well, just let me just say this. If I could,
I
I'll
was muted when I was yelling at you. So.
No, I couldn't hear you were muted. So I just want to say that right now we're at 545 days. Passage of this bill could take us to 1,200, 1,300 days to get through a foreclosure.
Okay. Next witness, Scott Nadell. Scott.
Good evening, Mr. Chairman, Mr. Vice Chairman, members of the committee. My name is Scott Nadell. I'm a real estate attorney with a focus on foreclosure and default work in Maryland and in DC. I sit on the Real Property Council of the Maryland State Bar Association, and I also chair its foreclosure committee. HB 803 seems to give the impression that counterclaims with juries are necessary in foreclosure cases, and that it would appear that there are no other protections to borrowers. Such a notion is not accurate. There are quite a bit and a number of robust protections that are and have been in place. For example, there's a right to file a motion to stay or dismiss, which we heard about briefly. The foreclosure, you can file a motion to stay or dismiss under Rule 14.211 of the Maryland rules. The foreclosure for essentially any issue you can file this motion that may lie with respect to the debt or the lien instrument. This motion goes to a judge for consideration and may be heard in a full-blown hearing in the circuit court to review those claims. There's also a robust mediation program that, once requested, entitles the borrower to sit with the assistance of an administrative law judge through the Office of Administrative Hearings to mediate for potential mitigation, live with the lender itself and its representatives. This gives the borrower really an opportunity to really sit down with everyone who's involved in the case to discuss what can be done. These are only but a few and a handful of protections already in place and which have been working very well to protect borrowers in Maryland. HB 803 will only unnecessarily lengthen the already prolonged foreclosure process, turn the current rules, process, and procedures on its head, and almost certainly increase costs for all parties. I would strongly urge an unfavorable report. Thank you.
Okay, next we have Jeffrey Nadell. Are you the brother of Scott? What's going on?
I am not the brother,
but
I am the father. As a matter of fact.
Okay, all right. My mistake. You look so similar to him.
I thought you were going to say that I look so much younger. Unfortunately, I don't.
I'm not that much of a suck up. Anyway, go ahead.
Mr. Chairman, Mr. Vice Chairman, and members of the committee, just a little bit of background on myself. I am an attorney. I, for the last many years, have been handling default work for lenders, for servicers. And during the debacle of 2008, I was chairman of the foreclosure committee for the state of Maryland Bar Association. I held that position from 2008 through the end of 2011. And it was during that period of time that I worked very closely with Bob Enton and with members of this committee and all kinds of committees in the Senate. And we came up with what I think was a very, very good scenario for foreclosures, which did include what my son just said, 14.211, and it's also prescribed in 7105.1. This bill will not only extend the timeline tremendously, but this bill is giving a right to a jury trial, which is unheard of in these kinds of situations. If there are issues, they can be brought up in 14.211. If you don't like what the judge does in 14.211, you have the right to an appeal. But you don't necessarily have the right to as you, Mr. Chairman, said, if you don't pay your mortgage, you have a right all of a sudden to a jury trial. What are they going to adjudicate? It's almost nonsensical. I can understand that the argument is that perhaps certain jurisdictions don't handle the situation as they should. That can be alleviated with a complaint of some sort. It's not to be alleviated with the enactment of Bill 803 and giving all new rights that have never been part of this scenario in Maryland in hundreds of years. I would therefore request an unfavorable report. And I will just say, since I have a few moments left.
Actually, you don't, but if you could wind it up, that would be terrific.
I will wind it up. I'm not trying to tell you what a genius I am in foreclosure law, but I will say that I just edited the only treatise on foreclosures in the state of Maryland this past April. It came out for the Maryland State Bar Association. That's Gordon's on foreclosure.
Right, well,
edition.
We can buy that on Kindle then. That's true.
I have nothing to do with the finances of that, Mr. Chairman. I donated my time.
Okay. Next, we're going to turn to Ramon Luby with the Bankers Association.
He is not present, Mr. Chairman.
Not present.
Right.
Okay, how about John Bratsakis? I know you're here.
Mr. Chairman, thank you. Mr. Chairman, Vice Chairman, thank you for the opportunity to speak. I'm John Bratsakis. I represent the Maryland and DC Credit Union Association and our 70+ credit unions who focus on improving the financial well-being of over 2 million Maryland consumers. In fact, in the first several months of the pandemic, credit unions stepped up, helping hundreds of thousands of consumers with billions of dollars in support of deferments, forbearances, and other loan support. This foreclosure process in Maryland is already one of the most lengthy and comprehensive in the country, as it's already been discussed. So by the time the credit union chooses to foreclose, they've already expanded every resource and time to solve the issue in any other way available. In credit unions, as financial cooperatives, our members come first in everything that we do. So the foreclosure is truly the last option. However, with this bill, it would most likely lead to further delays in what's already an inordinately long process that actually doesn't necessarily lead to a better result for either party. So with that, I'll try to keep my comments brief. Happy to answer any questions, but we would also encourage an unfavorable on this bill.
Okay, let's go to Matthew Cohen.
Hi, hello, I'm Matt Cohen. I'm a Maryland lawyer practicing in foreclosure for the past 15 years. The current framework we have in foreclosure forth in Chris Gen, which is cited in the bill, already allows counterclaims in foreclosures and has a system to deal with them that's fair and equitable to all the parties. This bill is not about clarifying that these counterclaims are allowed. It's about dramatically changing the framework that the court, under which the court is supposed to deal with these type of counterclaims. In our current system, if a counterclaim is filed and we see them from time to time, the judge has a discretion under Chris' case to determine whether or not to stay the foreclosure until the counterclaims are done or whether both can proceed at the same time. And he makes that determination under Maryland Rule 14-11, which sets out the grounds under which the foreclosure should go forward or be stayed. And there's a bond requirement to protect the parties during any stay. HB 803 seeks to drastically change this existing framework. It would require a court to stay any foreclosure based on the filing of any counterclaim that requests a jury trial. It doesn't matter what the claims are or whether they're at all related to the foreclosure of the mortgage. The borrower could be 10 years in default and allege you was assessed a single incorrect $10 late charge. As soon as that claim is filed under HB 803, the foreclosure goes on hold for years automatically. And unlike our current system, there's no reference in HB 803 to the posting of any bond to protect the parties during the time of the stay. This type of drastic change is not needed. It would encourage litigation, discourage settlement, incentivize people to tie up the court process so they can stay longer for free in their homes, regardless of whether or not they have any sort of valid reason for doing so. There's no reason to create that type of incentive or delay when the law already allows a borrower to file a counterclaim and already has a workable and fair way to deal with them. For those reasons, I'm requesting an unfavorable report on HB 803.
Okay, next, let's turn to Jason Weintraub, former legal staff of the Ways and Means Committee.
Good evening, Chair Barve, Vice Chair Stein, members of the committee. It's good to be with you, even though it's dark outside. Jason Weintraub here on behalf of the Maryland Bankers Association, requesting an unfavorable report on House Bill 803. Mr. Enton has pretty much summed up all of our policy points in opposition to this bill. The only thing I'd like to point out is page 2 of the fiscal note. Says that general fund expenditures increase potentially significantly for DHCD to the extent that it incurs additional contractual legal fees as a result of the bill. Respectfully request an unfavorable report. Happy to answer any questions. Thank you.
Okay, and next we'll turn to Drew Jabin. Drew, welcome to the committee. You have 2 minutes.
Thank you. Chair Barve, Vice Chair Stein, members of the ENT Committee, thank you for having me. For the record, Drew Jabin on behalf of the Maryland Bankers Association in strong opposition to House Bill 803. You all have my written testimony. It is a packet of information on the foreclosure process. There's some data in there. You've heard from all the other brilliant panelists in opposition to this bill, including my dear friend, Bob Enton. So I will keep this extremely brief. I think I can speak for everyone here when I say that no one wants a foreclosure. The borrowers don't, the bank doesn't, but this bill just isn't the answer. So accordingly, MBA requests a unfavorable report on House Bill 803. Thank you.
Thank you. And the final witness opposed is Andrea Collender. Andrea? I guess she's not there. So we have some questions. Delegate Weigel is first.
Thank you, Mr. Chairman. First of all, I didn't realize Bob Enton had so many friends, but
he actually does.
A few questions. A lot of you all talked about the number of foreclosures. Do we have any idea, or do any of you can provide a list of the number of foreclosures over time, like how many we have today versus what we had pre-COVID or over the last 5-10 years?
I can answer that. You have in the Maryland Bankers Association testimony, one of the things that's happened is the Commissioner of Financial Regulation keeps track of a ton of foreclosure data. They have 3 categories. Under Maryland law, you have to send the borrower a notice of intent to foreclose at least 45 days prior to the date that you file. And you have to send a copy of that to the Commissioner of Financial Regulation. In addition, when you file the foreclosure, you also have to send a notice of that to the Commissioner of Financial Regulation, and that triggers the Commissioner of Financial Regulation sending you documents, and they're attached to our testimony as well, which explain the foreclosure process and most importantly, urge the borrower to reach out to the listed housing counselors and assistants that they can get to deal with the foreclosure process. Then the last piece of information they get are what we call the notices of foreclosed property registration. So when somebody buys a property at sale, it actually goes to sale and gets bought, then that also gets filed. So the numbers are very, very interesting. The numbers show that, for instance, for fiscal year 2020, that's the fiscal year ending on June 30, 1921, there were a total of
2021.
I'm sorry.
Well, I knew you were old, but
yeah, so I say 1821. There were 56,000 notices of intent to foreclose. Now that may sound like a lot, but most cases you very, very often don't get the attention of the borrower until this notice goes out. And then that wakes the borrower up as to what they have to do and who they can call to get assistance. With the process that we have in place right now, they get a lot of assistance, they can get a lot of help. Now, the next, if you look down on this chart that has blue and green and orange lines, you'll see that of the 56,000 in fiscal year 20, that resulted in 12,000 actual cases being filed. And more importantly, that resulted in 4,300 properties going to sale. 4,300 out of 57,000 actually went to sale. So those are the numbers. We have more recent numbers that go back to years such as that I got over the phone today from the department. That let's go back to, say, in October of 2018, pre-COVID, there were 637 properties that went to sale back in 2018. So our numbers are below what they were, for instance, in 2018. In addition, you heard testimony about counties. Once again, the commissioner tracks the foreclosure by counties. And this information is available from the commissioner. Some of this will be on his website probably in about a week. But we heard about Prince George's County. So Prince George's County, in the month of a period from July the 1st to 2021, when the governor said that you could start to send out notices of intent to foreclose, through February 20th, so that's what, 7 months, I guess. Through 7 months, Prince George's had a total of 117 sales total. That's it. So I think that what the numbers show, Delegate Weibel, in my opinion, is that all the hard work that occurred in 2008 and 2009, 2010, all of which through this committee has worked, and we have, even at 545 days, a low number of foreclosure cases and a process that works.
Okay. You mentioned the Commissioner of Financial Regulation. I know Delegate Stewart often does extensive Google research while the bills are being heard, so I took the opportunity to do that as well. They had a work group on this foreclosures this past summer. Did they bring up this issue that's being raised by this bill?
You know, it's interesting. I spent hours and hours in that work group, as did consumer advocates, as did attorneys who handle foreclosures, as did the department. And no one ever raised for 1 minute that this issue was a significant problem. And I think that's because it is being dealt with appropriately. And if it is a problem, you have remedies. What we focused on was making sure that the notices that went out to borrowers were friendly. So if you look at our written testimony, you'll see this thing that says mortgage late, don't wait. And this is the new document that goes out from the commissioner's office. The old document, if you go online, you look at it, was very legalese. And what we pressed for, and the consumer advocates pressed for, and we agreed, was you have to make this consumer friendly. So that was one of the big things the work group did. The other thing is, right now we have there are regulations pending in the Maryland Register. They were published on January the 19th, which implement a number of the recommendations for things that were problems with the current law that could be changed by the commissioner. My understanding from the commissioner's office is no one has yet to file any opposition to those amendments, and they should become effective shortly. So, you know, this is a robust discussion that goes on and on and on, and it's one of the reasons that we have such a successful program with such favorable outcomes.
Okay. you started to talk about the average time for foreclosures. I know since I've been on this committee, we've had several bills trying to get banks to address the abandoned house issue that become kind of blights on neighborhoods. And so I guess the point was made during those proceedings that the banks don't own the property, they can't maintain them or do anything. So do you think if we went to this type of process, it would exacerbate that issue where you potentially have abandoned homes in a neighborhood longer than what we had in the past? You talked a little bit about a judicial foreclosure state versus where Maryland is today.
Right, right. I definitely think so. And I can tell you, and I remember sitting during the summer in your committee room with the chairman and then having follow-ups in the real property subcommittee. And, you know, there's the focus, I would say, I could, and I'll finish into the subcommittee. If you look at the bills that were introduced over the last 5, 6, 7 years, the vast majority of those bills were introduced to address the issue that blighted, that foreclosure, that properties in foreclosure were causing blight in neighborhoods. And what happens is no homeowner who's in foreclosure is going to make any improvements to that property, knowing that whether it takes a year or 2 years or 4 years, they're going to lose title. The lender, even if the borrower moves out, the lenders are not prone to go in there because the next thing they'll get a claim that they did something bad inside the property and the properties just sit there. So we had a bill a few years ago that we said for a vacant property and put in place, it came out of your committee. I forget who the sponsor was now, that sought to address that by putting in an accelerated process. But that's been the focus. I can't imagine in like the state of Florida where the average length of time is 1,138 days. It's a judicial foreclosure state. What happens to the properties there? So, you know, the focus has not been on this issue. The focus has been much, much more on the blight that these properties can cause and what to do about it.
All right. Thank you. I have one last question, Mr. Chairman. As I was listening to the testimony, I know banks are going to recover their costs. So if they end up in more jury trials than what they have today, does this bill potentially increase the cost of borrowing for all Marylanders?
Well, I would say this. I mean, I think it's hard to quantify. But look, we all know there's no free lunch out there. That we know. And I don't have any data. I can't look back and, pinpoint this, pinpoint that. There are a lot of variables that go into the rate of interest, but there are no free lunches out there. And I think the thing that really concerns me as much as anything is if we're going to delay this as the bill will undoubtedly do once this becomes law, I can't imagine it's not going to have a negative impact on lending. If you had the choice to go to make a loan in Virginia versus a loan in Maryland, and the foreclosure process in Maryland takes 1,200 days, and if the borrower defaults, and let me be clear, believe one thing, and I've said this before, that as much money as people think I've made over the years as a lobbyist in Annapolis, I can't walk into a bank and borrow $300,000 or $400,000 without putting up security and collateral. And nobody can go into a bank and borrow $200,000 or $300,000 or $400,000 to purchase a home. They put down 20%. The bank puts down 80%.
Bob, I think you're wandering off the topic of the question.
Okay.
Let's move on to the vice chair of the committee.
Thank you, Mr. Chairman. No problem. You can tell I'm a little pumped up.
I hadn't noticed. The vice chairman has a question.
Thank you,
Yes,
Mr.
sir.
Chairman. I guess this is for Scott or any of the opponents. The proponents of the bill are saying that there's ambiguity as to whether there is a right to counterclaim for borrowers. That some counties don't, the courts in some counties don't allow it. But what you're saying is that there is a right, be it to counterclaim directly or for stay or dismissal. Maybe could you just confirm that you're saying there is a clear right to counterclaim or something of effectively the same as a counterclaim. Is that what you're saying?
Who did you direct the question at?
Scott, maybe?
Sure, yeah, I mean, the case clearly indicates that, but not only that, there's no rule that I'm aware of, and Matt may also be able to speak to this as well. There's nothing that's prohibiting anything at all. So to answer your question, in short, you're right. There's nothing that's prohibiting any counterclaim right now.
If I could very quickly, if you look at page 2 of the bill, lines 20 through 21 of the bill, what the current law is, nothing in this subtitle precludes the mortgagor or grantor, that's the borrower, from pursuing any other remedy or legal defense available to the mortgagor or grantor. As Perry Mason would say, I rest my case.
Mr. Chairman, if I could just follow up very quickly. So you're saying there's the courts, there's no ambiguity as to how courts interpret that to allow counterclaims already?
Yes.
Okay.
It's in the code. It's in the rules of procedure. They can take an appeal if they feel that's been abused. And keep in mind what the bill does. It says the foreclosure can't move forward in any fashion until this counterclaim is resolved. And that, that's not the case law.
Okay, thank you.
I think the last question possibly will go to Delegate Healy.
Thank you very much, Mr. Chairman. It's like old home week here. I have Jason Weintraub, who was not only staff for Ways and Means, but he was my staff on House Rules for many years. And right now, one of our witnesses is Keisha Monroe, who is now my chief of staff. I'm actually executive director for the Women's Caucus in her day job. She's here on just a personal matter, but still, there's so many friends here. I don't know who to ask this question, but I'm going to ask.
And don't forget Drew Jabin, the better-looking half of the Jabin siblings.
Absolutely. Obviously, Ben was my intern, so. But I do want to ask Bob, who is also a friend. The issue I see as the real serious equity issue is the inconsistency from one court to another. If there's a rule, whether it's common law or it's case law or it's rules of the courts or whatever, they're not being applied in the same way across the board. And if you can get a different kind of hearing in Montgomery County than you can get in Prince George's County, then you can, or if you go from one judge to another in Baltimore City or Baltimore County it's different and you don't get the same treatment, automatically things are dismissed. We hear from the NAACP in Prince George's County. That's a serious concern, Bob. And I want to know what you would do to remedy that issue so that people, wherever their property is, whatever their situation is, if they have a case like this and where their situation has been abused, that they have a remedy in court the same in every court in the state.
Yeah. So I think, I have let's see right here, Delegate Healy, if you can believe it, these are the rules for foreclosure cases right now. It's probably 100 pages of rules. Rules of court are promulgated by the judicial branch, by the Rules Committee, which is made up of the chairman of judiciary, JPR, lawyers, and judges. And you have a wonderful Court of Appeals. Former members of the General Assembly serve on it. And I think that they're the ones that the Rules Committee and the Court of Appeals, if there's a problem that the rules don't adequately address this issue, then I think it should be brought to the attention of the judicial branch, because they are the ones that manage the courts. And if we need to change the rules to make it clear that in some fashion, they need to send something out to show that, what's in this bill that says that nothing precludes the borrower from pursuing any other remedy, then I think that's where we go. But to pass a bill that's going to do nothing but delay foreclosure cases for years and years and years is not the remedy. I'm happy to work with you and the committee. Maybe we can write a letter to the judicial branch. I'm good friends with Judge Wilner, who's the chairman of the Rules Committee. I've been going in front of that for decades, and see if there's some, if this is a problem, then let's try to put it on there.
Yes,
To me, I think that we may not have the solution here, but we definitely know there's a problem.
Absolutely.
Okay,
Thank you
well,
very
I'm happy
much.
I'm happy to work on addressing it.
I'm
Always.
finished. Thank you.
Well, you may be finished, but David Fraser Hidalgo is not. So DFH, you're up.
Am I the last question of the night?
Unless somebody else asks a question after you.
Okay, well, I'll try to close it all up with a little ribbon. So this message is, this question is to Mr. Enton. Mr. Enton, I've known you for a long time, and there's been a lot of conversation tonight about your friends. With all that said, I've never heard of you having a friend named Perry. So I don't know who this Perry Mason guy is that you keep talking about. I'd be curious to see
Showing how young you are. But the older members of the committee remember Raymond Burr was Perry Mason, and he never lost a case, ever.
Mr. Enton, I know.
He had a really he had a really lame opponent, though. There's that. Any further
Berger
questions?
was his name. Berger was the
Yeah,
prosecutor.
Yeah. Oh, gee.
Could I just say something?
Yes.
This is Liz Johnson with the NAACP. And there are many, many, many rules that we don't see that are enforced. I talk to people every day that come to me and talk about how these rules that you're talking about are just simply abridged over and over and over again at the mediation level, in the courthouse, and everything. I see the flotsam and the fallout from these predatory loans. And I hear so many people talking about timelines, but I don't think I hear you talking about the human flotsam that is caused from these rules and regulations that so favor the financial institution. And that I feel is egregious. And we are seeing people who are living in their cars and living in the woods and in tents, all because they are fighting a system that they are financially ill-equipped to fight. There are people really that are going in there with pro se litigants who have no clue about the rules. And I know that's not the industry's fault. But one thing that is for sure is that there definitely has to be something that's going to address the personal and the private citizens, tax-paying citizens that have lost everything behind these rules and regulations that so favor the banks. Thank you for your time.
Sure. Any further questions for?
Can I speak, please, Chairman? I'm sorry.
Who's?
This is Adele Penny.
Sure. I'll let you have the last word.
Okay, I appreciate that. I don't mean any disrespect to any of the bankers, but they are the reasons why we're in this whole financial crisis in the first place, by doing their predatory loans. And so far as holding up the foreclosure systems, you have people that have been living in their homes for 30 years or more. And I think by us being taxpayers and citizens of the United States, that we deserve jury trials to make sure that these aren't pretender lenders. Okay. In 2011, in April, the OCC came out with an order to cease and desist for all these major banks. They were supposed to stop with their predatory loans and stop all of the borrowing and lending and all of the activities that bankers do, and they didn't do it. That's why in my speech that was whatever, it stated that these rules need to be enforced. And the gentleman that said that we don't have time, people have been in their homes, like I said, 30 and 40 years. Generational wealth. Once you rip the bottom out of a home, you ripping away family traditions, you ripping away everything that a human being is, because a house is more than a home. And yeah. I don't know if you know anybody that has lost their home or not. It don't seem like any of these bankers are, it seem like they're sitting pretty. But like Ms. Liz Johnson said, there are people that's living in the woods because we haven't got due process. All of those regulations that are in those books that these people are doing, Maryland is the #1 foreclosure state in the union. And these they need to be addressed. Yes, it is. Okay.
No, it's not.
Okay, well, I think you need to take your head out of the sand.
Yeah, I think you need to get your facts straight, ma'am.
Okay, all right.
Okay.
All
and
right.
so far as you're being conditioned and letting
ma'am,
people think
Miss
letting
Penny,
people think that if you don't pay your mortgage, that you get your home taken. No, they're going over our heads. These are pretender lenders. We don't owe them money. They're taking our homes.
Miss Penny, ordinarily, let me just say this. I know this is a very emotional issue, and I know that I remember this whole issue after the financial crash in 2008, 2009, and under Martin O'Malley, we passed in this committee a large number of laws that has really created a lot of mediation in the system. And I know no system can be perfect. I recognize that. But the real question before us on this bill is whether this bill addresses an imbalance that has occurred as a result of this. And I have every confidence to know that the members of my committee and the subcommittee on real property will give this the same thorough examination that we do to all legislation that comes before our committee. So with that, that will conclude the public hearing on this bill.
I hope you would do that, Chairman, and not just say that to me to get the meeting over with, because this is a real issue that needs to be addressed. You are talking about a whole community of Black and brown people that are getting their generational wealth snatched.
Okay, I'm going to say 6:30.
Okay, they are killing us. They are making us extinct. They're taking everything that we have.
Ms. Penny, thank you. All right, that ends the public hearing on this bill. Announcements for the committee, subcommittee chairs.
Mr. Chairman.
Delegate Gilchrist.
Natural Resources Subcommittee will meet at 6:30.
Okay, who's next?
Mr. Chairman, the Environment Subcommittee was going to be meeting after bill hearings to review House Bill 653, the Conservation Finance Act, but we're going to reschedule that for Thursday at noon.
Okay. Any other subcommittee chairs?
Yeah, Mr. Chairman.
Delegate Lehrman.
The Land Use and Ethics Committee is going to meet immediately following session on Thursday, and we are hopeful that is before noon, so that anybody who's on my subcommittee we can do our thing. We'll be quick, and then you can go to ENV.
Okay.
Mr. Chair.
Marvin.
Yes, the Housing and Real Property Subcommittee will meet tomorrow afternoon. All of you have received notification of the meeting and the associated bills to be discussed. Thank you, Mr. Chair.
Okay. Any other subcommittee chairs? All right, let me just make a scheduling announcement for voting session. We're not going to vote on Saturday because we don't have the ability to pay staff to work on Saturday. So we have a very long public hearing on Friday. Chances are it could be a 6-hour public hearing. So I'm not going to make you vote after sitting through a public hearing like that. So I'm toying with the idea of either voting Thursday or Monday of next week. So get back to me on which of those. Actually, here's what I need to know from you: whether you're willing to vote by Zoom, obviously Monday morning. That's unusual, but we're backing up here.